Welcome. I'm AdaKay, your deaf courtroom commentator, breaking down the gripping courtroom drama, providing ASL interpretation when possible, while making justice accessible to everyone. Grab your favorite cup of Java and let's dive in. Oh, hello, everybody. Welcome. And yes, we are finally here for the verdict watch in the Ali case. It is now day 3 in this verdict watch. And y'all, we are so ready for the verdict. So ready for the verdict. So thank you so much for joining me, everybody. Appreciate it. Love you. Hello, everybody. First in chat, Defender, Christy. Oh, thank you, Flash Fan. Thank you so much. Out and About with Diane, Brooklyn. Angela, we made it. Woohoo! Thank you so much for coming on over here. This has been a busy day. And 2 cases that we were supposed to be having hearings on didn't have the hearings, and one of them's rescheduled for this afternoon. So we are going to be bouncing around a little bit. But while we are waiting for the verdict watch, while we are in the verdict watch, I'm going to keep this up here. We're going to be diving into the Stampin' Up! Heiress case and trial. She is accused of a Lori Daybell unaliving her husband. No, was it Lori Daybell? Sorry. I am tired. I just lost it. Anyway, she is accused of unaliving her husband for the custody of her children, because of her children. So yeah, y'all, that's pretty so messed up. So messed up. Ex-husband, excuse me, you're right. Ex-husband, Donna Adelson. It's a cross between Donald Adelson and the Karen Reed trial, sort of, kind of. And when it comes to all the finances and all the plot. Sorry about that. My son just showed up. Matt, they may have ice next door. I need ice cold water. I can't drink hot, warm water. It makes me sick. Hello, Diane. Is Margie okay, love? I need to know. Just yes or no. Is she okay? So anyway, the gist of this is that the Stampin' Up! Heiress the daughter to the Stampin' Up company owners are, huh? Unalived her ex-husband over issues with the children and the custody and all that. Anyway, very similar to the Adelson trial, but this woman is a $10 million. She's worth $10 million. So it's going to be interesting. It's going to be real interesting. Sorry, I'm grabbing my drink mixes for the morning. Much more than 10 million, but she's worth her personal wealth is at 10 million. So what we're doing right now is while we're waiting for the Ali's situation, we are watching and catching up on this trial. Why am I all of a sudden interested in this trial or this case? Well, because I used to be a Stampin' Up demonstrator for over 10 years. And I know the owner. I know of the owner. I've met the owner once. I don't have a personal relationship, but I do have connections to this. So it's very, 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 very interesting. Very interesting. So anyway, quickly, we're going to go over and look at the live concerning the trial here. Who are they talking about? Let's see. Oh, yeah. We're going to go over to Court TV real quick, and then we'll go back to the hearing that we were watching in the previous live. Thank you guys, everybody, for joining. And I want everybody to know we have a new mod in the house. Miss Tinkitude is a new mod. Thank you so much for joining the team, y'all. It's a higher hitman agreed to testify against her. However, he may recant. We've got a lot going on. I'm a little bit disheveled because I'm trying to learn and assimilate all of this information in a very short time. I knew nothing about this case until late last night in the wee hours of the morning. So let me get this rolling. And
where jury deliberations continue in the attempted honor killing trial for parents Ihsan and Zahraa Ali. 14 hours they've been out. We'll take you there if there's a verdict or a question.
And in Montana, testimony back underway in the returned mail murder trial. The defendant here, Jordan Palmer, is accused of shooting his neighbor after a fight that started over a piece of mail. Let's head there now.
That's crazy, y'all.
Day two. On the stand is a detective going over some of the court exhibits.
State's Exhibit 146.
Photograph of the firearm that was located on scene.
State's Exhibit 147.
It's another photograph, a closer view of it.
State's Exhibit 148.
It's just another one, a different angle.
Oh, I'm going to really do deep into this one. This is going to be one that is going to be, we're going to be having a lot of coverage on this one. But Frankie Leroy, how's the sound? Does that court sound real loud to you? I can't tell because I have a hearing aid, so everything's skewed. Frankie, I call him Frankie Leroy. Let's just see if she hasn't in her to time you out when need be. Hola, hola, hola.
And State's Exhibit 149.
I believe I flipped the gun around and take another photo of the opposite side.
State's Exhibit 150.
That's a close-up of the firearm with the serial numbers visible.
He's already doing great.
51.
A different angle of the firearm.
And this one's a little bit different. States Exhibit 152.
This is just a picture with the slide locked in the, or put back in the locked position.
And why would you take a picture with that kind of manipulation?
General functionality to see if it went all the way back.
When you were manipulating it, did you notice any issues with how it was functioning?
I did not notice any.
States Exhibit 153.
Just a different angle of the firearm.
And what are you focusing
Okay,
on
I
there?
don't know. I'm not gonna.
This one on the chamber. Nothing specifically. It's just a close up of the chamber.
Okay, we're not gonna watch this case. We're gonna go. Sorry, guys.
States Exhibit
What I'm gonna do is we're gonna go back to what we were watching before, but I will keep an eye on the time clock. I got it put aside. But we're gonna go back to the trial, the hearing that we were watching with the Stampin' Up heiress red room trial of her ex-husband. And we'll be bouncing back and forth, but yeah, we need to continue with this one. Here we go.
Two,
Yes,
and that's inevitable.
yes,
And
Well, I
does this
put
email,
something in my gut.
contain an attachment?
yes.
And what is the name of the attachment?
Confidential timeline.
And was that timeline, who created that document?
It was created, I would say it was a combination between the attorneys with the input and assistance of Mr. Fernandez.
We are still waiting for the verdict. We're in 14 hours and 30 minutes. And so we are still waiting for that, y'all. Still on verdict watch.
Did he participate in creating this document?
Yes,
Was this document ever intended to be made public or got seen by anyone else?
no,
Was this document titled confidential
yes,
in an effort to keep it what?
confidential.
To your knowledge, does this document exist anywhere else in Discovery?
No.
And I'm going to jump ahead of some of my questions, but I think now is a good time to stay. Was your primary goal still in the past to work on Discovery in this case?
Yes,
How many hours do you think you've worked on Discovery in this case?
well over 1,000.
Do you believe that you've reviewed substantially most of what's been provided to us?
Yes,
And does this exist, the document that we're specifically referring to, exhibit 2, anywhere that you've seen other than in this email?
no,
And is this one of the documents that Lindsay Butler sent to Christina Stiff?
yes,
Next slide. And I want to make sure we're clear on one exhibit, not this slide, the confidential conversation. Who created that document?
Mr. Fernandez.
And was that document created at our request?
Yes,
Was it created in anticipation of future litigation?
yes,
To your knowledge, does this document exist anywhere else in Discovery?
no,
Is this document comprised of screenshots, like typical from your phone? You make a screenshot and then you can see what a text message is?
no,
Does this document have any indication that it was created by a provider like AT&T or T-Mobile?
no,
Is there any indication that it was created by a third party or someone not Mr. Fernandez or someone in our office?
no,
Object to speculation.
To be very clear, I'm asking, is there anything that you know on that document?
I have no reason to believe that.
I'll roll it, go ahead.
I have no reason to believe the document was not created by Mr. Fernandez.
And is that, with the confidential timeline and the confidential conversation that we've just discussed, were those sent from Lindsay Butler to Ms. Stifler?
Yes,
Have you been in court specifically with the confidential conversation where you've been made aware that they intend to use that document against Mr. Fernandez?
yes,
What are we showing you now this day?
this is a letter that we prepared and sent to Ms. Stifler on February 7th, 2023.
Was this email attached, was this letter attached to an email?
Yes.
I know it may seem obvious, but is that a scenario where we send Ms. Stifler an email and say, please see attached?
Yes.
Your Honor, may I approach?
Yes.
Entering exhibit. Is the next number exhibit?
6.
Thank you. Any variations to the state?
I've shown everything in the state, most of which you're going to be handed, Your Honor, with the exception of a few things, was attached as an exhibit to our motion to disqualify.
Okay.
Is this a copy of the February 7, 2023 letter?
Yes.
Did you help prepare this letter?
Yes.
And can you briefly tell the court what this letter was intended to do?
I believe Mr. Fernandez's electronic devices were seized pursuant to a warrant on February 6th. So we sent this letter on February 7th to alert Ms. Stifler that there were likely privileged communications contained on the device and to ask that she refrain from downloading or reviewing the device until we could file a motion for a protective order.
Okay. And was Mr. Fernandez arrested at this point?
No.
Was he was out of custody?
Yes.
Had his devices been seized?
Yes.
Is this, and this was filed the following day that his devices were seized?
Yes.
And we, as you just testified, we had concern that we wanted to protect our clients' communications.
Yes.
Did we in fact file a motion for a protective order?
Yes.
Can you go to the next slide? May I freely go between the podium?
Yes. Yes.
To be entered in full as defense said. When I say in full, meaning the slide may not have the entire, but the record will have the entire.
All right.
Any new comment?
Is this the motion that we asked the state to hold off on review because in fact, well, I'm sorry. Is this the motion that we prepared?
Yes.
Did it bring to the court's attention that we wanted to preserve our privilege?
Yes.
Were we able to get a hearing?
Yes.
Next slide, please. What am I showing you now, Ms. Day?
This is footnote 4 to the court's order regarding our motion for protective order, and I believe it's on page 2.
And would you read this aloud?
The state has agreed that any communications protected by the attorney-client privilege will be removed from the devices by a non-state third party prior to downloading. In this way, law enforcement officials will not be able to view content subject to the attorney-client privilege. Counsel for both sides are working together to identify sending, receiving phone numbers, email addresses, so that these attorney-client privilege communications may be removed. Accordingly,
I don't know what happened there, but what they're currently arguing is that the state apparently was able to access or see information that was protected under the client confidentiality with the attorneys. And so there's a motion hearing to disqualify the state attorney's office from the trial.
Next slide, please.
I just have my sweet now here. I'm going to get my second. I haven't had a second cup of coffee in a long time, but this chick's working on 4 hours or less sleep. I'm getting a second cup.
Ms. Day, what are we showing you now?
this is a letter that we drafted and sent to Ms. Stifler on February 8th, 2023.
And this would be Defense Exhibit 9, Your Honor.
Thank you.
And what was the intended purpose of this email with attached letter, Ms. Day?
After filing our motion for protective order on February 7th, we sent this letter on February 8th in an abundance of caution to provide Ms. Stifler with the names and contact information of attorneys who we believed may have had privileged communications on Mr. Fernandez's device.
Thank you, Flash Fan.
Is my information on that email?
Yes.
Is my accurate email address on that letter?
Yes.
Mr. Hills?
Yes.
Mr. Tassoni's?
Yes.
Yours?
Yes.
Mr. Cox?
Yes.
At the Bedell firm?
Yes.
And is that our firm emails?
Yes.
When I was talking to you about various documents that the court has, exhibits 1, 2, 3, and specifically 5, the remainder of all of the emails, Are the email addresses that Mr. Hernandez used the same email addresses that we provided the state attorney's office?
Yes.
How many times did we send this particular letter?
We sent it twice. We sent it on February 8th, 2023, and then we sent
Damn,
it again on
Tinka
February
Dude.
23rd following the court's order.
Next slide, please. This next slide is Defense Exhibit 10. Ms. Day, would you tell the court what generally is not on the screen, but what Exhibit 10 is?
It is the search warrant for Mr. Hernandez's Google account.
And does that contain the search warrant, the affidavit, and the return?
Yes.
Would you please read paragraph 11 from that search warrant on page 2?
All files contained and associated with the Sheets/Docs service provided by Google Inc. and is associated with the target accounts, to include media in all formats, including but not limited to digital photos, video files, links, documents, shortcuts, sound files, and executable files. This is to include any files that were saved, uploaded, shared, generated, received, deleted, and or transferred into the accounts associated with the above listed emails.
And what's the significance of that paragraph?
That in issuing the search warrant, the state anticipated and specifically requested attachments that had been transmitted via email.
And when approximately, and I can hand you the document if you don't know, was that warrant issued?
I believe it was April 3rd or 4th of 2023.
Is that after or before we made an agreement about our privileged communications with the state attorney's office?
After.
And approximately when did the state receive the return from Google?
June 27th, 2023.
Mr. Dreiser, on State's Exhibit 10, something's happened to the printing, so I'm going to ask that you replace the first.
Somebody asked, what did I put in my coffee? I'm really struggling to get protein into my diet. I have a very limited stomach due to an old sphincter repair surgical procedure. And so, anyway, so one of the things I'm doing is I'm adding extra protein powder. There's no flavor. It's unflavored instant protein powder. It's only 6 grams of protein, but that's okay. It has no carbs, so that's good. So, so anyway, it's got some other stuff mixed into it. It's for gut health and stuff. And I put it in my coffee. But I have to froth it up because it's clumpy.
Page of the document. Okay.
I'll never remember that. Give me a moment here.
Defense 10?
I'm sorry, Defense 10. It's from the printing, something, this text is coming off of it.
Is it just the first page?
Looks like it.
Yes, ma'am. We'll have that.
Thank you.
Can you see the next slide, please? Ms. Day, what are you looking at now?
This is an email that Angel Nazario sent Detective Johns and Detective Lamont on September 8th, 2023.
Okay, and the email speaks for itself, but what was the, why am I asking you to discuss this here?
Because Mr. Nazario returned the completed tape review of Mr. Fernandez's Google return to the detectives on that tape.
Defense 11, Your Honor.
Thank you.
And Ms. Day, some of this stuff you've talked about so much, but I just want the record to be clear. Who is Angel Nazario?
He is a U.S. Secret Service agent that was assigned to complete the tape review in this case.
Was he the only taint or filter agent assigned to this case?
Yes.
And we've mentioned the name Lindsay Butler. Who is Lindsay Butler?
She is an ATF analyst who I believe did the review but was not a tape agent.
Do you believe or you know Lindsay Butler was not a taint agent?
I know Ms. Butler was not a tape agent.
Next slide, please. is this, Ms. Day?
This is an email from Lindsay Butler to Christina Stifler on June 30th, 2023.
And is this the email from Agent Butler at ATF to Ms. Stifler that contained the documents that you testified to earlier that have been provided to the court, confidential timeline and confidential conversation docs?
Yes.
Defense Exhibit 12, Your Honor.
Thank you.
At the time that this email was generated, did our office know that Ms. Butler had sent Ms. Stifler this email?
No.
Was this provided to us in real time?
No.
The next slide, please. And what are we showing you now, Ms. Day?
This is a text exchange between Christina Stifler and Lindsay Butler from June 30th.
And in a time frame, when was this text message conversation in relation to the email in Defense Exhibit 12?
This was approximately 45 minutes prior.
This would be Defense Exhibit 13, Your Honor. Next. Ms. Day, what am I showing you now, which has been previously marked as Defendant's Exhibit 14 and will be entered into evidence?
This is a letter that we sent to Ms. Stifler on September 27th, 2023.
Again, like many emails that we sent to Stifler, was this attached as a PDF letter?
Yes.
So much like we allege the attachment in the emails were confidential and privileged, Mr. Fernandez, we communicated with the state attorney's office in the same fashion. Is that fair to say?
Yes.
Can you read from that screen, Ms. Day?
Yes.
Your Honor, Defense Exhibit 14, I'm turning over. Ms. Day, would you read that letter for the court, please?
Oh, thank you for getting on the mic.
As you likely recall, we had a conversation outside of Judge Pike's courtroom this morning, dated April 27, 2023. During this conversation, you advised me that you were recently in possession of what you believe to be deleted and hidden text messages between my client and Henry Tennant prior to and post the homicide of Jared Brigan. During this conversation, you mentioned that the file was titled Confidential. As always, I have appreciated the candid nature of our conversations. However, this particular piece of discovery that you are in possession of leaves me with some grave concern. The reason for my concern is not the content of the messages between Mr. Tennant and my client, but in the manner in which these messages may have been obtained. I'm concerned that the way in which this discovery could have been obtained by law enforcement is by law enforcement intercepting privileged and confidential communications between my client and his attorneys. As evidenced by the emails attached to this letter at the direction of his attorneys on August 25th, 2022 at 7:28 a.m., my client sent his attorneys all text messages saved between himself and Mr. Tennant prior to and post the homicide of Jared Brigan. As instructed and as indicated in his email to our firm, the subject line of the email and the document containing the text messages that were attached are titled Confidential Information and Confidential Conversations. Even more troubling is I am now in a position where I must disclose a privileged attorney-client communication to evidence my concern that law enforcement may have intercepted privileged communications. Additionally, it needs to be established that the confidential titling of the text message.
So I just signed to you. Can't have just a itty bitty bite and just kind of break it down to mush before you swallow.
And the email.
I'd be doing anything. I don't eat them often, maybe twice a year. I don't eat them often, but I love them.
Counsel was not done to evade law enforcement or for any nefarious purpose, but rather to confirm and protect privileged communications between my client and his attorneys. As you are also aware, on February 8, 2023, I sent you a correspondence outlining all of the attorneys who represented Mr. Fernandez who had sensitive and privileged communications with Mr. Fernandez and provided their email addresses and pertinent contact information. I would expect law enforcement and analysts to easily identify that this confidential information containing the text messages were sent and attached to an attorney-client privileged communication to an email address identified in our February 8, 2023 letter. I hope you can understand my concern, especially given the amount of times we have discussed our concern about law enforcement invading the communications between attorneys and our clients in this case. I look forward to speaking with you about the matter soon.
And a few things. I was referring to the letters that are now in evidence as evidenced by our providing the state our email addresses.
Yes.
Is that what I'm referring to?
Yes.
And we now know that it was intercepted or sent to the state back in what date was that?
June 30th.
Did Ms. Stifler respond? Next slide, please.
Yes, she responded the following day, September 28th, 2023.
Defense Exhibit 15, Your Honor. And that was a response via email?
Yes.
In this case, is it fair to say there's an enormous amount of discovery?
Yes.
Prior to next point, and can you just briefly tell the court what next point is?
Next point is, I guess, a file sharing platform. I would maybe compare it to Dropbox.
And is that a platform that the state chose and hired to try to arrange and organize this discovery?
Yes.
Prior to next point, how were we moving discovery back and forth between the state and the defense?
External hard drives and flash drives.
Were you, again, responsible at our office, along with myself and Mr. Hill, for trying to organize and gather this discovery?
Yes.
Did you have access to next point?
Yes.
Did I have access to next point?
Yes.
And Mr. Hill?
Yes.
And I'll get to some more others in a few. But all of the emails that are contained in Exhibit 5, unredacted and redacted, meaning that the clerk's screen has them redacted, the court has them unredacted, were all of those emails uploaded to next point?
Yes.
Did you upload them to next point?
No.
Can you upload anything to next point?
No.
Next slide, please. And what is Defendant's Exhibit 16?
This is a screenshot that I took of the Next Point portal, which shows all the individuals who also have access to the portal.
And I know I asked you about a few folks from our office, but are there state attorneys on there?
Yes.
Are there co-defendant counsel, meaning people from Mr. Baez's office?
Yes.
Ms. Stifler on there?
Yes.
Mr. Wingard on there?
Yes.
Mr. Carodi?
Yes.
And Defense Exhibit 16.
Belgian waffles.
Current user,
Mm.
the screenshot, is that correct?
Yes.
Your Honor, Defense Exhibit 16.
Thank you.
Mm.
When you found.
Oh, I'm sorry, Angela. I know what that problem's like. I hate dumping.
No.
Ate it.
What would you do?
It would show up as if it were a list of links by subject line, and you would just click on one and the email would open in I think either a pop-up window or a side pane.
Did you have to unzip anything?
No.
Did you have to have any special software?
No.
Next slide, please.
Hey, Turco J 1990. She's doing fabulous. She's doing fabulous. I don't know why she's drowning. She's doing great.
What is on
She
your
got
screen,
this.
identified
Thanks for
as
supporting her.
Defense Exhibit 17.
This is a screenshot of one of the privileged emails that I discovered on the portal.
And did you click on, as an example, did you click on the email to have it pop up?
Yes.
Is that how you were describing it would pop up?
Yes.
Now, in Defense Exhibit 16, I'm sorry, is that, I handed you 16?
17.
Excuse me, 17 that I just handed to the court, is a redacted portion of what the email said, is that correct?
Yes, the body of the email has been redacted.
But when you clicked on it, or anybody else that was on Next Point clicked on it, would it have been in that redacted format that Exhibit 17 was?
No, it would have been unredacted.
Thank you, June. Thank you so much, June. You're amazing. As always, love you,
What
darling.
is on your screen, and I will say for the record, is labeled as defense exhibit 18.
This is a screenshot I took from the Next Point portal, which shows Michelle Medina exported all of Mario's emails, which included our privileged emails.
Who is Michelle Medina?
She is an employee of Jose Baez's firm who represents Ms. Gardner.
Someone from co-defendant counsel's office?
Yes.
Did we become aware that anybody else besides the lawyers and our client had access and incidentally reviewed our emails?
Yes.
And can you go to the next slide, please? And what am I showing you now, Ms. Day? It's defendant's exhibit 19, correct?
This is a letter that we received from Patrick Brody on December 4th, 2023.
And would you just read the second to last paragraph?
Members of Ms. Gardner's defense team have reviewed attorney-client communications between Mr. Fernandez Saldana and his counsel that was provided to us by the state attorney's office as discovery via the Next Point application. At the time the materials were reviewed, we were unaware of the prior litigation regarding such communications. We ceased reviewing any communications that appear to be between Mr. Fernandez Saldana and his counsel.
Besides the many hours that you spent organizing and helping us prepare discovery in this case, did you also attend meetings with our office and state attorney's office instead?
Yes.
And when you would attend those in-person meetings, I know there are different people at different times, but can you tell the court who you either are aware that Mr. Hill and I met with, or that you personally met with at the state attorney's office?
I know that I personally was present for meetings with Ms. Stifler and Mr. Mizrahi, I believe, and Lee Hutton as well. And I believe you, Mr. Hill, and maybe Mr. Jason, I'm not sure, have met with Ms. Stifler, Mr. Mizrahi, Mr. Wingard, and I believe Mr. Hutton.
Besides the upload to Next Point of all of our emails, right? Taking that aside, did Detective Johns and did Agent Butler have access to our emails outside of Next Point?
Yes.
And starting with Detective Johns, when we filed our motion to disqualify the state attorney's office, the night before we filed it, did we send a courtesy copy to the state attorney's office to say, we intend on filing this and we wanted you to have a chance to review it before it hit the airwaves?
Yes, and that would have been November 14th at approximately 4:35 o'clock.
And at some point that evening, what happened to Next Point?
It was shut down.
And have you ever had access since that time?
No.
Okay. After that time, that Next Point was shut down and we were post the motion being filed, did we request that Detective Johns give us an unredacted copy of the Google return so that our expert could review it?
Yes.
And did he do that?
Yes.
And how do you know he did that?
I went to the Jacksonville Beach Police Department and he handed me the flash drive that he had downloaded for us.
And when he downloaded it, were all of our emails on it?
Yes.
So whether or not you can testify, you can't testify that he saw those emails. Are you certain that he had access to them?
Yes.
How do you know Ms. Butler had access to our emails?
In her deposition, she said she was provided the entire Google return, though I believe initially she was instructed not to open the folder that contained the emails. It's my understanding she had access to them.
And that conversation you're referring to is part of the record in the deposition of Agent Butler that my office, our office, and Mr. Brody and Mr. Baez's office participated.
Yes.
At one moment, the clerk round.
Yes.
Did I get 1 through 19? No missing. Okay. I don't have any further questions for Ms. Day.
All right, thank you. Cross-examination.
Definitely.
Afternoon.
So obviously, protecting attorney-client privilege is taught in law school 101 if you're representing clients, correct?
Yes.
It's very important to you.
Yes,
Entire firm, correct?
I don't think just our firm, but yes, it is very important.
Very important. And so you have testified that other people had access to these emails.
Yes,
Do you know who Sundar Pichai is? Pichai.
no,
Are you aware that he had access to all of these emails?
no.
Do you know who he is?
No,
He's the CEO of Google. You understand what I'm getting at?
no.
No, the twins were not in the car. His other 2-year-old daughter from the new wife was in the vehicle, and she was 2.
Are you aware that all of the information that we're discussing here today was obtained from Google?
Yes,
Not your office, not the defendant, correct?
correct,
A third party.
correct.
And you're aware of Google's, I guess, insidious reputation of using all user information for their own purposes, correct?
Not particularly.
Have you ever used Google Maps and it tells you where you're going before you actually go there?
Maybe I'm not sure.
Have you ever received an advertisement based on something that you were talking about or something that you were searching on the internet and suddenly you get pop-up ads for that particular thing?
Sure,
So you're generally aware of the concept that third parties have the information and use it as they see fit, correct?
yes,
So you were aware that your client had a Gmail address.
yes,
And so all of his information would be part of Google, correct?
I suppose, yeah.
And certainly you, in your experience and in the vast experience of your firm, would know that law enforcement agencies serve search warrants on Google to obtain communications between your clients and other co-defendants or things like that, correct?
Mhm.
So yes.
Yes, sorry.
And so certainly that's something that you knew and could have tried to prevent by using encrypted things to communicate with your client over the interwebs, correct?
I suppose that's a possibility.
Well, when you meet with your client, you make sure that no one else is in the room. That was one of the first questions that was asked, right?
Yes,
When you communicate with your client, you use Google.
sometimes.
And sometimes certainly you're aware generally that you could use a more secure way to communicate with your client, correct?
I thought our emails were secure.
Okay, but you agree that you're aware of more secure lines of communications that are encrypted, things like that.
I have never personally used a more encrypted. We've never had issues with our emails like we have in this case.
Like WhatsApp, I think is encrypted. You've heard of that before?
I've heard of it, I've never used it.
So you would agree that the two different items that you've reviewed everything that the state of Florida has actually looked at were not emails, but actual just documents, correct?
They were documents attached to emails.
But the form in which the state of Florida had them, they were not attached to documents, correct? I understand they may have been attached to documents, but the form that we reviewed them at, they were not.
When you reviewed them upon being provided by Lindsay Butler?
Yes, they were just, or both, from Lindsay Butler, you took a deposition, so you know. Lindsay Butler did not click on an email and then take an attachment and send it to us, correct?
Correct, that's not how the Google returns come.
Right, it came just as a document, correct?
Correct,
And it was labeled either confidential or confidential, correct?
correct.
It wasn't labeled attorney-client privilege, it had none of your names on it or anything like that, correct?
The email that they were attached to did.
Correct, but we didn't know about that email.
Not the way it was sent to you, correct?
There would be no way for us to know the email unless we were searching the emails.
Or unless Nazario did the tape review.
Well, we talk about tape review. You would agree that tape review in your training experience is generally done when agents are actually looking at the communications themselves to determine whether or not those communications contain privileged information. Is that fair?
Sure.
And in this, what happened in this particular case is the communications weren't even reviewed. They were immediately dumped into albeit unlabeled, into a different folder. So they were never actually even reviewed. If they had an attorney name on it, it was sent to a different file. Correct?
The way the Google return works is all attachments to emails are separated from the email folder and are put in their own document folder. So correct, there is no way that you could associate a document with an email absent looking at both folders.
And in all of the communications that your firm did with the state of Florida, there was no alerting before the fact that anything that is labeled either confidential or confidential is actually an attorney-client privilege, correct?
I don't know that I understand the question.
Well, let me this real fast. You alerted the state of Florida as to all the names, phone numbers, and emails, correct?
Yes,
And you could have alerted the state of Florida that you told your client to label attorney-client privilege attachments as confidential or confidential, and that we should be on the lookout for any documents that say confidential or confidential, correct? But you didn't.
we informed the state that there were emails, those documents were contained in emails.
You informed after the fact about them, once we told you about them. But before the fact, you could have told the state of Florida, let me ask you this way, did you know at the time that you asked the state, when you gave the names and the emails and the numbers, that attachments would be safe?
Okay, that was not Shannon's daughter. That was the daughter of her ex-husband and his new wife. So no, she didn't care about that child. Neither did the gunman. I'm shocked that they do that with children in the car.
Gave you a different form on Google?
Yeah.
Okay. But certainly, you could have informed the state that your client was sending attachments and labeled confidential and confidential, and we should be on the lookout.
Had we known the state was going to review email attachments before sending it through the team, we absolutely would have researched every attachment title, and we would have provided that.
I understand your testimony that these documents were emailed, but the state did not review email attachments. To be very clear about that.
The confidential conversation is an attachment that the state has reviewed.
I understand it was attached to the email, but the state did not click on the attorney-client privileged email and read that document. Those are two different things.
You did read the document.
Correct, but we did not click, I agree with that. We did not click on an email addressed to an attorney or vice versa that had an attachment, correct?
I have no evidence that you clicked on the email, correct?
Well, you have evidence to the contrary.
I do not, no.
Let's talk about this text message. You would agree that Henry Tennant is not your client.
Correct.
And that Henry Tennant's communications will not be privileged with your client.
Correct.
Okay. The timeline, I have never seen either one of these documents, but my understanding is that the timeline contains dates and generally known information that could be found in other sources. Is that very accurate?
I'm going to object to insert privilege. That's why we provided it to you.
Okay.
Well, the court's seen it, that's fine. Well, I don't need to know the nature of it. I just need to know whether or not these things could be found in other ways. Like birth dates and things like that. That's my understanding of what's going on. Does it make sense?
I'm going to ask that she be prevented from instructor not.
I'm asking what it is.
Let me see you roll outside for it.
Yes. Okay, guys, we're in 15 hours, 7 minutes, and 38 seconds into deliberation in the Ali trial. I hate that the poor load lady has to carry up her machine every time she goes up. That's ridiculous. That is. Oh, Brooklyn, you were so good. That is good. That is so good. Oh, I am so over this verdict watch with the Ali. I don't know why they're not back yet. I do not know. That is frustrating. But I'd rather them take a while and get it right than not get it right, you know. I didn't know my voice was open on my phone in Discord all this time. Yeah. I don't know him. I don't think I've watched anything with him in it, so I don't know. I have no idea. Me no nada. Me no nada. Nada nada. By the way, everybody, thank you who are joining and lurking in the background. You are so welcome to comment here, but I understand and I appreciate you being here. Please like and subscribe and share. It would greatly be appreciated and it will help us out. And when you do that, if you will type the comment I like, I share, I shared, and I sub. If you're a new subber, only for people first time subbers. If you will do that, here's an I shared. Type it all caps ISHARED, ILLIKED, or ISUB. Here's an I liked. When you do that, it will get you an entry. It's all free for the end of the month giveaway. Thank you, Luca. Thank you. He's the attorney on record for the Casey Anthony case. I didn't follow that. Oh, the Aaron Hernandez. I don't think I followed that. I haven't been doing this but a year, so there's a lot of these older cases. I don't know. Oh, excuse the yawn. We need a stretch break. Man, I could have gotten more sleep. I could have slept till 10 and not gotten up at 7:45 after falling asleep after 4. I had 3 hours and 45 minutes of sleep. Tink and I were talking late last night. My hearing aid died, and I just thought, boy, she just thought I fell asleep on her. I bet she thought I just fell asleep. Nope, my hearing aid battery died. By the time I got them put back in and came back, she was gone. Wow. Yeah, why were you up at 5 a.m., my dear? Yo, that's saying a lot, boo. Why were you up at 5 a.m.? Why? Girl. Oh, excuse the yawn. Yeah, I know. I'm Yanni. I almost said Yanni Ronnie. That would have been fun. Not what I wanted to do. Yeah, maybe it is. Maybe it is. 5 p.m. Okay. Well, train them to get up later. How is there not a verdict yet? I don't understand what the jury's having a hard time with. My faith is in our justice system is fading fast. Hi, Eddie M. I honestly think they had a question about the third charge, which was the kidnapping charge, and I think that they're hung up on that. A lot of people don't understand that kidnapping is not always where you tie someone's hands and carry them across the state line. I mean, kidnapping is impeding anybody's ability to move freely.
The timeline contains information that could be found out through other means, through normal due diligence in investigating the case.
And count 3 of daddy.
It's possible, but I don't recall the specifics as to what's contained in the timeline.
think you said something about uploading into Nextdoor. You couldn't do it. I think you did upload things into Nextdoor. Is that true?
I don't think so.
You've never, the Geiser firm has never uploaded.
This? Oh my gosh.
You would agree that at least for a time during the pendency of this case, that Ms. Gardner and Mr. Fernandez Saldana had joint representation.
Not with our firm.
But certainly you were.
Good for you, Boo. Thank you.
With the other firm's email and contact information, things like that.
Thank you, Boo.
I passed their contact information from their office to Ms. Stickler, yes.
And you would have joint meetings with counsel from Ms. Gardner, correct?
I don't know that I would say that.
There was never a discussion of joint trial strategy or things like that, how to handle what's going on?
I don't believe so.
If you don't know,
I don't know.
that may be something that someone else.
Yeah, possible.
In your motion, with regard to the disqualification of our office, asked for Next Point to be shut down, correct?
Yes,
So that's, I want to make sure that was why it was shut down so quickly.
yes.
As you sit here, and I think you said 1,000 hours, wow, a lot of time. As you sit there now, do you possess any evidence whatsoever that the state of Florida looked through the emails that were improperly labeled that were uploaded to Next Point?
Aside from the attachments,
Aside from the timeline and the text messages that were referred to.
I do not personally have any evidence of that, no.
And your research has not led to.
No.
Well, no, you're not.
Yes.
That's all.
Any redirect?
A few things that, the text messages, you testified that text messages between perhaps Mario Fernandez and Henry Tennant may not be privileged, is that right?
They may not be.
In this case, do you believe that they are privileged?
Objection, huh?
Friends.
Speculation goes to the heart of the matter. Belief is not what's relevant.
Oliver Rock.
In this case, Ms. Day, were the text message in the limited, I'm very specifically in the limited.
Okay, we do have the clock has stopped. I'm guessing they're on their morning break. It's 10 o'clock their time, but the clock has stopped in the Ali jury deliberation for a few minutes. I'll let you know if anything pops up.
Capacity that they existed in that attachment, did our office consider them privileged?
No, this is to do with the police they were going through not Cellbrite, but this has to do with the fact that the phones and other electronic devices had communications between the defendant and her attorneys, and hold on. They have a question, so we're gonna keep an eye on them. So anyway, as investigators were going through the phone and devices, they were supposed to send everything off to a third party to have the information redacted. That was information that was considered private, confidential, attorney privilege, and something went awry, and so we're in a hearing. And this is that's who's testifying. Somebody involved with that.
No.
I'm asking, you know, capacity.
Yeah. Yes. Sorry, I misunderstood your question. Yes, we did consider them privileged.
And are you personally aware who created that document?
Yes, Mario did.
And if the state had those messages downloaded from Mr. Fernandez's phone between Mr. Fernandez
Thank you, Flash
and Mr.
Fan.
Tennant, then would those messages be privileged?
No.
Do they exist anywhere else in this case besides the attachment?
No.
And who created the attachment?
Mario.
You testified and the state asked you about the difference between the email and the attachment. You understand what I'm asking you?
Yes.
In a vacuum is what the state is saying they saw this attachment. Is that how you understand it?
Yes.
I went through a litany of documents and timeline with you.
So the powers that be, the court people are heading into court for the question. As soon as that comes live, we'll pop it up. But there is a question. I hope it's not. We think we're hung, Your Honor.
Could have our office acted any faster in trying to preserve any communication that we had with our client, in your opinion?
I don't think we could have done anything more or faster.
When did Agent Nazario get assigned to be the filter agent?
I believe it was February 27, 2023.
Had he even started on the Google return that contained those attachments in July or June 30th when those emails were sent to the state?
No, I believe he started August 21st of 2003, which would have been months later.
And Mr. Mizrahi said to you, in your understanding of the taint procedure, he gave you the credibility that you know something about it. My question to you now is, was Agent Nazario going to just look at emails, or was he going to cross-reference the documents folder with the email folder?
He testified at deposition that if he had found an email with an attachment, he would have cross-referenced the other folders to remove the attachment from those folders as well.
Can you see your screen?
Yes.
Is this a part of a deposition transcript that we took and is part of the record in this case?
Yes.
Between our office and Mr. Baez's office and Agent Nazario?
Yes.
Okay. Can you read the top paragraph?
Yes. Question, and if in fact the attachments existed somewhere else besides the email, is that where your job would have required what we talked about in the beginning of the deposition, which is a little bit of cross-referencing to filter out from the device itself where it's being stored, that you may have to remove that as well? Answer. Part of my search parameters did include the locations within the parse data to include any images, any documents, anything that was stored elsewhere. So say, for example, I found a privileged communication that did have an attachment. I would then try to locate those attachments within the other locations of the parse data to then have those tagged as well and removed.
Did Agent Nazario even have the chance to do his work before Lindsay Butler sent those two attachments to the state of Florida?
No.
Lastly, Mr. Mizrahi asked you why we provided Hank Cox of the Dell firm's email in our correspondence to Mr. Fernandez, to the state of Florida, in the exhibits of the letters of our contact information.
Yes.
Do you recall that answer?
Yes.
And that question?
Yes.
At some point in time prior to our representation, did Hank Cox have possible communications with Mr. Fernandez?
Yes.
And were we trying to protect any communications that Mr. Fernandez had with any lawyer that he may have retained?
Yes.
No further.
Yes, witness speaks.
You're going to ask a recross based on something that was just asked.
Something new?
Yes. Mr. Dreiser asked you, I'll redirect, about the, in your opinion, whether or not the text messages between Henry Tennant and the defendant were privileged in this context, correct?
Yes.
You said in your opinion they weren't, correct?
Yes.
And you would agree that at that point, when these text messages were sent to your office, that the defendant knew that he was being investigated for a criminal crime, correct?
Well, no, it's a privilege. You can only know that if you knew what Mr. Fernandez had told his lawyer.
I'm not getting into the substance, Your Honor. He retained counsel. That's why we're here.
It's bootstrapping substance. If you know the answer to that question, you knew it because of what Mr. Fernandez perhaps told Ms. Day, myself, or Mr. Hill, or Mr. Stone.
Let me look back at the question, okay? I'll sustain it.
For 3 days, 15 hours, 13 minutes, and they have their second question. They notify the court that they are interested in understanding something, but we don't know what that is yet.
You see live pictures.
In other words, can we find him guilty or whatever on all charges and be hung on one?
From inside the courtroom. We're being told that the judge is allowing the parties to assemble, and because there's interpreters here as well, it's not just the court staff and the attorneys for each side. They are estimating we're not going to know this question for about 20 minutes. So we got a little 20-minute waiting period here, but this could be big. Are they going to be deadlocked, or are they just going to ask a procedural question, which was basically their first?
You were hired as Mr. Fernandez Saldana's attorney before these phones were seized and before the Google.
Okay, so we're going to have a 20-minute wait.
The officer was retained because he was under investigation for a criminal matter, correct?
Objection, privilege is why we were retained.
I'll remove that question. Your client, if the text messages don't exist anywhere else, what happened?
I don't know.
Would you agree, because you've given opinions about things, would you agree that the deletion of communications between your client and a potential co-defendant could amount to tampering with evidence?
I'm going to object. It's argumentative, asking her to draw a legal conclusion, and quite frankly, it's asking the lawyer of a client to potentially incriminate him in a new crime.
Well, Your Honor, the reason I asked that is because I didn't ask it on my original cross-examination. Defense counsel got up here and asked this witness about whether, in her opinion, this was privileged communications.
Okay, so what does this question have to do with anything?
Because I'm trying to show that it's not privileged communication. I'm trying to show that this was evidence in the case. It suddenly doesn't become privileged because they email it and he deletes it.
Oh, why, thank you, Ada.
That's what we're trying to show. And that's my point. I'd like her to answer that question.
There's no evidence that it existed besides that document.
Mr. Drive, hold on. Just move on. I think you can make those arguments without asking the question. I think it's dangerous territory.
Okay, no further question.
May the witness be excused?
Yes.
All right, I'm gonna take a 2-minute recess.
I'm sorry. I am so sorry, hon. Madam, women, ladies. All right, guys. I know in this day and age, people really don't care. But in my time, when I was young, I never needed anyone. Look at how you look from behind when you put clothes on. Panty lines, bra lines, roll lines. I'm not trying to be mean, but there is something said for an all-in-one when you wear that kind of material and dress. Just saying. Especially when you're in a court that has a live feed and the backside of you is going to be showing more than the front. Either that or put your long hair and cover it up. Sorry, I just can't. That's not me. I was told that we would have this happening, so we're prepared. I mean, it doesn't look bad from that angle because she's all stretched up like that, but ladies, foundation is important. And I'm sorry. I feel like we as women have let ourselves go and we don't think about these kind of things anymore. I'm just saying, if I'm going to be in a courtroom or anything that I need to be concerned about how I appear from both front and back, this chick is going to have a girdle on. This chick is going to have a slip on. But you can't even buy a slip anymore. No one sells them. I had to make my own. Frankie. Okay, Tinkitude, your first major decision as a mod. Do you time him out or not? My skin is getting, look at that. I used to never be able to do that. Blue skin. Maybe one day I'll be like this again. I'm not far from it.
The clerk has it all. He said so, but I'll make it. I'll stand up. Thank you.
It's like, don't make me get the bot. Don't make me get the bot. Don't make me send out the bot alert. I know, Ronnie, I'm being silly. I'm just being silly. But see what I mean, y'all. Let's just skim through because I don't want to sit here and watch all these backsides. Just saying.
I immediately called the contact me.
Frankie Leroy, we're kidding, boo.
Client communications uploaded to the site, and this was after hours.
Frankie, we're teasing you, honey. You're good.
Immediately shut down access of all users and all Next Point staff to all of the information on the platform. I then the next day called Mr. Carodi on my phone and advised him of this issue and asked him to not review or to return any information they may have downloaded. I also emailed Ms. Michelle Medina with the bias team, spoke with her, advised her of the situation.
Hey, BK Jr.
Stop reviewing and or return all information that they had downloaded from Next Point.
And have you subsequently gone back and asked the Jacksonville Sheriff's Office to do examinations about whether or not these items were accessed?
Of the Google Drive that's at issue in this hearing, Mr. Fernandez Saldana's, I had a computer forensics expert with the Computer Forensics Investigation Unit with the Jacksonville Sheriff's Office do a forensic examination of the flash drive that contained the return from Google that came directly to Detective Johns, specifically the folders labeled email and email attachments. And Detective Ostertag with the Jacksonville Sheriff's Office was able to verify that those particular folders had never been unzipped, opened, or accessed, at least from the examination he was able to do on that flash drive in Detective John's computer.
I am so sorry, boo. Oh, I went through breast cancer, but I got to keep my girls. Mastectomy's move vibe, LOL. Oh, honey. My heart goes out to you. Don't make me cry.
We have
I was sobbing earlier, so don't make me cry.
States Exhibit 1 for the purposes of this hearing by stipulation.
I believe it was even in States Exhibit 1.
So we heard, we were able to hear on direct examination, has anyone in law enforcement of the state attorney's office accessed emails, actually viewed the conversations between defense counsel and their client?
No.
And what was the intent of, let me go back for a second, what was the intent of the investigation into Mario Saldana's cell phones? What was the purpose of seizing those and searching?
During our investigation, it became known to us that the defendant, Mr. Fernandez Saldana, was communicating with the individual who later confessed to shooting and killing Jared Bradigan, Henry Tenen, leading up to the homicide on February 16th, 2022. Afterwards, for multiple months, with a flurry of activity at what I would call significant investigative points in our investigation, up until Mr. Tenen's arrest on unrelated charges on August 18th, 2022. We also became aware through a previous Google return search warrant prior to the one at issue in this hearing that Mr. Fernandez Saldana had deleted a large amount of data on his phone and in his Google account at those points that I would call significant investigative points. Specifically, when he was going to speak to investigators with the Jacksonville Beach Police Department in March and April of 2022 after the homicide, he deleted, I would say, approximately 500 times more the amounts of deletions he would normally do.
Object to relevance, Your Honor. We didn't file a motion to suppress the seizing of the devices. They seized the devices. It's only a limited issue as to the attorney-client privileges on those devices. So what he did.
What are the grounds?
Relevant.
What's the relevance of this?
The intent under which the state endeavored to perform investigatory steps in this case is relevant for the intent surrounding any inadvertent handling of attorney-client privilege or any inadvertent viewing of attorney-client privilege, because the intent was based on credible evidence that we were allowed to get search warrants for, not to search anything having to do with the defendant or his attorneys, but for the defendant and his co-defendants. And that's what we were looking for.
Right, I'll overrule the objection.
And because we were just looking for evidence between the defendant and the co-defendant, when you were aware that these devices or Google clouds would have potential attorney-client privilege, were you, as the lead prosecutor in the case, interested in all of those conversations?
Not attorney-client conversations, no, but.
Would that help us prove anything?
No, we're not.
You were searching for conversations between the defendant and his co-defendants?
Yes, in particular, Mr. Tenen and his wife, Shanna Garner.
And so did you ask anyone as a Tate agent or any other members of law enforcement to review attorney-client privilege information, potentially attorney-client privilege information, to do a deep dive into whether or not it was attorney-client privilege?
No, in fact, the opposite. I instructed law enforcement and Agent Nazari of the Secret Service, unlike a classic taint review where the agent is reviewing the content of communications and making a legal determination whether it's privileged or not, I entered into an agreement with defense counsel and Ms. Gardner's prior defense counsel and instructed law enforcement based on that agreement that anything between an attorney and a client should be deleted regardless of content. It was what I call a
Here we
Headed
go.
to the courtroom, the judge on the bench.
By the way, Alita, I am so sorry. My heart goes out to you, but I'm so, as a fellow cancer survivor, thank God you lived, and thank God you're with us.
We are present on cases 24-1-130234 and 24-1-132534, State versus Ali. Ms. Stone and Ms. Zoe are present on behalf of the state. Mr. Kading is present representing Mr. Ali, who is present. Mr. Leary is present representing Mrs. Ali, who is present. We have a question from the jury. As it applies to instruction number 46, element 2, does the violation of a temporary protection against a person or property therein? My proposed answer, please refer to and reread the jury instructions. Ms. Stone?
I gotta go.
Yes, Your Honor, thank you.
I gotta go back because my hearing aids disconnected. So let's play it again. Wait.
Against a person or
It was
property
them.
therein. My proposed answer, please refer to person who is present. As it applies to instruction number 46, element 2, does the violation of a temporary protection
Okay, I guess they're cutting out the name.
or property therein? My proposed answer, please refer to and reread the jury instructions. Ms. Stone?
Yes, Your Honor, thank you.
Mr. Kading?
Yes, Your Honor.
Mr. Larry? All right.
So they're going through the jury instructions as they apply to each count. Actually, I can appreciate this, y'all. I know it's long. I know it sucks, but they are doing their due diligence. They're doing it methodical. This also helps with appellate issues. So I'm very grateful. They're on 46 out of 49. We may have a verdict today. God, I hope so. I would hate for them to have a 3-day weekend and come back, and us as well.
There were 2 sheets to get in. There you go. Thank you. Thank you. All right, we will be.
No, it's the restraining order. See, you're saying it was the restraining order against the boyfriend. No, the boyfriend's father and had a restraining order against Mrs. Ali, so she couldn't go anywhere near his son because of her past behaviors. Oh my gosh, radiation is next, boo. No. No, you're going to have radiation. Oh, boo, my heart goes out to you. Keep us posted. We'll keep you in prayer. Oh, gee, gads, honey, we're with you. We're with you. I swear that woman in the dark glasses, is that you, Alita? Are you the blonde or the brunette? Because a brunette looks like she could be my mother. I kid you not. They could be sisters. Yeah, that's why they blocked the name, because he's a minor, or he was. Yep. So the thing is that, so that's why it's taken so long. They're going through everything methodically. And I'm happy with that. I know it's long on us, but I'm glad that they're doing it the correct way. Okay, we're going to hop over.
Recess. Thank you.
All rise. Court's in recess.
All right, that question, we did have to drop that sound because of the minor name that was included. We can only say the first name of the boyfriend in this case, but the question.
I have had mammocyte radiation. It's a little different from what you're probably going to have, but radiation, it sucks. So many of us have been there. We're praying for you.
Question from this jury is, does that protection order, the order of protection, temporary protection order that was in place against mom, we know that from the testimony in this trial, does a violation apply to the boyfriend, his person, or to something broader, the person or places or property, perhaps the building is what they are asking about.
Because this bus stop was near the school.
Right. Which was on school property.
Hey, Flash fan, if you're still watching, will you go to private message, please?
It seemed, because we had the officer in the body camera footage when he's basically interviewing mom. He said, you know, you're not supposed to be here in violation of the temporary protection order. We told you about that. So that would seem to be more property, but the jurors want to know if it had to do with just the boyfriend. Let's bring in our guest who's standing by this hour to help us analyze this in Los Angeles, California. We have trial attorney Miguel Custodio. Miguel, good to see you. Tell us about what you think about this question. I mean, this is count 5 for mom. If jurors are going through one by one, are we getting close to the end here?
It seems like we are getting close because, well, first off, it's good that they're being very thorough with all the charges. And sometimes we don't see that in all of the cases. And so it seems like they're going
Angela, oh my gosh, that's horrible.
It's very surprising that they're still deliberating, to be honest. And I think they feel.
Yes, they got a question about the 46th charge instruction about the restraining order, and the judge said refer back to the exclamation in the jury instruction. So they're struggling with that.
Just based on how it's the evidence that's come across this trial, it feels like the jury feels like the mom should be held accountable for something. Probably not the more serious charges, but I think that they really want to do something against her with regards to these lesser charges, and that's maybe where this question is coming from.
Yeah, if indeed they'd already found her guilty of something higher, this seems like a lot of jurors, which you sort of referenced to, would just sort of check that one too. Throw it on top. It's the least, and it's she's guilty of that as well. So if you're the defense, especially for mom here, and this is the question,
I'd be feeling good.
Hours and counting of deliberation. How are you feeling?
Feel pretty good. If they're asking about a protective order, and we know it's one of the lesser charges, I think that her fate is going to be probably less than what her husband is going to have to deal with. I think the video shows clearly the husband choking the daughter. The mom, I think there's evidence from the daughter that it's hard for the jury to really find her guilty of one of these higher charges.
And just to let our viewers know what that penalty is for that count 5, the violation of a temporary anti-harassment order, it's a gross misdemeanor. So the penalty is up to a year or a fine of up to $5,000. So we are talking really about the lowest of the charges that are against any of these. And the dad doesn't have a violation of a protection order. That didn't apply to him. It was the mom who went on to school property and confronted the boyfriend at a prior time. What does that look like going forward, Miguel, in terms of these defendants? If we have dad guilty, mom not guilty, but they still have children together, there's perhaps if mom gets a violation of the lower, does that impact their ability to move forward as a family?
I think it does, because you're going to see dad in a jail, prison, mom with a misdemeanor.
Okay, guys, unfortunately, I have to go by the bank. I've been needing to do it, but their lobby closes early today, so I'm going to have to go by the bank. So what I'd like to do is we already know about the questions and everything, so we're going to put this on the side here. We're going to go back to the other trial over here, the hearing on the Stampin' Up! Eris Redrimmer. And what I'm going to do is I'll have the live going off in my ears while the bank is literally across the parking lot. And I will be back. If there's a verdict, I'm going to bolt. And I'll have my son come over here and switch the feed until I can get back. But it's something I have to do. I cannot avoid it any longer. So mods, I appreciate your help and just kind of keeping everything flowing. And I'll return as quickly as I can.
Welcome back to Court TV Live. Thank you for following along with us. We have just been reporting that breaking news out of Washington State, where in the case against Ihsan and Zahraa Ali, those were accused of second-degree attempted murder against their daughter. The jury had their second question. It pertained to count 5 for the mother. And we wonder if, because that's the last count for the second defendant, will the jury have a verdict very soon? Could be imminent, so we will monitor that courtroom for anything that happens there.
Yeah, our team is there as well, and as soon as we get word that there's another question or a verdict, of course, we'll immediately head out to Washington. Right now, let's head to Montana. More testimony in day 2 of the returned mail murder trial. Defendant Jordan Palmer killed his neighbor, Stephen Campbell. Nobody is arguing that. He admits it. But was it self-defense? He claims it was self-defense after he says he found a piece of mail on the ground and wanted just to deliver it back to his neighbor.
Yeah, he says it was all a misunderstanding. Let's get back into the courtroom now. We've been listening to the detective on the stand, and it's the cross-examination by the defense attorney who's been really turning this witness into her own use of force expert, asking what a detective or a police officer would do if their life was in danger. Let's go in.
And Your Honor, if I may approach to hand the witness a marker.
You may.
Let the record reflect that I just handed Detective Sirvante a Sharpie marker. Detective Cervantes, can you point to where Mr. Campbell's residence is in this image?
No.
Do you recognize this as a aerial view of the 804 Mantle Drive area?
It appears that it is that area.
So on the right side of the street would be 803 Mantle, where Stephen Campbell lives, right?
On the right side?
I'm sorry, I misspoke there. So the left side of the street is 803 Mantle, where Stephen lives, correct?
Yes.
So could you,
Yeah, unless he was representing the fact that it was not.
I'm sorry, Your Honor, I just misspoke there. So the left.
Excuse me, Mr. I have to make the record. What was your objection?
Just representing the facts and evidence as to the number of the house.
All right, and Ms. Wasofsky, what's your response?
And I did misspeak there, my apologies.
All right, so I'll sustain the objection. You need to fix the record to make sure you have the correct number, all right, Ms. Wasofsky?
Detective Cervantes, Mr. Campbell lived in 807, in the 807-808 Mantle apartment complex, right?
The 807 apartment complex, yes.
And that was on the left side of this picture, right? You can barely see it, but it's you can see the driveway to it, right?
Yes.
Can you mark the edge of the picture where Mr. Campbell's house would be?
It would be in this area.
And then could you just write SC1 where Mr. Campbell's house is? And Detective Cervantes, could you write that in a little bit larger lettering so the jury can see it? I'm sorry. Let the record reflect that Detective Cervantes has marked the left side of the picture with the labeling SC1 to denote where Stephen Campbell's residence was.
Record so reflects.
And Detective Cervantes, do you remember where Stephen Campbell's clothes were located on that scene?
I believe they were in the general area. They were in the driveway of 808 Mantle Drive.
And his clothes show where his body would have been found, correct?
Correct.
Or where he was laying down on the scene when officers arrived.
Correct.
Detective Cervantes, can you denote that location with SC2? Let the record reflect that Detective Cervantes has now written SC2 on the driveway on the opposite side of Defense Demonstrative A, a map. So Detective Cervantes, what that means is that Stephen Campbell went from the left side of this image, or the left side of the street shown here, to the right side of the street, right?
Yes. Yeah.
And I'm going to ask you to draw an arrow showing the way that Mr. Campbell moved, okay? An arrow from SC1 to SC2.
I don't know if the exact direction Mr. Campbell moved that night. I don't have any personal knowledge of the way he moved.
But you can testify that he started off in the SC1 area and he ended up in the SC2 area, right?
Yes.
So he went from the left side of this picture to the right side of this picture.
Yes.
And he went across the entire street, right?
Yes.
And you can see from the little measurement at the bottom of the image that the street is about 10 meters wide or a little wider than that, right?
Yeah, that's what the image shows. Yes.
So that's the distance that Stephen Campbell traveled. Roughly that, or even farther than that. And Detective Cervantes, do you remember from the video that you reviewed where Jordan Palmer was before Stephen Campbell came into view?
He was near the mailbox.
And I'm going to ask if you could write a JP in roughly the location that you remember him being. So Stephen Campbell ended up in the location where or around the area that Jordan Palmer was initially, right?
Yes.
And he started off farther away from that. And that would suggest that Stephen Campbell moved towards Mr. Palmer instead of the other way around, right?
With the video, it was appeared different in the video. They had confronted each other in the street.
But you see that he goes from the left side of this image
Yes.
to the right side. Now, Detective Cervantes, I'm going to show you again State's Exhibit 108. And this image is a little bit blurry, but in this picture, can you point out for me, and I'm gonna ask if you can leave the bench in order to do this, if you can point out for me where the clothes of Stephen Campbell are located in this picture.
This fully have the objection if the detective approaches the street. No objection. You may, detective.
And detective, if you want to use this pen to point, you can do that.
The clothes are right here.
And you may return to the stand now. So in this image, you can see that the clothes are several feet away from that mailbox, right?
Yes.
Thank you. And Detective Cervantes, I know we've already been through a lot of photos today, so I'm not going to have us go back through most of the state's exhibits, but I just want to focus on a couple that are relevant, okay? This is State's Exhibit 157. And this shows the magazine of the gun, right, Detective Cervantes?
Yes.
And you can see in this picture that there are 8 rounds still left in that magazine, correct?
Correct.
And what that means, right, is that Jordan Palmer did not empty his clip, correct?
Correct.
He stopped firing before he ran out of ammo, right?
Correct.
Now, I also want to show you what's been marked as State's Exhibit 101. And this exhibit shows a picture of a freshly burnt cigarette, correct?
Correct.
And you labeled it with tint marker 15, right?
Yes.
Do you remember, and I'll show you State's Exhibit 103 to help with this. And I'm going to ask again if Detective Cervantes can leave the witness stand in order to point to the exhibit.
This fully have the objection.
No objection.
Detective demand.
Detective Cervantes, I'm going to ask if you can circle where tint marker 15 is in this exhibit.
So on where is he marking that on the hard copy?
Oh, I am. And if you can actually just point to it, Detective Cervantes, that would be great.
I can't tell if that's marker 15 or not, but the far tent is in the general vicinity of where marker 15 was.
So that would be where the cigarette is, right?
Yes.
Thank you, and you may return to the stand.
That it sounded like at some point, maybe I just didn't understand your testimony, no one ever clicked on the attachment, and if they did, it just would have been like zeros and ones in code.
That's my understanding from Ms. Butler.
But when you clicked on it, when it was emailed to you, and you clicked on it, it wasn't zeros or ones or code, right?
Right, the document, emails themselves, if you clicked on an Outlook file without having Outlook loaded, would not load. The document, you're able to look at because it's a thumbnail. The emails, if you clicked on them, unless you ran it through the applicable program, you're not able to read it.
So clarity, the emails may have been some kind of code, but the documents that are in question, confidential conversations and confidential timeline, anybody could have clicked on it and read it.
Yes,
Ms. Butler, in fact, clicked on it and read it.
yes,
You are the lead prosecutor in this case?
yes,
You're not working alone though, right?
no,
You work with Mr. Mizrahi,
yes,
you're working with Mr. Wingard,
yes.
you attend meetings with the both of them,
In general, yes, in regards to this case, yes,
and at some point in time, when Mr. Hutton was an employee at the state attorney's office, was he part of your team?
yes,
And there are times where you would roundtable issues specifically the issues of these documents you did discuss with Mr. Hutton.
I discussed the issue of these documents prior to reviewing their contents with Judge Hutton, yes.
Now, the Honorable
Yes.
Judge Hutton.
I can't not use his honorific.
Understood. And for the purposes where this all started, would you agree, just to kind of make a clean record, on February 6th is when you seized the devices that had the ability for you to get the Google returns?
Law enforcement seized the devices in Washington State and Orange County, yes.
No, Mr. Fernandez was not in Washington. He was in
No,
Florida.
Ms. Gardner.
I'm not worried about Mr. Gardner. Mr. Fernandez's devices were seized in Florida, right?
Yes,
And you would agree the next business day is when I sent you that letter saying, hey, I want to see what I can do about it.
yes,
And you had already run a wire, and you suggested that you wanted to make sure that the attorney-client privilege communications on the wire didn't get intercepted. Right?
yes,
You weren't doing anybody a favor. That's the law under Title 9, right?
right.
Title- So the wiretap statute, that you have to minimize certain conversations and avoid the interception of attorney-client privilege information, right?
I'm not sure about the title number, but
Sure.
we were going to comply with both legal and ethical duties, and our entire intent was not ever to intercept any attorney-client communications.
And on Exhibit 9, which is the letters, you can pull it up so you can see it. Those are letters that my office did in fact send you,
Yes,
and they were attached ironically to emails, right?
yes,
So if there was a Google return of that information or some server return, it would have gone perhaps to a file, and the email would have gone somewhere else.
my understanding, it probably was duplicated in multiple folders.
That's not,
But this one's on letterhead, so we wouldn't have read it.
it's not an uncommon form of communication, right?
Emails, no.
And attachment.
Yes,
Please see attached.
yes,
You see that regularly in your line.
yes,
And we sent this to you multiple times, once right after and before we got the order, and then again right after we got the order from Judge Parker.
yes, and I was in agreement with it. We agreed not to download any devices until we had the hearing. And I agreed not to download them even after Judge Corbola's denial, in order that Mr. Cox or yourself could file a stay or file an appeal.
And we had an agreement, and that
Yes.
was read in court, footnote 4.
Yes,
And Mr. Fernandez, at some point in time after we had come to this agreement, you don't disagree that we had an agreement, right? What was read in court? That was your understanding?
our agreement,
Our agreement.
yes,
You, Exhibit 10, the entire document, 15 or 17 pages wasn't read, but the Google search warrant, did you help in that preparation of that warrant?
yes, the state attorney's office and our circuit reviews search warrants before the judges sign off on them.
Okay, so paragraph 11, you were aware that the Google return was not just seeking, it was seeking all of the things that are listed in paragraph 11.
Yes, photos, documents, videos.
Sure. So it's not foreign to you by any stretch of the imagination that there could be attachments to emails in the Google return.
Yes,
In all of the emails that we provided to the clerk and to your office that were redacted, would you agree that the emails are in fact the same emails that we provided you?
I'm sorry, I don't understand.
I'll ask a better question. The emails that we provided you multiple times in those 2 letters that I've asked you about.
The email addresses.
The email
Yes.
addresses are in fact the same email addresses that the emails and the attachments that are attached to emails in controversy are to and from those emails.
Yes, I don't dispute that those 2 documents I reviewed were attached to emails between you and your client.
Who is Agent Nazario?
Agent Nazario is a Secret Service agent.
And was he assigned to be the filter or taint agent assigned to this case?
Yes,
Is he the only taint agent and filter agent assigned to this case?
I believe so.
And when did he start, when was he given his title and his duties? Sometime in February, is that your understanding?
I believe so. I was not present for those meetings. I was not involved in that decision or in the procedure of the taint team itself.
But that sounds about right.
I think based on his deposition testimony and his reports that on February 27th, they created a procedure for the taint review, and by they I mean Secret Service and the Jacksonville Beach Police Department.
No question in your mind or anybody else's mind that on June 30th, Agent Nazario was assigned as the taint agent in this case.
Yes,
You knew who he was.
I knew of the existence of a taint agent. Again, the purpose of it was for me not to be involved. I don't know if I knew his name on that tape.
Okay. But you certainly knew a taint agent had been
Yes.
assigned.
From Secret Service, yes.
You had told me that a taint agent had been assigned.
Yes,
It's not a secret, and it was certainly
No.
someone that you and your entire office were aware of this procedure that was happening.
correct.
I'm going to show you Exhibit 12. This is the email that Lindsay Butler sent to you on June 30th with the 2 attachments.
Yes.
Again, yeah, she clicked on those documents or you clicked on those documents. It's not code, it's the documents in controversy.
Yes.
And before she sent those to you, right? She didn't send them to you unsolicited. Do you agree with that? If you don't understand my question, I can ask about it.
I think I can answer it. I told her she could send them to me after we had a couple conversations regarding that they were labeled confidential.
But you didn't just open your email one day and get these messages.
No.
It was after instruction by you to Ms. Butler to send them. Is that right? Okay. And it was because, and you testified, there was a couple conversations about these messages that there was some concern on Ms. Butler's part that she should send them to you because it could be confidential, right?
Yes, the word confidential made her nervous and she wanted to make sure that it did not have a legal meaning.
And the word confidential, what's your understanding of what the definition of confidential?
In this context, labeling something confidential could mean that it was privileged, or it could just mean that somebody was trying to hide something from somebody else.
And you don't know because you haven't seen the documents on June 30th, right? Well, prior to June 30th. When you're having the conversations with Ms. Butler, you don't know, right?
Yes, she called me on June 29th and said she had a question, she had a concern. She found documents in a folder and they were labeled confidential.
And you know, because you sat in the deposition of Ms. Butler, that Ms. Butler was aware that a taint agent or a filter agent was assigned to this case when she had that concern.
Yes.
And fair to say, and I'll ask a few more questions about this, that was never sent to Agent Zahraa.
Correct.
Before, and in addition to the conversations that you and Mrs. Butler had, there was a text message. Is that right?
Yes.
And is this the text message that you provided me, Ms. Stifler?
Yes.
Okay. And it says, Ms. Hutton and I say no privilege. That's the first sentence?
Yes.
Ms. is Alan Mizrahi.
Yes.
Hutton is Lee Hutton, the Honorable Lee Hutton at this moment, but at the time, a chief assistant of the state attorney's office.
Yes.
And I is you, Christina
Yes.
Stifler. And you say no privilege. Is that right?
Yes.
But you haven't seen the document at this point.
Correct.
Alan Mizrahi has not seen the document at this point.
Correct.
And Lee Hutton has not seen the document at this point.
Correct.
You were not part of the taint team at that time, were you?
No.
Alan Mizrahi was not part of the taint team at that time.
No, nor Judge Hutton.
And you make a determination, no privilege. That's what you write. That's what it means, right?
Yes, following our conversations.
Read them and call me immediately. That's the next line of the text, right?
Correct.
Never at any given point did you, Judge Hutton, who was not a judge at the time, that's the record, it's an important point to read off, or Ms. Rahi, or anybody else in your office say, the lawyers in this case have done all of these things to make sure privileged communications. Why don't we send it to Agent Zahraa? There's no conversation that happened or occurred.
No, because we were making the determination, if we sent it to Agent Nazario, it would have been deleted because he was doing content line deletion.
If it was sent to Agent Nazario, it may have been deleted because if he did a cross-reference, he would have seen that it was attached to our emails.
At the time, we had no way to know it was an attachment to an email.
And at that time, when you had no way of knowing, you, Alan Mizrahi and Lee Hutton made a determination without the use of the taint agent in which we went to great lengths to have assigned this case. That's correct, right?
Correct, because at the time, there was no indication it was an attorney-client communication.
There's no doubt that on that day, she sent them to you because we have the email that I just showed you that it was sent.
Yes, she sent them to me after I sent her this text message.
And you saw the text messages on that day, they weren't in code. You've seen them and you intend on using them as evidence in this case.
Yes.
And the timeline, you said you laid eyeballs on it in your testimony, but then you said you didn't, you never saw it.
I did not view it. I don't know if it's an actual timeline or a list.
So you're the lead prosecutor of a sensational murder case.
I don't know if I'd use the word sensational.
You certainly know that the media is following this case, right?
I do, yes, they're
It's
here right now.
considered a high-profile murder case, and that you are the lead prosecutor. You get a confidential timeline that just may very well be a diary of Mr. Fernandez, every movement. And this timeline does include the day of the homicide. You know that, right?
I don't know that.
You don't know that? So you, as the lead prosecutor in this homicide case, that's been going on and included wiretaps and included federal agents and Secret Service agents and all the people at the Jackson Beach Police Department, all the people at the State Attorney's Office and the FBI, all the people that came, you didn't read the timeline that was considered confidential. You just said no need to read it.
Correct.
You had no reason to believe it was privileged. Why wouldn't you read it? You're a brilliant prosecutor and you are dutiful and do your job. I agree with that. You agree with that, right?
Yes.
You just chose not to read a confidential timeline that was sent to you by the lead agent at the ATF in this case?
Yes, because what she advised me it contained was not germane to the investigation or useful.
As the lead prosecutor, you just took the witness's word for it. You didn't want to even peruse it and make a determination for yourself to see if perhaps you could make use of it as a lawyer and prosecutor versus a law enforcement witness?
No, because the content material had nothing to do with the homicide.
Well, how do you
And the
know
point
that?
of, the point of having an analyst is to assist me in parsing through digital evidence. We have so much.
Why open the text message document?
Because those were, in my opinion, relevant to the homicide.
You can't make an opinion about something you don't read yourself, right?
She was advising me as to the contents.
You did, in fact, have a conversation with me on the 27th.
Yes.
And I documented that in a letter and I sent that to you, correct?
Yes.
And you told me enough in that conversation that it concerned me, right?
Your letter, yes, you expressed concern.
And I was able to know from a very brief conversation outside this courtroom that potentially what I knew was contained in the documents that we were talking about that I had never seen other than from my client. Blindly, I was able to correctly identify the two documents in controversy in that letter, right?
Yes.
And you did respond.
Yes.
I want to break this. Can you see that response?
Yes.
You said thanks, and I assume thanks is a way of saying I received your letter.
Yes.
We had a tape agent remove all attorney communications for both defendants and firm.
Yes.
When you sent this letter, this email to me in Shannon Day, our office, on September 28th, the day after I sent that letter, in June, a taint agent hadn't removed anything at that point, correct?
Correct.
In June, a taint agent hadn't even received the Google return. Correct?
Yes, I know that now.
The discovery that we discussed was not attached to an email, right? Now that's what you believe at the time that you sent me this.
Yes.
But you now know, because you've seen it and it's in evidence, it was in fact attached to an email, correct?
It was attached to an email and it was available on the Google Docs drive, yes.
But you now understand you were wrong. It was attached to an email.
Not the way we received it, is the way I meant it here, but now I know that you had your client email to you.
And you know that had Agent Nazario been able to do his job, he would have removed the attachment. You were sitting in the depot when he said that.
He said that, yes.
And then you said, did not show any attorney names or emails.
Correct.
But again, you can't know that because 3 days after you got the return, your analyst just started looking at it.
And then you can figure out pretty much where
or lawyers were attached to those communications. Fair to say, right?
Ms. Butler told me there were no names, emails, or phone numbers attached to that document, and when I received it, there were not.
Right. Because Agent Butler had started looking at it before Agent Nazario, the taint agent, ever was given the document to make that determination, correct?
Based on her testimony, she began reviewing it in June and specifically did not review the folders that would have contained attorney-client communications.
Because she's looking at it in a vacuum. Agent Nazario is looking at it in a cross-reference, looking at it to cross-reference, different than Agent Butler, right?
Perhaps, yes.
But Agent Butler can't do that until Agent Nazario does his job, right?
I don't know about that, no.
Well, of course, you sit here today and say, I didn't know it was attached to an email. I didn't know it was attached to a lawyer's address.
Correct.
Because you never gave Agent Nazario a chance to do his job, right?
No, that's not true.
It's not true because you just looked at it in a vacuum, right?
I looked at it in the context of where we found it on a return from a search warrant.
But as we sit here today, we know that it was attached to attorneys' names and emails, right?
Yes, in some form it was, in another form it was not.
And it did not contain attorney-client discussion. Again,
Correct.
the judge is now in possession of the discussions about those text messages. So Mr. Mizrahi asked you on direct, did it have any, color, or did it have any context about them? That just wasn't contained within that one document. But you have no idea what was contained in the emails, correct?
Correct, but the document I'm referencing this email is the document that Lindsay Butler sent me that I've already testified about, did not have any of those markings.
Right, but perhaps if you ever had the luxury of looking at the emails that were.
I don't want to look at the emails.
I'm not asking you to, I'm preventing you from. But if I were, and you did, you don't know that possibly what this court knows. What I know is that the client did or could have commented about the document.
Yes, today's hearing, I believe you that these were attached to an email sent to your client you provided in the court. I don't dispute that.
And as it turns out, it sounds like you even agreed that it was created by Mr. Fernandez. You said that.
I believe it was created by an application. It was downloaded from an application. I don't think he wrote it and made it up.
If someone takes something that's not in its original format and puts it in another format, Mr. Fernandez did that. He would have created it, correct?
No, he downloaded it.
How do you know it's all of them? How do you know it's accurate?
I know in general, based on my conversations with Henry Tenen, and I also know from the format that it was in that it's consistent with an application that downloads text messages onto a spreadsheet. I know that it was in UTC, and people don't type things in UTC.
Does it do that by itself, or does someone have to do that?
You have to open the application and click download.
You then say, the taint agent forwarded to us for review. Okay? The taint agent didn't forward that to you for review.
At the time I wrote this email, I didn't know that.
When you wrote this email, it was in September.
Right.
Lindsay Butler sent you the document in June.
Right.
Lindsay Butler is not a taint agent.
Correct. When she asked me about the documents, I thought they had been flagged by the taint agent, and I thought she was bringing it to my attention.
So you were wrong.
Yes, I was incorrect, and I later corrected this in our filings to the court responding to your motion. The actual facts are laid out that Lindsay Butler was the one who found it, and that she brought it to my attention.
So when you told me on that day after I sent that letter, the taint agent sent it to review, you acknowledged that's not what happened.
Correct, and I told you that.
And then you say, based on what he advised, you know Lindsay Butler's a she, so that's just because you thought it was Agent Nazario.
Yes.
And this would be really good if in fact Agent Nazario had sent it to you for review, because he would have determined it wasn't attached to anything.
I don't think there's a difference of who sent it to me. If ultimately it's not privileged, it doesn't matter who flagged it.
That's your determination. The guy
Correct.
who's to make the decision as to what's privileged and not privileged is not the guy that sent it to you.
He was not making any determinations as to privilege and not privilege. He was just deleting attorney-client communications.
But you would address essentially the same things.
No, he's not reading the content and making a legal determination. He's just blindly deleting.
Things that are attached to email.
Correct, and this was not attached to an email.
So there is no way to preserve an attachment that a lawyer sends a client under your theory.
If you put it on letterhead, yes.
Only if we put it on letterhead, that's the only way we can do it?
No, there was nothing about these to indicate they were attorney-client. They weren't labeled in any way.
And according to Mr. Mizrahi, I suppose if we use email that a client that has a Gmail address, we're waiving our privilege in its entirety? Because the CEO of Google could potentially look at my emails? Is that the state's position, Ms. Stifler?
I'm not going to tell you how to do your job.
I'm not asking you, I'm asking your opinion.
My opinion is if your client was going to send you inculpatory evidence, he should have come to your office and handed it to you, sent it in a certified letter, or put it on their head.
So if I find out in this motion that was held in abeyance that you and Mr. Mizrahi used T-Mobile to send text messages to one another, that could be work product, privilege, something that I perhaps no interest in. But if I find out that the CEO of T-Mobile could have accessed it, I assume in this public records request, the state of Florida is going to have no objection because the CEO of a Fortune 500 company may have had access to your text messages?
T-Mobile doesn't have access to people's text messages.
Okay, what about your emails? Does the CEO of Google, the CEO of Google had access to you or Mr. Wingard or Mr. Mizrahi's emails? The state's never going to have an objection because we invited in a third-party provider? Is that the state's position?
If I used my personal Gmail to send evidence or work product to Mr. Mizrahi, I would not expect to be able to claim it as work product. That's why I use my work email. Okay,
so it is your position that because the CEO of a company like Google could in fact look at something, it eviscerates privilege.
I'm not going to go that far. I do think that it's an app issue here. We're serving search warrants on Google, a third party. We're not serving search warrants on your emails personally.
And then you wrote, I determined that nothing would suggest it was privileged at the time.
Yes.
Other than the fact that it was titled confidential.
Correct.
Other than the fact that the agent.
Well, it was titled confidential.
And confidential time.
Yes.
And other than the fact that the agent didn't just send it to you and had concern.
She had concern it was labeled confidential. She's not a lawyer and didn't know that. was a legal distinction.
When I sent you the courtesy email with the draft motion before it was filed, you shut down Next Point that same night?
Yes, as you requested.
Did you just take my word for it?
Yes.
No one checked to see if our emails were actually on there?
No, because we were trying to avoid reading the emails, so I didn't want to send someone to Next Point to open your emails.
And that's
We sent screenshots as well, and they looked to be,
you don't doubt that all of our emails were uploaded to Next.
I'm not disputing that, no. I haven't clicked on them to open them to see if they are there, but you said so, and I take you at your word.
Yeah, one more.
Yes.
Given that the word confidential has appeared in all of these emails, it's been a feature, have you ever, since this time, looked to see what in fact the definition of confidential was?
No.
If I told you that the definition is intended to be kept secret, is that something that
That sounds about right. I think that's sort of what I said earlier.
entrusted with privacy or restricted information?
Correct. But there was other litigation in this case regarding the confidential nature of marital communications, and the court denied your request to stop us from looking at those. Confidential could have meant between he and Ms. Gardner. It could have meant because he didn't want anyone looking at it. It could have meant attorney-client. As you know, as I said, I'm not disputing that it was an attachment to your email. I still think the content makes it non-privileged.
I understand. Thank you.
Regret.
Thank you. Just briefly, I want to clarify something about the Google search warrant they put up there with the paragraph that's highlighted. The emails that it was referencing were not the attorney emails.
No.
So the emails it was referencing were the defendant's email.
Yes, the Zephyr at Gmail.
And so there was no Google search return or Google search warrant done on the attorney's emails.
Oh, no.
I think you said this at the end, but I want to clarify, is even as you sit here today, is the fact that the text messages that were downloaded were emailed to a lawyer, does that make it, in your mind, attorney-client privilege?
No, it does not.
If in the course of your experience, have you heard defendants talking to each other, it said something to the extent of, hey, just between you and me?
Yes.
And would you say that just between you and me is the same as saying confidential?
Not particularly.
Well,
Maybe.
Is it a less sophisticated way of saying confidential?
Yes. It's like writing top secret on your diary.
And during the course of your experience, you have used conversations between, let's say, co-defendants that were intended to be kept secret, but were probative, relevant evidence.
Yes.
And that is what these text messages
Yes, they were intended to be kept secret because they relate to the planning of a homicide.
are. And they were between the defendant and his co-defendant.
Yes.
If the text messages would have been between the defendant and his lawyer, what would your response have been? Probably wouldn't even known that, first of all. Second of all, if they did bring it up to you, what would you have said?
I said absolutely not. Shut it down. Don't look at it. Delete it. It's privileged.
That's all I should have.
Maybe Ms. Steph, step down. Okay, thank you, Ms. Steph.
I just have a minute to confer with it. I don't think we have any other evidence.
Okay,
That's all we have.
all right. How do you all want to handle the arguments with the motion that you recently filed? Do you want to wait, or do you want the one about the text messages?
I mean,
Are you prepared to go forward?
you're talking about the in-camera inspection motion?
Correct.
Yeah, I'm gonna do a public records request tomorrow. That's gonna take months. I mean, I would imagine, I've never gotten a public records request back number one, they're gonna have to receive it. Number two, they're gonna determine how long they think it'll take to gather all that.
Okay.
Then they're gonna ask me for a bill, then I'm gonna submit money, then they're gonna potentially send it to me.
Are you prepared to go forward now with the argument?
Yes, if there's some, I had no expectation the court was gonna give me months to argue, to wait at this point.
All right. Mr. Mizrahi?
I was just waiting to see if you court had a question about it.
All right. I want to hear from the defense. It's your motion.
I just have one moment to.
Sure. Do you want, I can take a brief recess if you need that.
No, come here.
Okay. Where we feel more comfortable.
I feel more comfortable at the podium over here,
Okay.
only because council speaks, which they're, of course they do, but it's hard to focus. This is the argument on the main motion, the swap.
Correct.
Your Honor, what we demonstrated today is prior to our client ever being arrested, I would say is a scenario I'm unaware of this ever even being done. I wasn't so certain that when we brought it to the state's attention that Mr. Cox and I were even going to be able to get a hearing. So there's no case number, there's no court assigned, there's no judge, and that was a distinct possibility. We drafted a motion for protective order and with no case number, and we sent it to the courts and said, can we get a hearing? And the courts obliged and gave us a hearing. And what happened at the hearing is immaterial because we came to an agreement. And that agreement was read to the court today in head note 4. And that agreement was that the state was not going to be in possession of any potential material until it had gone through a taint procedure. The state has agreed that any communications protected by the attorney-client privilege will be removed from the devices by a non-state third party, that's the taint agent or filter agent, prior to downloading. Well, we know from the evidence today that as soon as the Google return came back, 3 days later, chomping at the bits, the analyst in this case downloaded it, had it in her possession, and started going through it. Agent Nazario never had an opportunity to do his job. The agreement on whatever day Ms. Butler received the Google return, which had to be sometime before June 30th, the day we have an email proof that was sent to the state, and 3 days prior, the proof that the Google return is signed by Detective Johns, the actual inventory return, what they got. So we're talking a matter, and this is all in evidence, of a few days. Lindsay Butler knows that a taint agent has been assigned to the case. Detective Johns knows that a taint agent has been assigned to the case, and everybody at the state attorney's office knows that a taint agent has been assigned to the case with the purpose of removing attorney-client privilege. And there's no way in good faith the state attorney's office can stand up here today and say, it's just emails. It's just the content of what's inside the box. When even Ms. Stiffer testified, it's routine. Ironically, before this ever became an issue, almost every time I corresponded with the state attorney's office, I attached an email, a letter. This is the way we communicate. When I send the court documents, I send exhibits as attachments, I send motions as attachments, I send orders, proposed orders, maps, pictures. It's an unlimited imagination of what could be attached to an email. When I gave those letters that were sent 2 times to the state attorney's office with all of our email addresses, it would be one thing if I sent something from my personal email to the client and it didn't get intercepted, and I stood up here whining about how it was inadvertently intercepted. It was Jesse Dreiser at Custodial Law, Shannon Day at Custodial Law, Frank Custoni at Custodial Law. The very nature of what Agent Nazario was going to do was made very clear by the emails, and it was made very clear by his understanding of what his prerogative was, which is to cross-reference and remove privileged communications. And we'll get in. I'll get to what I'm sure the court wants to know from me is why are the text messages privileged? The timeline, there is nothing more privileged than a lawyer and their client coming together after representation has been solidified and the lawyer learning about what's going on prior to what the state alleges is his involvement in a homicide, during the course of the day of when this homicide occurred, after this homicide occurred. This is privilege. And I find it suspect at best that the state attorney takes a stand today and says, I'm the lead investigator, lead prosecutor, heading up all of the lead investigators, from the FBI to the ATF to Secret Service to St. John, Duval County Sheriff's Office and St. Jack Beach Sheriff's Office and all the other cooperating law enforcement. She obviously, Ms. Stiffer, doesn't believe that that document is privileged. The timeline. but she just didn't look at it. It's emailed to her. Look at it, call me immediately. I just took her word for it. I just think there's probably nothing relevant in there. Because they have to. We have to say that at this point. Because if you don't, they're in possession of our attorney-client timeline that we put together with the assistance of our client before, during, and after this homicide. Okay? The state attorney's office, in terms of the communications and the text message, Ms. Day told the court, and the court knows, and I will tell the court, that if they download Henry Tennant's phone and they find text messages between Mr. Fernandez and Mr. Tennant, it's not privileged. Okay? I'm well aware that just because a lawyer gets his hands on something doesn't make it privileged. In this case, Your Honor, I left the jail after visiting Mr. Fernandez one afternoon, and he had given me some letters that I was to review for mitigation purposes to learn about his life and then pass on to his brother. Okay? I got a phone call from Ms. Stifler. Ms. Stifler said, you can't do that. She must have heard through a jail call from him to the brother that I was going to give him a letter. Okay? And she said, I need those letters. You're bypassing the snail mail system where we get a chance to review those letters because they're not privileged. She said, do you have them? I said, yes, I do. I'll scan them to you and I'll send them to you. The court never learned about that. There was no litigation about that. They weren't privileged. They were in my briefcase. They were given to me by Mr. Fernandez, and they just simply weren't privileged. So I clearly understand that you don't just get to bypass what could be damning evidence because you give it to your lawyer. But what I also clearly understand is that if I ask my client to help me create something that doesn't exist anywhere else, that's privilege, and that's work product. There's not a single piece of evidence that exists in this case that those text messages exist. Mr. Tennant can say, yeah, I text messaged with Mr. Fernandez. They could have called Mr. Fernandez or Mr. Tennant, I suppose, to say, yes, those are exactly our text messages. I remember them. They didn't. The evidence that you've been provided is they don't exist anywhere else except for in an email titled titled confidential, because the subject line is confidential, in an attachment that says confidential, which is a typo, an extra O, conversations, and confidential timeline. That's where they exist. This court has had the luxury at the waiver of our client and the lawyer saying, Judge, at one point, Judge Foster, now you can see it. You know that it only exists in one place. From an email from Mario Fernandez, you know what he says in the body of the email about assisting us in the understanding. You know how the timeline got from us to Mr. Fernandez and what Mr. Fernandez intended to help us in anticipation of future litigation. That's contained in the body. The attachments are contained to the body of the email. That's it. Alan Mizrahi or Christina Stifler, if they remain on this case, or any other prosecutor from anywhere else in the state of Florida, kicks the doors open and walks in here holding a download from Henry Tennant's number of phones that he had, or our client's phones that were seized. And they said, we got them. That's it. They're not privileged. No question in my mind. I want the court to know that I clearly understand that's not what we have. That's what they wanted. That's what they hope it is. So they looked at it. They didn't wait for the change procedure. They didn't wait for Agent Zahraa to do it. So they have to say it. It's just text messages that just happen to not exist anywhere else. And even by their own admission, Judge, they come in here and they tell you it was created by Mr. Fernandez. They have evidence that when they went back to try to find it, like it was created through an app. Apps don't create things on their own. Someone has to do that. Someone has to go and take messages that perhaps exist somewhere else. Quite frankly, I don't know why they don't have them. Their theory is so true that they existed somewhere else and then they were created, manifested through an application, then sent to our office. Well, where are they? Well, we think he deleted them. They don't know that. It's not shred. There's not one witness that took a stand and said they were deleted. There was a digital footprint of those messages. The Stifler was like, I don't know, I think they deleted them. That's it. That's the best you got. How does that not work properly? How am I supposed to have my client ever do anything for me if I can't have him make something, create something, assist in our litigation, unless it existed somewhere else in which it simply does not? And Your Honor, why in the world is Mr. Mizrahi, at the time, Lee Hutton or Ms. Stifler, making a privilege determination? when they all know that a tape agent has been assigned. Do you know how easy this was to fix? This isn't inadvertent. This is intentional. I mean, this is what it says. Ms. Hutton and I say no privilege. They're not tape agents. Who are they to make any decision about what is or isn't privileged after the exhaustive efforts that myself, my firm, everyone working at my firm, and the Bedell firm, followed by the Baez firm, took to make sure this couldn't happen? One phone call, one text message, one email that goes this way from Lindsay Butler to Agent Nazario instead of this way, which is Lindsay Butler to the very prosecutor, asking, essentially, or getting word. And I find it curious that she was so concerned, Ms. Butler, her depo is part of the record. She's so concerned that she read them immediately and call me. Read them and call me immediately. It's pretty clear to me. She double checks. So I'm okay to look at it? Okay, yes. She's so concerned that after she is clearly told to do something, she double checks. If they're that concerned, and it's unsolicited from Lindsay Butler to Christina Stifler, why not send it to Agent Nazario? And then it is, or it isn't. The person who's assigned and agreed in an order, footnote 4, to do his job is left blind. And you know, because the transcripts are now part of the record, and I say that, have you read those transcripts, Sean?
Yeah.
So you know that Agent Butler knew about Nazario, and Nazario says that's what I would have done. That was my job. And we said, you can attach it. And that part was read into the record today, that piece of the transcript. Yes, attachments. Never. The system can't work if you don't, if you have an agreement, the system only works when you agree to the agreement. What was the harm? And then, I guess, I'm just Nostradamus, that on September 27th, when Ms. Stifler takes me out in the hallway and says, man, we got this confidential document off. I've never seen it, though. It's not provided to me in discovery. That same day, I'm able to go back to my office and write that letter that was read into the record today, specifically identifying, because I know exactly what I instructed my client to do and when he did it and how to title it, and you know what's in the body about how that exchange occurred. I'm not Nostradamus. I knew exactly what it was. I knew they didn't wait. I knew it didn't go through the team procedure. And that's why I wrote on September 22nd, I have grave concern that law enforcement may have intercepted my client communications. And I'm thinking attachments and communications because I don't see them as separate. Because I know that a team agent is going to do his job and he's going to look and find things that correlate to emails and do exactly what we agreed on. I assume he's done his job on September 27th and they still got it. But what I didn't know, and I would have never known, just so the court's very clear about this point, but for this inadvertent uploading to Next Point, I would have never known about this text message or the email from Lindsay Butler to the state on June 30th. That only came out in discovery after we filed our motion. So not only on September 27th, when I wrote that letter outlining and detailing what had happened outside the schoolroom, that's in the complete dark of knowing that that's exactly what happened. That Lindsay Butler, law enforcement, intercepted the communication and put it right in the hands of the very people we did everything in our power to prevent from happening. I'm sorry, if there's something more that defense lawyers can do to prevent this from happening, I'd love to see it. The day after the devices were seized, we filed a letter saying, give us a moment to file a motion, pre-arrest, get an agreement pre-arrest. Letters with all of our contact information. Oh, what more can a criminal defense lawyer do to preserve? And then we have to come in this courtroom and sit here and learn that perhaps, I don't even believe they believe this, quite frankly, that if you use Gmail, the CEO of Gmail, Mr. Sundar Pichai, I'm engaging in a third-party communication and nothing's privileged. The very nature that they made that argument to the court in that questioning is saying to me and every other criminal defense attorney in the United States that would communicate with a client via a Gmail account or Yahoo account, AOL account, or any other account, that their emails aren't secure. Well, did you encrypt them? What are we, the CIA? I don't even know what that is. I've never done that. I don't know any lawyer that's done that. And encrypting emails is an absurdity, and I challenge the state to send you one piece of case law, one statute, from anywhere in the country, federal or state, that suggests that the lawyer needs to encrypt his email in order to keep the privilege, sanctity. I heard that. I'm fairly certain. The inadvertent upload, they're right. We have no evidence that anybody from the state of law enforcement looked at our emails. But there is no question they access. Undisputed, Lindsay Butler, in the email, he read it, in the deposition, he read it. I said, my understanding, ma'am, if you were walled off, I was walled off. I wouldn't use that word. I'm paraphrasing the depo, not relying on what the depo actually said. That's how I learned. And I said, what do you mean we're walled off? Well, I had access to it, I just didn't look.
Can I ask you a question? What's the prejudice then if they didn't access it?
I can't prove that they looked at it. I don't know how anyone can prove it. There's jump drives going all around. Anyone needed one, you get one, and they showed you one document they put in evidence that said forensic interview with one jump drive on one computer was they didn't look at. They said no one in the state attorney's office. No. Only one person from the state attorney's office testified. You didn't get affidavits from everybody in the state attorney's office and affidavits from everybody in law enforcement. They just said they didn't look at it. And they take things at my word. I'll take their word for it. But they didn't access it. But they did access the document. And that is key prejudice. I know they accessed the document. I know that they read my timeline. Whether the statement says they did or they didn't, Lindsay Butler did, because she told Ms. Stickler what was in it. That's a bare minimum of the evidence. They intend on using our communications, the text messages, they're unwavering in that regard. And how am I supposed to know whether they're going to use the timeline against my client? There's no way. They read it. How am I supposed to know whether they're going to incorporate that into questions or strategy? They have it. It's in their possession. They read it. So what's the prejudice? That's the prejudice.
No, I mean with the
emails, I cannot specifically point to a piece of prejudice because I specifically cannot prove that somebody read something. All I can say is they all had access. With the exception, I'm glad I wrote down my notes, other non-law enforcement, non-state attorney, the inadvertent upload, which should not be ignored. It's just inadvertent upload. Again, going back to all the steps that I took to do that. If you go back to footnote 4 of our agreement, it says it should have never been downloaded. In fact, that's a really important point, Your Honor. It was downloaded onto Detective Johns' computer. It was downloaded onto Lindsay Butler's computer. Somehow, and there's no evidence in this hearing presented by the state as to how that happened. They agreed that it did. So it's on there. That's a violation of the agreement. It was downloaded. It should have never been given to Detective Johns. The return should have come and gone directly to Zaria. Once it's downloaded, we got access. We know it got downloaded in violation of the agreement and then uploaded next. And then Patrick Brody and Jose Baez and Ms. Medina, they downloaded it. Now they have it. Usually problematic. I didn't give it to them. They want to suggest that Mr. Cox and I or Mr. Baez and I had trouble. No, it's trying to prove that we share any privileged information whatsoever. Now,
before I can ask you another question. What do you see the interaction between the agreement that you have with the state of Florida and that breach of agreement that you did on into the court and just the overarching case law that I would have to decide this case? You're arguing breach of agreement, but the agreement in some ways well, the agreement was breached in some ways, just like you said.
I'm back. While mommy was away, did the mice play? Thank you, all my fabulous mods. You are so amazing. I love you so much. Thank you so much. Thank you, everybody, for sticking with us. Yeah, that was not a fun trip to the bank. We had an urgent bank issue I had to deal with, and I apologize so very much, but you guys are so simply amazing. I thank you so much for everything. Agree. It's very, so thank you, mods. I love you. Love you. Back to it.
And then I have to make a determination based on prejudice. What do you see the interactions between those two?
if it was just that I came here, I did reach the agreement, I found out that Detective John downloaded our stuff before the agent Zaria, I would never file a motion. Never.
Oh, why, thank you, Ada.
Oh, well, you're welcome, cell phone.
It's that the agreement was breached and.
Oh, we're chatting.
The state attorney got my communication, my attack. That's, it's not, vacuum of the breach, or a breach would never be sufficient to remove a prosecutor, let alone the entire office. It's that they breached the agreement. And when they breached it in the worst way. They breached it by getting our confidential timeline and our client's work product that are clearly attached to our communication or in possession. So to answer your question specifically, it's not just a breach. The breach is one parcel of my argument, but we know they have the two attachments. We know they had access. It's breach.
Thank you.
And distribution. It's breach and possession. That's the crux of the prejudice. And should we go to the case also? Your Honor, attorney-client privilege, Florida statute 9502(1)(c) is a communication between a lawyer and a client, and it's quote confidential. Ironically, that word appears in the very first sentence of Florida statute. The very word, the very.
Thank you, Flash Fan.
Every email, including the two attachments that you're aware of, we're titling this up. If it is not intended to be closed to third persons, no evidence is intended to be closed to anybody. To those who disclose in furtherance of the rendition of legal services to the client, so there's evidence that's exactly what this is for on this day, and those reasonably necessary for transmission of communication. Florida statute section 95022 says a client has a privilege to refuse to disclose and to prevent any other person from disclosing the content of confidential communications when such other person learned the communications because they were made in the rendition of legal services. Exactly how it happened. No confusion or exception. In absolute activist value master funds limited, the Divine 262 Federal Supplement 3D 1312, it's a Middle District Florida case in 2017. I gave you and state conference all in this case. Holding that the attorney-client communications were intended to be confidential, for the client created 7 documents in question and emailed them to her attorney using the subject line private and confidential. The state kept reiterating in their testimony, there was nothing.
Okay, guys, we do have the pre-trial. It's on. It's been on for about 15 minutes, so we're going to convert over to the pre-trial. This is what we've been waiting for. So we're going to move over there for just a minute. We're going to do this, and then we'll come back. So right now we are at 16 hours, 23 minutes, and 29 seconds. But we're going to come over here, and we're going to go into the a defendant says Jared Redrum Cape for pre-trial hearing. Is this the one we were waiting on, I believe? I don't know. We'll find out. I don't like this style of video. I really don't.
Jury pool, okay? Meaning that you all can just start your questioning. I think you will see that,
obviously,
generally speaking, it doesn't necessarily take that long to get down to that usable pool, but you need the numbers in order to get down. And my thought is a usable pool would be probably about 150 people, but you've got to get through / get people that can do it, and just listen, not about the facts, but that's why I'm saying 250 per. So I'm thinking, in Mr. Fernandez's case, you maybe will have out of that 250, you might have about 100 people say, I can't do it. Right now you're down to 150.
Too much.
Miss Gardner's case, you have about 150 that can't do it. Now, then you give those people the questionnaires. It doesn't make any sense necessarily to give out questionnaires of people that logistically, hardship, whatever, can't do it. So sending it out to a large jury pool doesn't, in my mind, use the time wisely, because let's say the person can be fair through the questionnaire, but they logistically can't do it. My thought is you summon more, 250 per, we handle hardships, potential cause challenges, then we start the questionnaire, whatever y'all might want to do. Then we know, then we have to have a day to process the questionnaires, right? Y'all have to have time to read them. And then we can have, like, whether we're going to put them in the usable pool. Then you're using your time wisely. Sending out a bunch of papers to people that logistically can't do it That's not doing anything for y'all. But I'm not even saying, I mean, the questionnaire really has to be not really anything. To me, the best user friendly thing to do is about publicity, like, and then the questioning. Some questions you may want to know by questionnaire, but generally speaking, lawyers want to see and interact with the people before they just accept something written on a piece of paper. And the clerk's office also processes the hardships as well. You'll have people with medical issues that get the summons, all of those things. So the 250 is building in that portion of it as well. That we'd have to go down there and try to make sure that people didn't have a medical issue that would be a cause challenge, a hardship issue. I mean, it's just a number of things. It's all the 250. I know sounds like a huge number, but really it will get you down to the number that hopefully will be jurors that y'all can question and that can actually serve.
You know, or does the clerk in the courtroom know that out of 250, what percentage show up?
And there's no captioning. Let me get my live
Mr. Hathaway, do
captioning.
you know?
I can inquire.
Get on the
They
mic.
come in way more than that. We get good response. The times that I've gone down to qualify, the entire jury assembly room is full. There are some weeks that we don't get good response.
I was just thinking, as you're talking, I'm thinking of new thing, 250 per. Is that taking in? That's what you want. That's what you're.
Why do we not? Okay.
Best. Are we taking into consideration the idea that?
No, they're
I'm going to
summon.
read it to
So
you.
if I say 250 people, right, they're going to summon way more than that because they have that number built in. Correct. So, for example, any given week in Duval County, there are 8 felony judges. We all have trials. We all generally want, let's say, 40 jurors. And so you multiply that by 8. They summon way more than that to get to those numbers that we would need for a jury panel. I'm trying to get y'all down to a usable panel that y'all can question. And
yes.
So when I say 250, I'm saying 250 so we can start the hardship part of it. And, okay.
A quick update for the court regarding.
A quick update for the court regarding discovery matters. I have provided today this to both the defense teams is updating the newest disclosures of discovery inventory, and I have given them paper copies. The state disclosures 89 and 10, whatever, will file after today's hearing in the motion. I also received an update from Detective Padilla that the Secret Service and the JSO Computer Forensic Investigation Unit, he was able to confirm the hash values on the devices and obtained a raw data requested by the defendant's gardeners. And I get it. I believe the defendant Fernandez also requested that they have been placed in hard drives, and the state defense team will have identical copies of all extractions and devices as the raw data, all devices absent. I think there are some devices belonging to the deceased victims where the raw data was damaged, but they have those. I know it's already on the way. Ms. Gardner's forensic expert detective has reached out to Ms. Day about obtaining a new hard drive and getting them that information. So that has been filed, those requests by the defense counsel, and the court should have received an email from Mr. Geyer. There's been some difficulties he's been having with copy the redacted version of Mr. Fernandez's Google returns and Mrs. Gardner's iCloud returns. They have resolved those complications. He's out of town. He is in receipt of the evidence I will be sending the redacted copies. He should be able to overcome the technical difficulties. We should be able to have a receipt in those shortly. I did get those. So there is a discovery update as far as from being the state's perspective.
So,
we have no further matters to bring before the court.
Unless there's anything y'all want to be heard on.
Okay, I hope y'all allow. I couldn't hear any of it, so I read it for you. My captioning's getting it. No, I don't have anything, Your
There
Honor.
was I did the notice of hearing on the motions for protective order. There has been no motion by the media to intervene. So I don't believe the state has any objection, correct?
I have no position.
I have no position. I don't believe the state necessarily a party to this action. I did note that Mr. Something's, this is in motion under paragraph 9. He's requesting the court.
Wait.
The
I'm not-
dissemination,
I have
disclosure, and the materials are seeking. Wait. I'm not. Hold on. I have Mr. Fernandez pulled up. In paragraph 9, second bullet point. Prohibiting dissemination of disclosure outside the state attorney's office. I would just like to clarify the request that the court is initiating an order. I don't believe that the court can, or if you can, I would ask you don't. There's no reason for the state attorney's office might need to disseminate or disclose information contained within those materials outside of our office and defense team. Specifically, hypothetically, perhaps maybe we want to speak to additional search warrants and need to put it in the body of each search warrant in its present judge, our law enforcement partners to further investigate, or to any individuals with mercy laws rights related to some of these items. And as Mr. Drescher and I spoke about this, his motion is specific that I would just ask the same defendant Garner's motion to the state not to be prohibited from disclosing it for necessary reasons. Further, the prosecution investigation of the case, I have no objections. I have no position on the public disclosure. As far as they're seeking, I don't know. We think we have any problems, no intended
So when I was
dissemination
speaking, I
on
was
these outside the
assuming you were
purpose of the
talking about
production of the
public
case.
records request as date. Were you trying to prohibit something else?
No, Your Honor, it was that, and obviously we would agree.
Well, I didn't know.
The state attorney's office and its agents.
Its agents, the state attorney's office and its agents. I'm trying to read captioning. As well as we explicitly recognize that they can use the information.
And I'm not saying that was their effort. I just want to make sure.
And I'm not saying that it was their effort. I just want to make sure it's clear that when you're on our issues, the order. Sorry, Matt, I'm having to read the captioning because I can't hear court. You are amazing. You're amazing. Thank you. My semi-lunch.
So, in order for, since the state takes no position, I've got to make sure that I'm complying with the law.
Have a good night out and about with Diane. Love you. Be quiet.
Narrowly tailored. Also, the time frame, and when the parties believe, I guess maybe the prejudice would kind of be alleviated, which I'm assuming would be the beginning of the jury selection process.
So, Your Honor, in my motion, paragraph 9, I explicitly say that you're asking that.
The line explicitly says you are asking Nick the prospective order remain in effect until the jury begins deliberating, and any penalty they issue one.
Can you send me, part of it is that I've got to make sure as well that it's narrowly tailored to make sure. So I don't even know what any of this is. So
I have it here on disk.
what I'd like for you to do, I appreciate that. I don't, because we're not having here, I don't know kind of what it is. And I want to see kind of where you believe the court's order should, so if you could submit maybe a proposed order also with the materials, that would help me do the appropriate analysis, but there has been no intervention. So I'll go forward with going through the analysis and drafting an order. Is it Mr. Fernandez team, do you?
I agree with everything.
If you, a synopsis.
And the materials, what do you think the actual materials, a synopsis would be better?
Materials.
I do think I think what you need.
But I would like to see what you all think the order should look like from the defense perspective. The state isn't really taking any position. So if you, that would help me with the analysis. Do you have the materials or no? Mr. Dry? Or is it, do y'all have it or no?
No. She's out. I cannot get this to court counsel after the hearing.
Yes. Thank
I
you.
cannot get this to the court counsel after to hear. Thank you. No. I will drop it off to the 7th floor,
Thank you.
formatted by the end of day.
So on those two motions, Mr. Hathaway, I will do the ruling at the next court date. That hasn't been set yet. So I'll take those motions under advisement. The court will conduct an in-camera review of the materials. All right. Then we have the motion to compel.
There's a motion to compel production of co-defendant jail communications and inmate mail, not specific.
Is a motion to compel the conjunction inmate mail not be specific to. The state has been very cooperative getting us that material. I think what we're really asking, because I assume you say it's been continued as they receive, it gives us copies of the routine working, and it's nearly more today. That's if we send you a proposed order until the trial that these things were something jail and say, well, we didn't. They didn't ask time waste, so we shorten the loop. It's kind of cut up. We're not compelling anything today. They're not already willing to give us. We just really want to be able to preserve the evidence.
Okay. Is there a preservation issue where he is?
We have provided everything that we have for.
No, I
We have
mean,
provided everything that we have
timeframe.
for no, I mean, that's a waste of, that's what the time, with it, we provide everything have within time frame. I'm not sure what the time frame is for the Nassau County Jail, but my routinely ordered is requesting, I'm asking the disc this morning with some updated calls and reports. So we are providing these, and we've been doing so and will continue to do so. There wasn't a motion to compel from the last different defendant Garner. There are some missing calls that we just don't have because we didn't preserve or order them. He's been in custody several years. We provided everything that we have. I do know that both of our offices in defense and public records requests of Jackson Sheriff's Office, we are all in receipt of the same. Jail calls and jail mail, there's a gap in which we all have, but the state is not possession of anything further than we already have solely because we are not previously preserving, monitoring, receiving over time. I have a supplemental disclosure all file, which specifically lists all the date ranges and the states in possession. And then once they have that, cross-reference it to the public records request and file an motion we want to compel. My response is going to be to the court that we have willing to give everything we have. There's something we don't have because of retention issues. We didn't necessarily order jail calls
So
every week
I'm more
in the
familiar
past
with,
3 years.
JSO. I've entered
God, that's hard.
orders for JSO to preserve before. Maybe that would be a better, because go ahead.
Nassau County Jail.
Maybe
That's what I'm saying. Like
Nassau County Jail.
I have entered orders where JSO for this particular inmate, preserve, do not destroy orders. Maybe that would be a more appropriate, because if they're getting it over, I don't see any reason to grant a motion to compel. So at this point, I would deny it, but I would sign an order of preservation directed at the Nassau County Sheriff's Office. What's wrong with that, Mr. Dreiser?
Nothing's wrong with that. I'm creating a problem that doesn't exist. So
I just think that create a problem. What's wrong with Mr. Dreiser? Nothing wrong with that. I'm just creating a problem that doesn't exist. So I don't think that makes more sense. Obviously, I received them from Nassau County Jail through their choices. They're not ability to verify preserving, and they're because I don't, not the custodian, not in control. The better solution, the problem doesn't exist. Mr. Driver is now created.
No information. I need to know how long they would normally.
I can get that information and provide it to court and counsel, because I know at Jacksonville Sheriff's Office, it's something like.
Why don't y'all call up there and just do a consent order? I don't.
Okay, is my reading over her helping y'all or no? I don't want to drive y'all crazy. Does it help? Yes or no? I'll wait for a minute. Yes, they are the two largest harbors. So right now we are in 16 hours, 42 minutes, and 31 seconds into deliberation. We still have no verdict in the Ali Ali trial. It does help. Okay, I'll keep going.
I don't think the state's objecting to it and say, you know.
we learned that Duval County under 20.
We learned that Duval County under 20. And so I guess this is all being done with the understanding that the state is going to continue to request that. Data is going to continue to disclose that to us, because if it's not happening, then the jail requires us to have a quota of how to get chair calls ourselves. I'm sorry. It is assuming we're operating under an agreement reservation order.
I'll have my paralegal who's been requesting and receiving these items.
I'll have my paralegal who's been requesting and receiving these items to ask Nassau County Jail for their reception policy, and I will consent to order for your honor. We'll have it served on them.
And they're willing to comply too, so this shouldn't be.
And they're willing to comply. That shouldn't be a problem.
Well, I just want to make sure. So it needs to be specific to whatever you all have already been, I guess, exchanging, right? Is it calls or video? What is the method of communication? Calls, videos?
They have access to tablet calls, tablet messages,
Okay.
and regular.
They all have access to
So whatever
tablet
you
calls,
all
tablet,
have already
regular
been
messages.
agreeing to, if the order would please specify those things. And then the reason why I'm asking for the retention is because let's say they retain for 90 days, that the order would say something to the effect of, you know, the court directs the sheriff's office to preserve beyond the normal, whatever their normal retention rates are, and, you know, do not destroy. And then you all are going to request them. So.
Thank you, Flash fan.
But I don't want to just enter something generic. I want to make sure that they know that they need to preserve it beyond whatever their normal retention would be.
Yes, Your Honor.
Yes, Your Honor.
Was there anything else?
Nothing from the state.
Nothing from the state. Nothing further for Fernandez.
When do you all think would be, I guess, a good time to, have there been any discussions about any need for the court's time on evidentiary motions or anything like that?
Judge, we're still in the discovery phase.
How far are you into that process?
Well, we completed
It's too soft to pick up. We completed a substantial number of them. That's all it picked up. It's too soft. There was a significant amount of new discovery provided in the last couple of months, including
You're obviously in the process of working through that. And then I think we'll pick up the speed again this fall.
picked up the speed again this fall. Okay. It's very soft.
Has the defense, actually, I'll table that question. All right, when y'all want to come back?
Wow, usually the judge will tell them when to
Mr.
come back.
Craig, that, Ms. Stifler mentioned the hash values and the expert. Is that any issue at all?
No, I believe that the state is facilitating that.
Okay.
I believe the state has been facilitating that, okay? Expert witness, which has greatly been streamlining the game.
So your expert has access to whatever
He hasn't gotten the drive yet, but
he will.
they can talk with each other.
Has the state concluded your listing of like experts or anything, everything like that?
We're waiting on some outstanding DNA reports, so that might.
We're waiting for the DNA report, so that might change, but for the most part, most of our experts have been listed, so I can't foresee. We won't have a list more something developed in the near future. Generally conclude the list of all of our witnesses and evidence, but as best as we can, but they have discovery inventory now. I can't foresee any major developments, but I obviously can't predict the future either.
Last thing about discovery, I want to make sure is that, so I guess fall timeframe, I'm assuming y'all are saying like maybe September, some mid-September,
Mid-September.
right?
That's agreeable to the state judge.
That's agreeable to the state judge.
Did y'all discuss a date?
We did not, Your Honor.
We did not, Your Honor.
September, the last week in September.
Other than that, the first week in September, the last week in September, I'm fairly open. Ha! Second and third, you're open weeks. For the defense counsel,
Okay,
the week of the 15th.
give me a date.
Give me a date.
You're gonna, that's the Renfro trial. Aren't you doing that?
That's TBD, but we could do that if you're available Friday the 19th in the morning. I have an afternoon.
9 a.m.
19th.
September 19th, 9 a.m.
Yes.
So dry, so you're not saying anything? Okay. All right, thank you. That'll be the next.
I've been in contact with jury services and they have a contingency plan in place to ensure that the days you desire prospective jurors, they will have that many downstairs for selection.
They are incredible. They are incredible people. Tell them I said thank you. My thought is when we get a little bit closer, I don't want to overwhelm court administration, the clerk's office. My thought is that number would be summoned kind of maybe a Monday, a Tuesday, a Wednesday, and we go through that process, and then we decide that, let's say Wednesday, we get down hopefully to that panel. Those are long days, lots of talking to a lot of people, but
So I'm a little lost because when I read like that, I don't retain. Are they looking for jury selection? Is that what they're looking at in September, or is this a pretrial in September?
But that number, it wouldn't be like all one day. It would be tiered over a number of days. And so that we can get through the process of talking and rescheduling. And if we do that, generally speaking, the citizens are appreciative of it. I did it on a smaller scale in another case. It worked really well. We just kind of cycled through, and the people that said that they could gave them a report date a few days out, and then we just kept doing that, and we got to a usable panel. So, but anyway, the next court date will be, what did I say, the 19th?
Yes, sir.
Okay, September 19th, 9 a.m., and that will be for pretrial on both cases. Thank you all very much. Let me see the lawyers. Not yet. Not yet. We'll just have the jury selection.
So this is pretrial.
Oh, why, thank you, Ada.
I'm putting it on the calendar as we speak. So mods, the pretrial is set. I got it there. Woohoo! I love it when I can be efficient. Not always, but I'm being efficient surprisingly. Is that the end? Okay, that'd be it. That'd be all she wrote, y'all. I'm just moving this trail over here. I'm deleting. We're going to come back over here. Let's take a little bit of a breather. I'm sorry, I kind of ran in like a wrecking ball. Ran in like, oh, Frankie Leroy, thank you. Oh my God, you were so kind and you were such a blessing. Thank you so much. For those of you who are new, thank you so much for joining. I'm AdaKay with AdaKay Media. I am a deaf courtroom commentator. Yeah, that's not that is not a normal. I found an article earlier. The judge said in the civil suit he has paused that case until the conclusion of this one. That is normal. I'm not surprised at that at all, to say the least. That sounds like a whole bucket of fun. Anyway, so yay.
Oh, why, thank you,
So
Ada.
we're going to go back in here. I was not able to hear anything, so I'm anxious to hear what's going on. Anybody want to give me a quick recap as to what's happened while I was gone? That would be fabulous, but not necessary. Not necessary. Oh, okay, Junie Boone. Oh, that would be great, Flash Fan 85. Thank you so much. Well, I'm talking about this hearing here. Okay, let's get in here. Let me know if this is loud or is it just me?
That it was private confidential. Yes, it was. It was on the email.
Maybe my hearing aid. People, oh, by the way, I'm going to say this. People think that when I say loud, that means I'm actually hearing it better. No, it's just a lot of vibration and discomfort on my ears when it's loud like that. So that's why I'm kind of like, yeah, we need to not go that loud. Loud is not always as clearer. That's one thing I try to explain to people.
Email address. You know that. I know that. They now know that because of the even redacted copies show that. Documents you question when they're titled that way. Attachments are part of the email line. That case is in Hagen's, the Gatorland Kubota AUDOTA, 45 Southern 3rd 73, First District Court of Appeals case, holding that intake documents prepared by a claimant's attorney, which memorialize a claimant's communication made for the purpose of obtaining legal services, are protected by the attorney-client privilege. And the Ford Paul Edwards 997 Southern 2nd 1140 case says the holding of the work product privilege protects quote, materials prepared in anticipation of litigation by or for a party or its representative. And the privilege extends to attorney's selection and facts and information that the attorney considers important in the case. This day, told the court that those text messages were prepared in anticipation by the client or our office in anticipation of future litigation. There was no evidence. Was this information confidential?
Oh, why, thank you, Ada.
Sony Dresser, no. Email between Mario Fernandez and his attorneys. Subject lines were all confidential. Documents were titled confidential or confidential, the extra O. An essay, Nazario would have deemed attachments privileged and removed them. No evidence to the contrary, that's not true. Second prong is refuse to disclose, or I would call it, more simple language, measures to protect. On 2/7, we sent a letter to Christina Stifler. On 2/7, we filed a motion for protection. On 2/8, we sent another letter to Ms. Stifler. On 2/17, we filed a hearing on motion for protection for order. On 9/27, I sent a letter to Ms. Stifler telling my greatest concern. On 11/15, I filed a motion to qualify request to shut down our next point platform. In Florida, courts have consistently held a prosecutor must be disqualified from prosecuting a defendant. The prosecutor has retained the defendant's privileged attorney-client communications, and expresses their intent to use such information against the defendant at trial. We've established both of those problems. That's Reeves v. State 574, Southern 2nd, 105. It's not that complicated. And before I go to disqualifying the prosecuting attorney in the office, could you skip 2 slides ahead, please, Michelle? 3 slides.
That actually does sound quite good. Cream cheese, little dill.
Your Honor, disqualification is a prophylactic remedy for likely future prejudice. It's not a punishment route of past wrongdoing. We're not trying to punish the state. This is the very beginning of this case. Not a single deposition has been taken. There's absolutely, the state of Florida intends to kill Mr. Fernandez. They made that real clear when they came in here and announced their intent to seek death. If you disqualify Ms. Stifler, or Ms. Stifler and Strachan, and Mr. Wingard of the inner circle, whatever this court chooses to do,
Tinkatu, do you need to discipline your Leroy?
whoever takes the case over, I expect that they're going to try to kill Mr. Fernandez. This doesn't get him anything other than the idea that he's not prejudiced and that he has a fair trial from prosecutors who didn't inadvertently or intentionally view attorney-client information. Doesn't punish him. Another prosecutor's going to come in here, and they're going to be very good, and they're going to put on, I'm sure, all of the same witnesses and use all the same law enforcement divisions and agencies to put together a case to try to kill Mr. Fernandez. All this is really done over the last December to today's date is it's been an unbelievable delay and an unbelievable expense to build out Mr. Fernandez on an issue that we did not want. We tried to prevent, and it doesn't get us anywhere. Nowhere in my motion do I ask for this case to be dismissed. I just asked for a fresh start for the prosecutor and to look it out. It's a prophylactic measure, not to punish past wrongdoing, protect future. In Florida courts, the Martinez case, 4 Southern 3rd 712, affirming the disqualification of the prosecuting attorney who listened to attorney-client privilege telephone calls and expressed intent to use such calls against the defendant. It's not the exact same facts of this case, but it's certainly similar. 2 documents, they saw them, they intend on using them. Disqualification. In the Reeves case, and I've already 574 Southern 2nd 105, where a prosecutor had previously represented the defendant and used purpose communication against the defendant in the penalty phase of first-degree murder prosecution, the appellate court reversed and granted his conviction. I'm never going to find a case with the exact same facts. The principles all apply. You get something that's privileged, you use it against the client, and you announce that you intend to, we're all coming back to on a first-degree death penalty.
Can I ask you in the Martinez case, So with the jail calls, the court held an evidentiary hearing, and you've asked for the entire Fourth Circuit to be disqualified.
I get that.
She doesn't even look old enough to be a judge. Are you kidding me? Sorry about that. Let me get that back up. She doesn't even look old enough to be a judge. What?
And you've asked for the entire Fourth Circuit to be disqualified.
I get to that analysis later.
You do? Okay, well, I'll wait.
Facts in this case supporting the disqualification of just prosecuting attorney. The search warrant.
He looks like a baby.
The Google returned to ATF before it was sent to the review. The 6:30 text message, the 6:30 2023 text message from Lindsay Butler to Christina Stifler, the email from Lindsay Butler the same day, the conversation letter from 9/27, and again, has already removed it, expressed to use this against Mr. Fernandez. Almost every single pretrial and in January they announced that. It's a conversation for product, and in the response on 9/28, they act, which is a response to my letter, they act as though they went through the same procedure, they did everything properly. Thanks, received, but you're wrong. We sent everything through the chain agent. No, you didn't. I mean, if you look at that email, John, it says thanks, but we sent everything through the chain agent. He reviewed everything, determined it wasn't privileged. Today the testimony is, I just got that wrong. When I sent that to you, I just got it wrong. It's just wrong. It was never sent to the chain agent. It was never sent to the chain agent to the state attorney's office. It was sent to Lindsay Butler, and now they can only say everything I wrote you. Well, I told you in your response to disqualify my office that I was wrong. Well, it took that to tell me I was wrong. When did they know it was wrong? I never got anything prior to filing a motion to disqualify the office to say, I got this entirely wrong. It was never sent through. Your letter is well received. You should have had concern. You never went through a team. There's no question, and it's so unfortunate, Ms. Stifler not prosecute this case anymore in the law and the facts of this case. Now, the disqualification of the entire state attorney's office is different. Where the disqualifying attorney either, and it's either, provides prejudicial information relating to the pending criminal charge, or personally assists in any capacity in the prosecution of the charge. Disqualification of the entire state attorney's office is perfect.
Yeah.
597, Southern Second, 259, 261. So that's in 4. Well, did Ms. Stifler provide prejudicial information relating to the pending criminal charge? Yes, Lindsay Butler provided to Ms. Stifler. Ms. Stifler intended on using it. And she has personally assisted in many capacities, let alone any capacity, the prosecution of the charge. Under either prong, the entire office would be disqualified. And in this particular case, I don't have to guess whether Ms. Stifler held this information to the chest, and it's possible that she didn't share it with anyone, because I have a text message about this very document, that she discussed it with Alan Rod, that she discussed it and made a privilege determination with Lee Hutt, the Assistant Chief of the Office, now the Honorable female, and herself. That's not a text message like, I can't really relate to this regarding. You would have to find that, and you can find multiple prosecutors can be removed in the state attorney's office case. But at a minimum, if you find that we haven't met our burden to remove the fourth judicial circuit, we are asking you to remove it.
Okay, Kristen, thanks for joining. We are currently watching the hearing. It's an old hearing, but we are getting up to date on the Riggin case murder. This is the case from the Stampin' Up heiress who unalived her ex-husband in front of his, not her, 2-year-old daughter over the custody battle of their twins. Kind of like another Adelson versus Karen Reed.
Ms. Rahi, Alan Rahi, Christina Stifler, and Mr. Wingard, because, as a testimony you heard, at almost every meeting,
While we're in verdict watch.
they've been on the email. It's almost as if they act as one. I mean, it's a round table. Many times when Ms. Stifler calls me, Mr. Rahi calls me, and Mr. Rahi calls me, Ms. Stifler calls me. Not unlike my office. I'm oftentimes Mr. Hill, or Ms. Day, or Mr. Stone, now we're all 4 on the call together. But they are operating in concert, and that's evidenced by the text message where they made a decision together.
text messages prior to the document being disclosed, correct, by minutes?
45 minutes. In the Martinez case, the court ruled affirming the trial court's ruling that, quote, the lesser sanction of disqualification of individual prosecutors would not suffice because the recordings were heard by a number of attorneys and the contents were discussed throughout the state attorney's office. I don't know anyone who never really proved it. You know better than anyone. You were there far longer probably than anyone in the court was supposed to. Yes, I thought Frank is sooner than that. I meant that table. But it was discussed. It was roundtable. We know that from the text. We know that from the meetings in the state testified to. We know that from their own admission. I mean, Mr. Wright has said that he has never looked at the document, both of them. But he wrote the response to the state. He handled the hearing for disqualification. I don't know how we could find, again, in a vacuum that Mr. Wright was somehow insulated to the state's strategy how to prosecute this case. In the Popjoy v. State 597, Southern 2nd, 335, the holding disqualification of the entire prosecutor's office required for the state attorney who previously represented the defendant to be employed by the state attorney's office. I would submit the principles and the case law are the same in that case. Absolutely. We did enter evidence that 25 people or more had access to the exploit and all our emails. You heard from one witness who said that she didn't look at it. We know the emails were downloaded by Ms. Medina, we know emails were read by Mr. Carodi, and we know that, and actually I don't think we know this, so I'm going to strike, I'm not entering this evidence. And we know that even after we filed the motion, Agent or Detective Johns had access to all of our emails and the attachments because we simply went over their account. We believe in, we would testimony that Ms. Stifler participated in every facet of this case. Mr. Wright substantially participated, and then he wrote the state's response. He's actively participated in attending the majority of pre-trial hearings since the filing of the motion, and or attended the majority, he was included in at least 20 emails regarding discovery. He attended several meetings between the state and defense counsel, and he participated via that text message and the very nature of the determinations for the document. And Mr. Wingard,
Now I need to start another one.
been included in over 20 emails. He's been in many of the meetings, and he was a point of contact with our office for coordinating transfer discovery through the next one.
It's not fully done. Got more to do.
That would conclude our argument. We would ask to grant our motion to disqualify the judicial circuit, and the court's not inclined to believe that we met that burden. We would ask you at a bare minimum to believe that that there could be lawyers within the office that have not participated with no evidence that were in that inner circle and move as a prophylactic measure, not a punishment, the Stifler, Mr. McBride, and Mr. Thank you.
Thank you.
So I do a single thread pattern, a single thread, but I go through them twice. Now I'm going to go round it to clean up the edges, and I need to do a double thread, which is 2 threads, 1 in each hand. It's very hard, so I'm going to wait and do that when I'm not live. So she's 47. She looks like she's all of 15.
Basically the remedy that the court is going to go with for the violation that found.
Are you kidding me? It's that bad?
It's not specifically detailed, but it seems like that court had some idea of how kind of far-reaching a breach, if there is one.
This sounds sucks.
That's where I'm struggling. Mr. Dreiser argues access, but the state and Mr. Dreiser both say, I guess, the state has not viewed that. We have these 2 documents that are an issue that the state admits, at least one viewed / you're going to try to move it into evidence. I need to know how far-reaching this is, and I haven't gotten a sense of that from the state.
Well, first of all, it's not our obligation. This is a defense motion and a defense burden to establish an attorney-client privilege when it's violated, and what the level of that violation is, and how.
What is it?
I can't do anything else. I'm 100% gained. I'm getting frustrated.
All right, sorry.
This is their burden. We don't have to establish that no one saw it or didn't see it. This is their burden, and they presented what they presented, because that's all they would be able to show. The concept of us calling every single assistant state attorney into the courtroom to say, I didn't see it, I didn't see it, I didn't see it, is ludicrous. It's ludicrous. They have the burden of establishing what, one, that this was privileged, and two, that there was some piercing beyond one person that saw. This is their job. In Martinez, it's very important the court actually reads these cases. They read it. The little snippets that you see are not the holdings. Martinez holding was all about whether or not this was an extraordinary writ, and whether or not Martinez court has jurisdiction to go back and look at what the state court did. That's why it wasn't analyzed in the motive. This wasn't about attorney-client privilege. The holding of Martinez is that we do not have jurisdiction to determine whether or not the court was wrong. Oh, and by the way, in looking at that, it looks like the court was wrong. That's the holding of Martinez, where a prosecutor intentionally knew a conversation was going on between a client and his lawyer and listened to it. And that's what they're talking about, Martinez. It's so far removed from what we have here that it's shocking. No good deed goes unpunished. They have conceded, the emails were never looked. Should the emails have been in that folder and uploaded to a brand new Nextel Discovery cloud? No, of course not. That should not have happened. But we're dealing with, and I don't know if the court gets terabytes and terabytes of information. It is so voluminous, and we're trying to help the defense and being able to sift through this vast evidence so they can always have access to it. This isn't turning over a notebook or a pile of papers. It's just turning over stuff that crashes computers. And so the whole concept of this Nextel is a unique thing that our office has never done to try to give the defense access easily, quickly, and because of the voluminous nature, and because we uploaded it, without labeling what it was, because by the way, we had to keep everything, despite what the defense argues, because that would,
if you know that reference, you're old.
Then disturb what we download. You delete things, and then they disappear, and it disturbs what was originally taken off of the cloud and off of the devices. So you have to keep them. So of course, we shouldn't have access to them. We shouldn't have been uploaded to the next one. We can see that point that there is no prejudice whatsoever. There's nobody there. Of course, you have the emails, and the emails have. That's why we want the court to read the emails, because emails may not even be prejudicial, even if they were read. But we don't know that because we have never read. The violation of the agreement and the challenge for Mr. Dreiser go hand in hand. Mr. Dreiser challenged the state to say about, I can't remember the entirety of the argument, but something to the effect that it was ludicrous to believe that Google is able to pierce the attorney-client privilege. The items that we're talking about, the two documents, were not in the phones that were seized pursuant and searched pursuant to the agreement. The agreement was with regard to the client's phone, which has a much greater expectation of privacy, which has a much greater expectation that he may be using that to communicate with his lawyer. And we were very careful not to invade that attorney-client privilege by going through voicemails or text messages or emails on those devices with regard to the lawyer. The search warrant was done to Google, a third party. And even with that search warrant onto a third party, we were very careful not to look at things that had any indication that they were attorney-client privilege. And you heard Ms. Stifler's testimony that when you look at the Google Drive, there is a folder for emails and a folder for email attachments. When you download from all these fancy programs, what we received from Google, not from the defendant, and what we received from Google, we downloaded. And we did not find this document in either one of these documents in any attached email or email because we never looked for it. This was saved on a Google Drive. It was a Google Doc that was saved on a Google Doc. It was saved in a Google Drive, which gave no appearance of any type of privilege whatsoever other than the label that this was confidential. The defense attorneys knew these things were set, and they could have told us, by the way, we told him to send all these attachments to us. And you can't, anything that you may find as a document potentially could be attorney-client privilege. That was never made aware to us in any way, shape, or form. And the letter requests were only emails and phone numbers. We scrupulously did not look at those things that we agreed to do. And because we found, and then There's the signs used to be in this court, professionalism and civility, nothing less than tolerant. I am not going to respond to personal attacks. And somehow a member of our bar accused the assistant state attorney of perjury, essentially is what he did, by saying things are suspect or best, and I find it hard to believe. Now, I will respond to his argument, whereby he made the argument to this court as an officer of the court and said that text messages, you've seen them, I have, you have, with UTC times and conversations that are very, very clearly the downloaded conversation between this defendant and his co-defendant, that those are somehow attorney-client work product because they don't exist anywhere else. They don't exist anywhere else because the defendant tampered with evidence and deleted those. And I'm not going to make the accusation that the defense attorney is told to do that and an email to him to claim privilege. I believe in professionalism and civility. And I have no evidence to support that. But that is the thing they're trying to disqualify us for. Clear downloaded text messages from the defendant to his co-defendant. There is nothing about attorney-client privilege in that in any way, shape, or form. You cannot email evidence, send evidence to your lawyer, and then claim privilege. Even if you do some form of download to a particular kind of evidence and then delete the original. It's not the way the law works. It's not the spirit of the law. And there's cases that we have cited in our response to specifically address that. And I know that you have them. And it's Ginny versus Air Data Women, 846 on the second, 644. And then there's one more. It's Tober v. Sanchez. I know the court would have those specifically indicate those cases that just because items were sent to a lawyer does not make them privileged if the item was not privileged in the defendant's hands at the beginning. And it wasn't. Because it's a conversation between a third party. With regard to the timeline, we have not seen that. We are generally aware of the contents based on what the agent told Ms. Stifler. We have no intent of using it. This is not prejudicial, of course. There was nothing in there that we intend to use. We never looked at it because it didn't provide us any information with regard to prosecutor defendant. And just like the text messages, this was from a Google Drive that did not indicate that this was between an attorney-client privilege. And by the way, if these things are attorney-client privilege, the court can later make a determination that they're inadmissible as evidence. The court may rule later that we can't use the text messages. But that does not rise to the level of us intentionally invading the provenance of the lawyer and his client. We did not do that. They have not even really accused us of doing that, other than with blustery language and politics. Because there is no evidence to support that we did that. All we did was spend countless hours trying to preserve the integrity of this case and do our best. Just to briefly go over some of the cases the defense cites, because they are egregious violations of attorney-client privilege. So we've already talked about Martinez. He listened to 2 calls. In Reeves, the prosecutor was previously representing the defendant and obviously had attorney-client information, because this was a death penalty case, so even though it was a different case, he had mitigation information that would be relevant to the penalty phase of that trial. And so he was obviously should not have been handling that case. And then Nunez was where a prosecutor intentionally listened to a communication, I think it was like a polycom, to be the case, a conversation between a lawyer and his client, and the prosecutor's listening to it, knows it's going on and continues to listen to it. Which none of these things remotely happened. And then the other cases he cited, they take a quote out of these cases as support for the idea that we should kick off the case, or even the Stifler should kick off the case, and she should not. The absolute activist case, which was a federal third supplement district court from Fort Myers, the quote that they put up on PowerPoint, Your Honor, says that the emails were attached. Attachments that they looked at from the client to the lawyer. The case says that the lawyer, I don't know if it was a lawyer or the client, sent those, so the communication was between the client and the lawyer with attachments. Those emails were inadvertently forwarded to opposing counsel, opposing person. So the defendant claimed that the reception of those emails somehow waived attorney-client privilege. That's what that is. So it's not about the attachment somehow make it, if you attach something to an email to a lawyer, it makes it privileged. That case was about accidentally forwarding privileged information, and then whether or not that waives privilege. In the Havens case versus Gabriel Kubota, this was not the creation of third, this was his own medical information that client was sending to his lawyer. So the argument was, well, you could have gotten his medical records from a different source, therefore it wasn't attorney-client privilege. The court said, well, no, this is obviously the defendant sharing his life experience, his background with his lawyer. And so that is a completely different situation. In Ford Motor Company, they actually sought to review the litigation database that the company used when they stored all their litigations. That's what they were doing. And I think they cited Tubular, there's a fee agreement, what the fee agreements count as attorney-client privilege. And then finally, Borough mutual documents related to the investigation. They were clearly attorney-client privilege. So none of the cases that they've cited are even remotely what we did right here, where we looked at the Google Drive return of 2 documents that did not indicate they were attorney-client privilege. Obviously the text messages are between the defendant and his co-defendant, and were clearly not attorney-client privilege conversations. The timeline, and we have to take their word for it about all of that. We have reviewed the document, certainly nothing in that is prejudicial. The call to question the Stifler or the state attorney's office's ability to prosecute this case fairly, and does not even give the appearance of impropriety. The defendant can rest assured that our evidence is based on lawfully obtained evidence and will be subject to legal analysis by the Honor and defense to determine its relevancy and admissibility, and then determined by a jury to see whether or not it was appropriate enough to convict him as charged. That would be the questions I have.
Why was it Nazario used to get the 2 documents?
Because Nazario was used later. Let me have a moment to make sure this is
Oh, why, thank you, Ada.
So they had the purpose of this, we keep using pain agents in a way that's commonly used, is when you use search warrants, and you go into a lawyer's office, and you start serving documents on this, and you don't want to look, you don't know what is actually evidence of crime and attorney-client privilege. So you have people who are actually reading the details of documents to determine whether or not these things are attorney-client privilege. The reason why the agent was not used was because we had already taken out all of the emails, all of the email attachments, everything that could be a conversation between a lawyer and a client, we never looked at. So when it was the agent going through, the ATF agent going through, we had already taken out all the attorney-client conversations from the Google Drive, and we're looking at just documents that did not indicate it. That's why she called. She's like, well, this says confidential. And the question is, does confidential, stamping confidential on a document, make it attorney-client privilege? And she's like, well, no, of course not. There has to be a communication between the 2. Now, there are 2 different things here. The defense is hard pressed to say that the text messages are a communication between him and his client. The timeline may be, but that's why the agent looked at those, because we had already taken out all of the conversations and walled off the emails and the attachments. So I said the attachments won't work out either. Those were walled off and taken away. So the only thing we were looking at is things that were saved on the Google Drive. And he was used like,
and my understanding is that so based on what was admitted through the text message, sent it immediately. Both items were sent 15 minutes later or so. Those 2 documents.
the timeline.
Right. And the one was looked at / you would like to use, the other one was not looked at.
The text messages were read. The Stifler went through the text messages and looked at them. She actually saw the document.
Okay, and then based on the representation about which she did not look at the timeline.
She has not looked at the timeline. She heard Butler said what was in the timeline, and she never looked at the text message. So she knows Butler's representations, and she testified it appeared to be either marriage.
I don't want to talk about the content.
Well, I think she testified.
Okay.
That's what she was talking about, the publicist. Again, none of that, in our opinion, I mean, whether we use it, the text messages or not, I can't answer that. I can tell you that she looked at it. I can certainly argue at this point, text messages between the defendant and the co-defendant and all that would occur based on the timing of when it occurred. Whether the content is from there or not, we have to make an analysis because we stop looking at this.
All right, that's the end of that.
This morning, we're shining our spotlight on the case at the state park in Arkansas called Devil's Den.
as much attorney. Do you know what? Devil's Den has been getting a lot of news. I don't even know much about it. So y'all want to watch that real quick? We can hear the judge because she's talking towards us. I'm back and I can't get some food. Still no verdict. I see no verdict. And we're coming up on 17 and a half hours. However, the question that they had, the jury had a question on the instruction number 46 and there's 49. So we're hoping and praying it's today. We still have about 3.5 hours left. So I'm going to come over into this. We're going to watch this for a few. Once they get back from their little court break. There's been, here we go. I don't want commercials. Can I ask y'all, so why do some of y'all not like that female? What's her name? Why do you guys not like her? Just curious. Just very curious. I know. The jury's probably out to lunch. It is their lunchtime. It is now 12 o'clock. It's 12:43 their time. It is 12:43 their time. Just saying. Yeah, from Court TV. Why does everybody give her a hard time? Just curious. Let's have a debate.
Where authorities have arrested a 28-year-old school teacher, Andrew James McGann. This is him. He was apprehended while he was in a barber shop about to get his hair cut. His arrest is in connection to the deaths of this married couple, Clinton and Kristen Brink. They were out hiking in a remote area of the park with their 2 young daughters when they were murdered. Their daughters were left unharmed. Arkansas Governor Sarah Huckabee Sanders had this to say to reporters after the arrest, quote, "If you commit a violent, senseless act here in our state, our law enforcement will hunt you down and bring you to justice, because that's what the people of Arkansas frankly deserve." Now, this arrest comes a day after police released a brand new image of who they say is the man who they wanted for questioning. This is the image right here, a picture taken from behind by somebody who just happened to be out on a trail. Actually gives me chills. Thank goodness for that. And they were able to apprehend this man, a 28-year-old school teacher. He just moved to Arkansas, was about to start a job, and police say he did this double homicide. Let's bring in 2 of the best investigators around. I have with me Manuel Gomez and Lieutenant Mike Gould. Both of these gentlemen served in the NYPD. Both of them served in our military. Great to have you both on the program this morning. So let's talk a little bit about what it's like in the hunt for a suspect like this. For those of us who are ignorant and in the public and have never done one of these searches, as you both have done many in your careers, what is it like when you're trying to track down somebody that could potentially be a threat to other people and could potentially harm other people before the capture? Manuel, would you start us off, please?
Well, I have to first say outstanding to the absolute resolute effort of the law enforcement in Arkansas for taking this monster off the street. Great job. Outstanding. This almost was the perfect murder. He had the right location. There was no cameras. If it wasn't that he showed up at that salon and that they identified the clothes he was wearing, he might have gotten away with this. So thank God for the relentlessness of the Arkansas police. Doing a case like this, you have to turn up every stone. This was an investigator's nightmare because, like I said, it was the sheer luck of that one person accidentally taking a picture of that guy that broke the ice on this case. Again, this was an investigator's nightmare, but it turned out to be a blessing because it just shows law enforcement will not quit.
Isn't that the truth? God bless those men and women in law enforcement who captured this guy, and God bless you both for your service in law enforcement. Not an easy job. It is. I say it's the toughest job in the world, and I really mean that. Lieutenant Gould, let me go to you next. Your thoughts on the capture and take us kind of behind the scenes. What's it like when you do a case like this?
Yeah, Julie, and thanks for having me. And of course, I agree with Manuel. This is a great day for law enforcement, another great day for law enforcement. But just in the last few months, we've had these horrendous murders by men in their late 20s. Luigi Mangione, the Midtown shooter just yesterday. And they were intelligent people, obviously some element of mental disorder. So as far as the apprehension, in this day and age, most often you can run, but you can't hide. Even in these rural environments that used to be you'd get lost, there's trail cameras actually now. The Idaho shooter recently who killed the firefighters was picked up on a trail camera. So digital footprints are really difficult to avoid. Could be time consuming. They could disappear in these rural areas for weeks and months, but there hasn't been really, if you think about it, apprehension is always likely eventually, because they just can't stay in the wilderness forever, and they have to show themselves around the residential community, and then that's where people are alerted to him. He's going to need another vehicle, food, and so forth. So, and they don't go that far. Generally speaking, they're located within a reasonable proximity to the crime.
Really helpful points you both are giving us. Lieutenant, thank you for that. Speaking of the guys at the barbershop, he's going to get his hair cut, like, no big deal. I'm just going to go about my life. You're right. He didn't go far at all. This guy, we have some information on him. I want to share it with you both now. Teacher at a small Oklahoma school district until May. Then he resigned to take another job in another state, had not yet started this new job in Arkansas at the Springdale Public School District. Parents of a former teacher described him as, quote, the most standoff teacher she had ever met. Wow. State police arrested him at that barbershop, like I mentioned, in Springdale, Arkansas. He's 28 years old. I think a lot of people wondering, is there any connection with him and this couple? I know our facts are limited, but I would love an educated guess. Manuel, your thoughts on that, please?
I don't think that there was any connection with him and his couple. I do believe that he is a serial killer, and that he was just going out there to do it again. He put duct tape on his license plate because he knew what he was going to do. He randomly picked these people out. There was no connection. I don't believe this was his first murder. It was too well done. It was normal for him. And if you look at him, he has that same stoic look as Brian Kohlberger. I mean, when I look at him, I see a mirror image of him. And like the lieutenant said, we've had Luigi Mangione. We've got the guys walking around with a rifle in Manhattan. I mean, the murders that are happening now by our youth is insane. We have a problem, and we have a national problem, and we need to try to do something to change this with our children.
Mm-hmm. Yeah, you're right, Manuel. Thank you for that. Yeah, 3 daughters this couple leaves behind. 2 of them were with them at the time. Thank God they were left unharmed. Lieutenant Gould, I want to tap into your expertise with the use of canines. You retired as a commander, of the canine unit in Nassau County. And in a search like this, curious how valuable dogs can be in tracking down a suspect like this guy, McGann.
Yeah, so in this case, the digital and witnesses, like Luigi Mangione, was sitting in a McDonald's and he was apprehended. Dogs are invaluable. Dogs in this environment, rural environments especially, outperform any other technology. They outperform helicopters that may or may not be able to fly. They outperform drones, and they outperform humans, frankly, because they're odor detectors. So they can generally go into these rural environments and pick up scent that's incredible. So in my view, they're invaluable, and certainly they were used here, but the facts of the matter was that this person chose to get a haircut, as you said, rather than flee the scene and go into the woods. But dogs are, maybe they're not as effective maybe in Midtown Manhattan as they would be, but in suburban and rural environments, this is their nature, that they're part of nature, and they're taught to hunt human odor. So it's really, they're magnificent. They actually have almost supernatural powers when it comes to odor detection and finding human scent.
I'm a big proponent in using canines in law enforcement, supporting the units that we know a lot of times rely on public donations.
Sorry, do you have a link for that?
To, in addition to what department funds are available. Would the reason, Lieutenant, would the reason that they're better in detecting, perhaps tracking a suspect in a rural area, versus like you use Midtown Manhattan as an example, is it because you have concrete in Midtown where when you have grass, you get foot impressions? Is that why more of a scent could be left?
Well, that's certainly possible. I mean, dogs can be trained to track through those streets of Manhattan. We did that very frequently. It can be done, but obviously dogs are part of nature. They have 4 legs. This is their natural environment. New York City is their unnatural environment. So when we can deploy them. They have 4 legs. They're waterproof. They can move 30 miles an hour, 20 to 30 miles an hour. They're very agile. So it's just a hell of a lot easier in a suburban or rural where there's vegetation, woods. They can climb cliffs. They're incredible in that environment. And they do great work in the inner city, but it just takes a lot more training for them to adapt to the subway. We can take dogs into the subway system and onto apartment buildings. So it's quite impressive, but it's more difficult. And naturally, your dog could probably find somebody in a wooded or vegetated area just out of curiosity.
Right.
They don't have to be highly trained. They would just go and say somebody's in the backyard.
Sure.
And they would detect human odor.
That makes sense. Well, I love when we always have them in the city. Like you say, they make everything safer, arenas, courthouses. That's always awesome when we see the dogs there. We'll keep talking about this case and keep digging in. You both always offer such incredible insight and analysis. Thank you both kindly. Manuel Gomez of Black Ops, Private Investigators, and Lieutenant Mike Gould, also the owner of Houndstown USA. Thank you both kindly.
We're in New Jersey. in Cherry Hills, New Jersey. We're in New Jersey. Actor Gary Busey is back in court via Zoom this morning. He's accused of inappropriately touching at least 3 women at the Monster Mania convention in Cherry Hills, New Jersey, at the Doubletree Hotel back in 2022. He touched the women, they say, during a photo shoot. He denies the allegations. Let's go back and listen into more of this hearing.
His hotel, not employees of Mr.
I know he's old, but he looks bad.
Busey.
Oh, thank you. Thank you,
In
babe.
any event, Judge, my
Got it.
primary argument is that if a grand jury, why not give it? There was no difficulty. For a second, firstly, I think investigation kind of segues into this whole thing, because the failure of the police to actually reach out and question Ms. Higginbotham, who was a direct line of sight possible witness, that's an error that affects, in my estimation, the integrity of the grand jury presentation. There was no reason to do that, to not do that, to not question her, or at least for the prosecutor eventually not to put a sworn affidavit of hers, which creates a whole lot of doubt about whether Mr. Busey did anything wrong or not, whether it's inappropriate or not. As I agree with the court, that's a jury question, inappropriate. But we can assume, I believe fairly, that neither of these individuals would consider appropriate some type of sexual contact that they observed. I think that's beyond cavil that would be the case. So in the end, I believe under State versus Hogan and the duty of the prosecutor, again, I don't want to reiterate, the court's well aware of those announcements and declarations about the duty of a prosecutor. There was just no harm in giving the grand jury, and no extra time. They simply had to put into evidence these 2 affidavits, even if they didn't take the time to get statements. By the way, law enforcement didn't even take a written statement for Mr. Philpott, another alleged possible eyewitness. So for that reason, I think the faulty investigation, if you will, contributed to the eventual unfairness that occurred during the grand jury presentation. I understand what Your Honor is saying, and there's some trial issues here, but we're saying is the case should not go to trial because the grand jury was not given an accurate, full picture of the evidence in the possession of the state. I'm assuming my predecessor counsel, in sending these affidavits to the prosecutor's office, which the prosecutor's office has acknowledged receiving, I'm assuming it was sent in order to demonstrate that the evidence did not support a charge against Mr. Busey for these offenses.
So you're saying to the court that each of these affidavits, the entirety of these affidavits should have been given to the jury?
At the very least.
That's what you're telling the court?
At the very least.
Okay, Mr. Carmi, I'll hear from you.
Thank you, Your Honor. Your Honor, the state's response to the motion of the defense is really twofold. First, that the information that counsel has discussed, the 2 affidavits are, number one, not clearly exculpatory. Your Honor, I just point out, I'm sure the court has had an opportunity to review the state's brief, and I'd rely on that. Just a couple points from Hogan, which is the primary case that we look to with respect to motion dismissing indictment. Hogan court indicated with respect to exculpatory.
I can't. This is driving me crazy. That would help if I slowed the speed down. Walker, I love you. Okay, we need a palate cleanse. I need a palate cleanse. I need a palate cleanse. Let's share this sweet thing. I got to share this. We're going to have a little palate cleanse, okay? Here we go. Okay, that's AI generated. That last one was AI generated.
Oh, are you okay?
Sedentary inactivity is terrible.
Okay, here's another one. Another palate cleanse. And here we go.
When Ricky finds out you didn't take the baby to nursery. Thank you, Ethel Bean Spiller.
Lucy, come here.
Hi, Ricky.
Lucy!
Gee, I didn't know you were home. I didn't hear you come up the stairs. Oh, you.
Oh, I know it
it's
is,
all
but
your
it's funny.
fault. You're the one that pestered Fred to have the stairs carpeted.
You come here. Why did you tell me that you took Ricky to nursery school?
I didn't.
You did too.
I did not. I said I enrolled him, and I did enroll him. I just didn't take him there.
See, I'm ashamed of you.
Well, I tried, but he refused.
He refused.
Yes. Ethel was right here when I asked him. Didn't I ask him? Yep, she asked him. She said, little Ricky, you don't want to go to that nasty old... We're depending on you to be our guide in Germany. Have you been studying your German?
Jawohl, Fräulein.
Hey, that's wonderful.
Geben Sie mir Einstein Wordspoiler.
Oh, great. What does that mean? What do you think it means? Give me a glass of beer. Is that all he's learned? Nope. He's learned how to order 9 different kinds of beer. Oh, we're going to have an interesting time in Germany.
Never mind now. You're not doing so hot with your Italian.
Is that so? By the time we get to Italy, you won't be able to tell me from Gina Lola Brigida.
Well, geben Sie mir Gina Lola Brigida.
Oh, shut me up. How you doing with your French, honey? Fine. I have mastered the 2 most important sentences in the language. What were they? How much is that dress in the window? And wrap it up, I'll take it. Actor we met in that restaurant, that Maurice Dubois. The one that looks so much like Boyer? Yeah, Ricky thought he really was Charles Boyer, right? He sure did. Well, I'm going to ask Maurice Dubois to come up here and make love to me right in front of Ricky. And I won't pay a bit of attention to him, see? And when Ricky sees that I'm not a bit impressed, he'll realize that he has nothing to be jealous about. Oh, boy, this is one of your crazy schemes you can leave me out of. Who asked you in? Well, you always do drag me into your crazy schemes. Well, this is one time I can do without you. What's wrong with me all of a sudden? Well, nothing, but this I can handle by myself. I know this sounds crazy, but I feel left out. Well, all right, Ethel, come along if you want to. No, I don't want to. I just wanted you to ask me. Oh. You'll never buy me anything.
What do you mean I'll never buy you anything? How about that Don Lauper original I bought you in Hollywood?
Don Lauper original. That old thing.
When I bought you that dress, you promised me that you will never ask me for another expensive dress as long as you live.
Oh, I couldn't have said a thing like that. You must be thinking about one of your other wives. Ethel, I'll leave it up to you. Does that sound like something I'd say? I pass. What do you mean you pass?
I'd like to read something to you. February 28, 1955. If Ricky buys me a Don Lauper original, I will never ask him for another expensive dress as long as I live. Signed, Lucy Ricardo.
Let me see that. Obviously a forgery.
It won't help you. I had a photo started.
Oh.
Good night.
My goodness, you scared me. When did you sneak in here?
A couple of minutes ago.
Oh, I must have been so interested in my book. Where'd my book go? Where is my book?
It went out the window.
Out the window? I don't see it anywhere.
Of course not. It's dark out there. Good night.
Ricky.
What?
One of us ought to get up and go down and get it.
One of us?
Yes.
Which one of us did you have in mind?
Oh, the one that's the biggest and the strongest.
Okay. Go ahead.
Oh, Ricky.
Now look, honey, I'm a husband, not a retriever. Good night.
Is there a difference?
How can I go to sleep till I know who killed her? Let's see, it was either the upstairs maid or the butler or the cook.
It was her husband.
Her husband, he didn't have any reason to kill her.
He was married, wasn't he?
Oh.
I can see it all now. He worked very hard all day. Got home about 2 o'clock in the morning. She started pestering him. Wouldn't let him sleep. He stood it as long as he could. Finally, he decided to do away with her. Too sloppy. Aha! A scarf. Perfect. He would do the job quietly and neatly. Slowly he approaches the bed. Murder in his heart. And then...
Oh, I love it. Love it. Okay, back to reality.
Afternoon to you, Judge Ashley. So day 3 of deliberations. Jurors have asked 2 questions so far. Earlier this morning, they came back with their second question. So here's what they were asking. As it applied to the jury instruction 46, is the violation of the protection order for Isaiah or for the building? So that seems to be what's kind of holding them up a bit. They wanted to get some clarification on that. The judge told them to reread the jury instructions. So that's what he instructed them to do, which is exactly the same answer the judge gave for the jury's first question that came.
Okay, we got one more to do and then we'll get back into that. I had to load it. By the way, this is thanks to our fabulous Flash fan.
Versus Devin Michaels. May the record reflect that Ms. Michaels is present in custody. Ms. Patrick is here on her behalf. Mr. Giordani and Ms. Griffith are here on behalf of the state. Mr. Dave comes up for sentencing. Are both parties prepared to go forward?
Yes, Your Honor, sure.
All right, state, this is a stipulated sentence. Anything you want to add?
I do just a couple of things, Judge. First, we have 3 victim speakers. I asked if they permitted me to speak last.
Okay.
We obviously went to a settlement conference. We stipulated this sentence. I think that
Okay, it wasn't a restraining order from the boyfriend. The boyfriend and his family had a restraining order from her mother. The mother's the one that had the restraining order.
the life tale
Thank you,
reflects the
Brooklyn.
gravity and the haunting nature of the facts. As you know, the defendant not only murdered her ex, but then desecrated his body by decapitating him and putting chemicals on his body, causing it to burn. The defendant admitted to the fatal blow. She never admitted to the decapitation portion of the evidence.
Whoa.
Obviously her who did it. Another haunting fact and something that should be concerning, which supports the life tale, is that the defendant had a corollary child abuse case pre-existed this. We reviewed, Ms. Griffith and I reviewed the minutes in that case, and it appears that 2 days after she murdered and decapitated her ex, she appeared in court in front of another judge in this courthouse and made representations that she was staying out of trouble, and obviously had that on her conscience at the time, walked right back out of the courthouse, and then ultimately was developed as our suspect and arrested. We take this case very seriously, obviously the family does as well. We believe the sentence reflects the gravity of the crime, so we will submit it. We do have some updates on CTS, which was wrong in the PSI.
Correct. I calculated the credit at 455 days as of today.
Okay, that sounds correct.
Because I calculated it in regards to she was on probation when this offense occurred. She then got that sentence imposed. She was released on that sentence, so she started accumulating the credit on that day. And I have it at 455 days as of today.
Yes, and we also have restitution requests. We've now received documentation.
Actually, I not received documentation.
Right, we just received it this morning. We showed it to Mr. Patrick. It's supposed to be 5,000 VOC.
I have that.
$1,923 to James Willett.
Hold on, just one $1,923
Yes.
to who?
James Willett.
Okay.
And $2,500 to Yoko Willett.
How do you spell the first name?
Y-O-K-O.
Mr. Patrick, have you seen this?
I have, Your Honor.
Okay, what's your position in regard to the restitution?
They had the documentation, we're okay with it.
Okay, think I'm gonna need you to file that documentation, because pursuant to the new case law, I can't order restitution without documentation.
Yes, ma'am.
All right? Ms. Michaels, what, if anything, would you like to say before I pronounce sentence against you?
I didn't do it, Ioana.
Jonathan was very special, very unique, and I know no matter what I say at this moment, I know right now no one in the family is going to believe me. I know right now no one in the family feels that I am innocent at any point, and I understand that. But I can actually prove my innocence. I actually can. And I'm not gonna stop fighting to prove my innocence. I have more than enough, and Jonathan deserves to have the actual person who's guilty behind bars. I was helping Jonathan. I can show that I was trying to help him, and this, I know, is hurting the family, and I can see it in your faces, and I know your hearts are angry, and they should be, and I'm angry for you. And this is not fair to you. This has been dragging out for almost 2 years. It's not fair to you, and it's not fair to his children, any of them. And it's not right. It really isn't. It's not. I've seen so much that it's just terrible. The way that they manipulated and altered and deleted things is wrong. They should not be able to do it, and they have. And for you to be able to look me in the eye knowing that the things are altered and
You pled guilty, man.
Ms. Michaels, you are not to address the state. You are to address me.
addressing
You are.
the state. I
You're addressing Mr.
apologize.
Giordano. You are going to address me. What do
My
you want me to
apologies.
say? What do you want to say to me?
My apologies. I wasn't trying to address the state directly. It's just, I was told. I was just told one thing after another, and I truly believed that we were going to do the right thing, and it just didn't happen. I am so sorry for all of this, but I'm so sorry. But I didn't do this, and I didn't know this would end up like this. I really didn't. And I will forever apologize to the family that I don't know how to fix any of this anymore. I don't. I keep listening to what everyone tells me is the best thing to do. Just do this and it'll work out this way, and follow this advice and we'll do this. And I keep listening to the people because they keep saying this is the best advice. It doesn't turn out the way they tell me it will. And it just gets worse and worse. And I don't know what to do anymore.
Judge, I'm not comfortable with this record. I'm willing to let her out of her plea if the court is inclined.
I don't know how to fix this.
All right.
It's just, this wouldn't be appropriate.
I completely understand.
Let's go to trial.
Mr. Giordano. All right. Ms. Michael Judge, Mr. Giordano says that he's willing to let you out of your plea and he's willing to try this case And you understand that he's willing to try this case on an open murder. So a jury can convict you of a first-degree murder. You understand that? Or you want to talk to Mr. Patrick about it?
Well, I don't want to talk to Mr. Patrick. He didn't listen to anything I
Miss
said.
Michaels, I need you to understand what I'm saying to you and answer my question.
Yes.
Do you want to withdraw your plea and go to trial?
Yes, please.
All right. This plea is going to be withdrawn. Mr. Patrick, I need you to have some discussions with your client about.
Your Honor, I've moved to withdraw at this time. This case needs to go back to the appointed counsel.
Miss
I will.
Michaels, hold on just one second. Miss Michaels, you need to conduct yourself like this is a courtroom. If you cannot do that, then they're going to remove you because I still have business to conduct.
Yes.
Do you understand? Mr. Patrick?
Judge, respectfully, I move to withdraw and have this case sent back to Office of Appointed Counsel. I am not in a position to accept appointment on this case should it go to trial at this time.
All right. All right, I'm going to have to reach out to the Office of Appointed Counsel and get her a lawyer that's going to be appointed with the understanding this case is 2 years old. This case is not going to sit stagnant and wait around for a trial. So I'm going to reach out to Ms. Bush myself and have a discussion with her in regards to the appointment of counsel because this is not going to be, this case has been delayed extensively, and this case is not going to further be delayed so that there is no justice for everybody.
Yes, Your Honor. And Your Honor, if I may, that's one of the other reasons because with Barry Edwards, it would be late next year before I would even consider putting this on as a trial.
So I'll reach out to Ms. Bush.
Understood.
July 31st, 9 a.m.
And Your Honor, do you grant my motion to withdraw, please?
Yes, I'm going to grant your motion to withdraw.
Thank you.
Wow.
First, and then defense counsel is arguing Mr. Ali is confused.
Wow. Now she's facing life. Why did she in sign language? Hello. Okay, yeah, we need an update on her. Yeah, flip crazy. She undoubtedly is in the wrong, but when she's at this stage with her, yeah, she's screwed. That's crazy. Thank you so much for that. Flash fan, thank you so much. She was due in court today, but no hearing yet. Okay. Well, we have a 4:30 case coming up too. We have another case coming up. So let's go ahead and get back over to this. I want to hear this while I start setting them for the other one.
He's on the ground. He feels that a mob is attacking him.
Okay, here we go.
Mr. O'Leary? I believe that this is the answer that Mr. O'Leary told the jury that they might receive if they had a question.
And let's take a look at that video. This is something both the prosecution and the defense really focused on in their closing arguments. Defense counsel saying this all comes down to 53 seconds. And the way he is talking about this video, he says, take a look at it. See that Isaiah, Fatima's boyfriend, punches Mr. Ali first. And then defense counsel is arguing, Mr. Ali is confused. He's on the ground. He feels that a mob is attacking him. He just wanted to come and take his daughter home, and his daughter didn't want to go. So he's saying there's no intent here. These charges shouldn't have even been brought. That was his argument in his closing. So again, the juror's been out now. The jury has been out now for nearly 18 hours, Judge Ashley. We are continuing to monitor this, and as soon as there is any movement inside that courtroom, we would be sure to bring you any developments.
Oh, fantastic. Thank you so much to Kelly Craft. Now, let's head back to New Jersey, where actor Gary Busey is back in court today. This is a Zoom hearing, and it turns out he has pled guilty to 1 count of sexual criminal contact after he inappropriately touched a woman at a convention. Let's go back in for more of the hearing.
Mr. Busey, I'm going to direct your attention to the date of August 13th, 2022. Okay?
Yeah?
All right. Were you in Cherry Hill, New Jersey on that date?
Yes. Affirmative, yes.
And were you attending something that's been identified as a Monster Mania convention or function?
Yes, sir. Yeah.
Was there a photo shoot set up where fans of William Gary Busey, could have a photograph taken with you?
Yes. Yes.
And during that session, you agree, do you not? You do agree that you inappropriately touched the buttocks of an adult female over her clothing. Is that correct?
Yes.
And you understand now, and you knew then, that that was not appropriate. It was wrong, correct?
Yes, very much so.
Yes. And you want Judge Blue to accept your acknowledgement of this particular incident. Is that right?
Yes, sir. It is the truth.
I have nothing else, Judge.
Is this satisfactory to the state?
Just that we identified the female victim by the initials AD. Would it be fair to say that you later learned that that victim had those initials?
Mr. Busey, the victim is identified with the initials of AD that you said you touched the buttocks of. Do you agree with that, sir?
Yes.
Okay. Nothing further. Thank you.
Keith, I don't have the indictment in front of me. There's no gratification or anything. This is a touching, right?
Well,
I'm looking
Your
at the
Honor,
indictment.
I think that is under the statute part of the purpose of the touching. So if counsel could address that specifically, that would be helpful as well.
Mrs. Willman, you need to fill. Mrs. Willman, you need to fill in the record more as to what his purpose was when he touched her buttocks. That's what I thought. I don't have the indictment in front of me, but there's something missing from the factual.
All right, I just wanted to indicate also, Judge, that the actual victim's name is in the indictment. We're not using that for this purpose today.
No, we use the initials. That's what we use, the initials.
Mr. Busey, I just want to ask you that you understand that it's only a violation of the law that you could plead guilty to if you intended to gratify yourself by committing that act. I've told you that, correct?
Correct what?
The touching of the buttocks was done for your gratification.
No, I was looking, my eyes were on the camera lens. I moved my hands up and grazed her buttocks without thinking and without looking.
That's not a factual basis. That's not a guilty plea.
What?
Mr. Busey, I've advised you, and we agreed earlier, that in order to plead guilty, you have to truthfully acknowledge.
I truthfully acknowledge
that you did this for your own gratification, as opposed to any request by AD. Is that correct?
Yes.
Okay. Thank you, Judge.
So this was not an accidental touching. You purposely touched her. Is that correct, sir?
Yeah.
Okay, and you did it for your own self-gratification. Is that correct, sir?
Yes.
Okay. Any other questions from the state?
No, Your Honor. Thank you.
Okay, Mr. Busey, do you understand that by pleading guilty, you're going to have a criminal record?
Yes.
Do you also understand you have to submit a DNA sample?
What? What?
A DNA sample. Whenever you're arrested, you have to give a DNA sample, which is a swabbing of your mouth. Do you understand that?
Yeah.
Okay. On the charge of fourth-degree criminal sexual contact, how do you plead? Not guilty. What is this, sir?
Guilty.
Okay, sir, I find based on your statements under oath, I find your guilty plea is known and voluntary. It's a factual basis for your guilty plea. Your guilty plea is accepted. Your sentencing, counsel, you're asking that he does it, that he could do a sentencing by Zoom, correct?
Yes, please, Judge.
Okay, your sentencing will be October 3rd by Zoom.
Okay, I'll take
Judge,
June?
October 3rd.
No, October 3rd.
Oh, okay. Gotcha. 5-3.
Judge,
10-3.
I'll have to discuss it with my client. I do have a very serious surgery scheduled for September 22nd.
I can do it before then. I can do it before that. I can sentence him. I can definitely do it before that.
Okay.
I will make it September. You want to do it? Let's do it on an off day. We could do September the 18th on a Thursday instead of my big Friday sentence day, okay?
Let me just check, Judge. Thanks.
You get that?
Yep. I'll tell you your date in one moment, sir. Joey, you called for someone to do his interview?
What?
No,
Yes,
not you, sir. One moment, Mr. Busey.
Judge, what?
I don't think he gets it.
We can do it at 9 o'clock on September the 18th. I said that's on a Thursday.
I have another, I don't know, I don't want to mess up the court schedule. I have something at 9. It's a lower court, but it's an old DWI case. Can we do this later in the morning?
Why do I have to wait for a lower court? I don't understand.
You don't.
Oh, why don't we do this, counsel?
As a matter of fact, I have no problem saying that Judge Blue told me I got to be there at 9.
What court would you have to be in on the 18th?
That would be Parsippany Troy Hills, but
okay, why don't we do, I can do it this, because I'm doing a sentence on September the 11th. How about the 25th? Are you available on the, well, that's close to your surgery. How about the 23rd? That's on a Tuesday, September the 23rd.
Oh, I'll be in the hospital.
Oh, that's the week you go in.
Yeah, but
Because this sentence is fast. I'm going to do this at 9. And it's going to be by Zoom, so you could be wherever you are. It's going to be by Zoom, right?
All right. Well, then we can do. I'll work it out with the lower court, who will, I'm sure, be subservient and acknowledge Your Honor's position. So
they may not, but you'll have.
You know what?
You'll have.
That's their problem, right, Judge?
Right. That's right. Because you'll have to come. You can't be in 2 places at one time.
No. And I'd rather be with Mr. Busey here. So if I had a preference.
This sentence will be really fast. It takes, 15 minutes to do a sentence, so it won't be long. Okay, Mr. Busey.
What date is that, Judge?
September the 18th. That's on a Thursday. Write it down, Mr. Busey. September the 18th at 9 o'clock a.m.
9/18, 9 o'clock.
Yeah, and it's gonna be where you are. You're gonna be able to come by Zoom the way you're doing it now, okay, for your sentence.
Yes, ma'am. Affirmative.
Now, I did make my record. I do find, as I said, that you've knowingly voluntarily entered your guilty plea. Your guilty plea is accepted, and that will be your sentence date of September 18th at 9 o'clock. The next step today, Mr. Busey, is someone is going to come on the screen, a probation officer. They need to do what's called an interview with you to prepare a pre-sentence report. So you need to stay on the screen until we tell you that you can step off, okay?
Yes, ma'am. Affirmative.
All right.
Judge, I'd like to stay with him on that.
Absolutely. Okay, you're going to go in the breakout room when that probation officer come on. Do we know who's doing it, Joey?
I don't get it. I'm going to reach out and make sure right now.
Because I need to rest my back.
You need to step away for a moment. You can, Mr. Busey, but just come back on, okay?
Thank you very much.
You're welcome.
I can't believe they accepted this. He's not competent. Is he coming back?
Is your trial over?
No. Will Mr. Brennan and Mr. Stas. Who was asking about the trial? I'm sorry, who was that?
I asked, Mr. Swin.
Oh, no, it is. They came back with a verdict today, so it's over. Yes.
No, this is now. This is like now.
Are the attorneys back on, Mr. Stas and Mr. Brennan?
Here. Yes, Your Honor.
Where's Mr. Stas?
Welcome.
Is he on?
Thank you. He's gone.
Put me in the breakout room with these two attorneys, Mr. Brennan and Mr. Stas, please.
Your Honor, may we be...
Okay, they're done.
Familiar on...
He fatally shot his neighbor.
Okay, they're done. Oh my gosh, I can't believe the judge accepted his guilty plea. That man is demented. You can tell he's got dementia. Any one of us who's ever worked with demented patients can sit there and tell you he's demented. Yeah, he's getting his beer. Yeah. I don't know, y'all. I'm a little confused by the that confuses me. Yeah. Either that or she knows that it's just going to be a probation thing and it's the easiest. I will tell you, I had a lady sue me and it was over nothing. Well, actually it wasn't. I opened a business with a woman and she broke the contract and walked out of the contract. I had a ironclad contract with her and I took her to court. I won. And then she took me to court over $32. And the judge looked at me and he goes, look, I can do one of two things. I could side for her and that will stop her from coming after you. I know this woman, she's in court every other month with people. Or you can take that easy way out, or I can find you guilty. You don't ever have to pay it. She can't make you pay it, but she can't sue you again. So he sided with her just to save me a lot of hell. I mean, I could see the judge saying at his age and everything, just accept the guilty thing. He'll be on probation and he can go on with his life and die a happy, peaceful man. I don't know. That's what I think. Yeah, and that was the other thing. He may not have intentionally touched her, but that saves him a trial. I don't know. All right, guys, we are going to come back over into the trials, the drama of the Stampin' Up heiress and the woman who had her ex-husband unalived in front of his other daughter, not her daughter, but his new wife's daughter, who was 2 years old, while she was fighting for, I guess, custody of and divorce, still fighting over the twin children that they had together. Let's look at this.
To wealth. Her parents had money, lots of it. She was also raised in a devout Mormon home. From the outside, it seemed like she was living a very stable, normal life. She then met a man named Jared Bridegan during a trip to Florida. Jared was also a devout Mormon. They fell in love and got married in Utah in 2010. They began their lives together in Connecticut and began raising their twins, but then moved to Jared's hometown in Jacksonville, Florida, for the health of one of their children. It was here in Florida where life changed for Shanna. marital problems, allegations of cheating, and actions very inconsistent with her Mormon upbringing. This led to a divorce. This also led to endless battles concerning the twins. Shanna did remarry. She met Mario Fernandez Soldana at the gym where she worked out. They fell in love and got hitched. Jared also got remarried and started a family with his new wife. Then Jared was murdered. Shanna skipped the funeral and moved to Washington State without her new husband. Then the killer, Henry Tenen, was arrested. Mario was arrested. And finally, Shanna was arrested, charged with murder, facing a potential death sentence. Shanna was in court today with her new husband and her attorney, Jose Baez. And tonight, we'll take a look at what happened in court. We'll take a look at the alleged motive in the case and the relationship between the two accused killers as we investigate the murder of Jared Bridegan.
I'm Benny Politan. Thank you so much for joining us tonight here on Closing Arguments. The man who killed Jared Bridegan had absolutely no motive. Henry Tenen is his name. No connection whatsoever to Jared Bridegan. No beef with Jared Bridegan. There was no reason for him to do it other than getting paid to do it. Acting as a hitman and setting him up and taking him out. But when you look for the motive, why would he do it? The only motive is money. Is being hired to do it. There was nothing personal. There was no relationship. There was nothing. His life and Jared Bridegan's life did not intersect until the murder. That's when it happened. Now, Jared Bridegan loved his children. Absolutely loved his children. He's a father, wants to be in their lives. And this became, number one, the reason they were all living back in Florida. One of his children had a medical condition, needed to live in that area that was best for the health of the child, but wanted to spend time with his kids and started a family with his second wife, but does not exclude his children from his first wife. No way. That's not Jared Bridegan. He's a dad. And because you're not with mom doesn't mean you're no longer a dad. And he stayed in his children's lives. And this became a real point of contention and turned into a 7-year custody battle with his ex, Shanna Gardner. 7 years of litigation. It just never ends. And people ask me, oh, well, you know, when you practice law, why didn't you go into family law? That's why. It never ends. It never, ever ends. And there was a bitterness here that went beyond many of them. I mean, how many times were they in court? Time after time after time after time. Can't work things out, can't figure things out. And you don't know who to blame for that. But my guess is, during the course of this trial, prosecutors will probably be looking at Shanna Gardner, the one who wanted control of those children. And she couldn't because Jared Bridegan was a great father and wanted to be in their lives. Now, that relationship obviously broken and could never be fixed, and the bitterness continued for 7 years. But I want to talk about another relationship. Is she going to have trouble with husband number 2? Her co-defendant in this murder case. I have a suspicion that, oh yeah, this is going to be big trouble inside the courtroom. You see, the hitman is somewhat connected to her husband, Mario, but not directly connected to her. The only viable defense she has here is to throw Mario under the bus along with the hitman. Mario was doing that. I don't know why he did it. Maybe he did it because he thought it would impress me or it would make me happy, but I didn't want him dead. Oh no, that's got to be the defense. And they're both going to be tried together.
Yes, I think that two things. One, I think Mama But the other thing is what they were asked questions on was the kidnapping charge, and I would say that would be on Dad. So I think it's Mama and Dad. I don't know. I think they're being very, very cautious and going through every single section of every instruction with scrutiny, which is, I guess, a good thing. The only defense is to pretend she knew nada, but I'm pretty sure it's all tangled web, just like the Adelson trial. Yeah, I do too. And that's why I hate some of these lesser charges and all this. When you have all these lessers and all these different levels of charges, I think it confuses the jury far more than it helps.
In this case, and it's going to be a strange dynamic. Prosecutors love this, by the way. We love to be, I'm a former prosecutor, love to be on one side of the courtroom and they're on the other side. I'm pointing the finger at them and they're pointing the finger at each other. That's like best case scenario for a prosecutor. So for those of you who don't know the whole backstory here, because it is layered, it's somewhat complicated, trying to work through it. Matt Johnson, Court TV crime and justice correspondent, has the story for us.
Jared Bridegan appeared to have it all. A new job as a Microsoft executive, living in sunny Florida with his wife Kirsten and 4 children.
We had just had London. She was 6 months old. So things were good.
Kirsten had 2 children with Jared, London and Bexley. They also shared custody of his 9-year-old twins from a previous marriage.
On the week that we did not have the oldest 2 kids at our home, Jared would take them out to dinner. It was referred to as date night in this agreement.
The agreement kept Jared and Kirsten in Florida. Bridegan and his ex-wife, Shanna Gardner Fernandez, were in a bitter custody battle. What was that relationship like, he and his ex-wife?
The relationship between us and his ex-wife was not cordial. Our communications were always in writing because there was not mutual trust between the 2 households.
On February 16, 2022, Jared had one of his scheduled daddy date nights. After dinner, he dropped off his twin daughter and son at his ex-wife's home in Jacksonville Beach, Florida, and headed home to St. Augustine. On the way, he stopped to get his 2.5-year-old daughter Bexley ice cream. She was in the back seat of his SUV. He then called Kirsten, telling her he loved her and would be home soon. How did you learn something was wrong?
As time started ticking by and the time that they're usually home passed, I can't even describe it. Like, I just knew something's not right.
Her fears became reality after an officer answered Jared's cell phone, telling her Bexley was unharmed, but they needed her to come by the police station to hear about her husband.
They later on that night told me that he had been shot. Where did this happen? Because he usually gets in the car and just drives home. I had talked to him.
Jared was not a victim of any robbery gone wrong or carjacking. Police say he was the victim of a targeted attack on a one-way road he traveled often. Jared came across a tire police say was intentionally placed right here in the middle of the road in the sanctuary neighborhood of Jacksonville Beach, Florida. That's when someone came out of these woods and ambushed the father of 4, killing him on the spot. For almost a year, no answers. Then in January 2023, a break in the case.
Henry Tenen was arrested for the following crimes: conspiracy to commit murder, second-degree murder with a weapon, accessory after the fact to a capital felony, and child abuse.
Now investigators say that Tenen has pleaded guilty in the case and admitted to shooting Bridegan.
Henry Tenen pled guilty to murdering Jared Bridegan. Henry Tenen has admitted that he in fact was the shooter.
According to court records, Tenen once lived in this house that was once owned by Bridegan's ex-wife's current husband. And now investigators have charged both the ex-wife, Shanna Gardner, and her husband, Mario Fernandez Saldana. with first-degree murder.
We will be filing a notice of our intent to seek the death penalty.
Prosecutors call Gardner the mastermind behind the murder. Both Shanna and Mario have denied any involvement. Meanwhile, Jared's widow says that she suspected them from the beginning. Had you suspected that Mario was also involved in all of this?
From very, very early on, I felt, like, obviously I didn't have any evidence, but I felt that Mario Fernandez and Shanna Gardner would be involved somehow.
And big day in the courtroom today. And afterwards, Shanna's attorney spoke. She's being represented by a man who's had a lot of success winning cases that people thought could not be won. Talking about Jose Baez. Take a listen to what he had to say.
Because he's got, I mean, she can throw millions at him. Her net worth, not her mommy and daddy's, their net worth is about anywhere from, someone said conservative $300 and $900 million. Hers is $10 million.
After court today.
Well, the prosecution thinks they have enough evidence to seek the death penalty against her.
Well, I've heard that before.
It's a death penalty case. Seems a little confident there, doesn't he? Let's bring in Court TV crime and justice correspondent Matt Johnson. Joins us live from outside that courthouse in Duval County, Florida. Matt, great to see you tonight. Let's start with the couple, right? You've got Shanna and Mario, both in court today. They haven't been together in quite some time. What happened today?
Yeah, big day in court. Nice to see you, Vinny. Happy Friday. So it was a big day because the former lovebirds turned co-conspirators, according to the state, and accused killers. They were reunited, and they didn't seem too happy about it. This is the first time that they've been in the same room since they were estranged.
Oh, yeah, they're in a whole nother league. He charges $2,500 an hour. That's freaking insane. I mean, there ought to be a cap. I'm sorry. I won't tell you what I'm not going to make that
separated,
comment.
And since his arrest and her arrest for the murder of her ex-husband, Jared Bridegan. Now, they also appeared very different in court. Take a look at your screen right there. He's in that jail suit that is appointed to him, where she's wearing street clothing. At some point, she was smiling with her attorney, Jose Baez. He was pretty much stone-faced, Vinny.
Yeah, there's quite a difference. I think what he's going to learn here is that when you marry a trust fund woman and you end up as a co-defendant, you will get the short end of it. She can pay for the big defense, which is what's happening, and she's going to point the finger right at him, and he is the one that's going to get the brunt of it from the prosecution and probably from Jose Baez at the same time.
Right, you know, and the situation with this is that it's a triangle, right? Because you also have a third co-defendant, Henry Tennant, who we talked about in that piece, who has already pled guilty, and he is required, according to his plea deal, he doesn't have life on the table. What he has is 15 years, but he has to testify against his co-conspirators, according to the state. And, you know, they are both facing the death penalty at this point in time, and Shanna has now joined her husband in waiving her right to a speedy trial.
Okay, so speedy trial is waived, so this thing is not going to move super fast. I understand that. And something is happening here, right? With the discovery in the case, there were some issues involving things that were placed on the server that were supposed to be accessible, but were not supposed to be there. Can you go through and sort of explain that situation for us?
Yeah, that's really an important key part of this case right now, and that's going to determine the projection of the case, for that matter, and what we're going to see next. So you have Mario Saldana, who says that he hired an attorney before he was even arrested. This is months ago. And then he's arrested. They take his laptop, they take his cell phone, and the contents are downloaded and uploaded to the state server. Well, that includes, according to the state, they said it today, some of the communication. So that was uploaded to the discovery. And that's what Jose Baez was actually talking about today, why he couldn't access all the discovery. And this is exactly why Mario Saldana's attorneys say that they want these prosecutors kicked off the case, because they say it's a violation of his rights, that it was attorney-client privilege, and they don't know how to remedy it.
So, what did the judge have to say about any of this? Was the judge concerned about all of this, or is the judge trying to figure out a way around all this?
The judge is very concerned, and we have a clip from that very important part of this hearing today. Let's take a listen.
Hate it when you get an itch and can't reach it.
Those emails that they concede are attorney-client privilege were uploaded to Next Point by the state's own admission. They have been able to be accessed at a minimum by anyone at Next Point, by law enforcement, and by the state attorney's office. I'm not prepared to respond today as to whether anyone saw it or didn't see it. I don't know that. But to answer your question, yes, there's one document that they intend on using, but that they've read and they've reviewed, and the court and defense and the state discussed in chambers this morning. And I think that's what is really the crux of what the next step is going to be, Your Honor.
We have received the discovery, and which consists of a thumb drive, and in addition to that, a external hard drive as well.
Just so you know, the jury is on a break as well. The clock has stopped. I do not hear anything about a verdict, so we're all assuming it's a break. It's about that time.
Review the contents of it. There is one thing I think that the court should be aware of. Since we had the Next Point issue come up, it was immediately shut down. So we did not have access to further discovery post the date of it being shut down.
What is that date? I believe it was November 15th, Your Honor.
So right there, you have a very critical moment and a key part of this case and how it's going to end up, Vinny. Like, do the prosecutors stay on the case? Do they not? The judge says maybe a special judge has to be appointed to listen to all the evidence because she doesn't want to hear it, because she is going to be presiding over the trial, as far as we know. So this is really key to determine what happens next, and that's still up in the air.
Yeah, that's problematic, because these are death penalty cases. Death penalty cases are the most litigated cases in our entire system of justice. Every issue is a potential problem. Everything has to be done 1,000% right. Cross the T's, dot the I's, etc. So my understanding, and one of the other issues presiding over this, you mentioned that Shanna waived her right to a speedy trial. I mean, that's another potential problem here, right? If you're saying, well, we're waiving the speedy trial because you did this with the discovery, it becomes problematic.
Well, it becomes problematic, but it was also expected, because Jose Baez was hired by this very wealthy family to defend Shanna Gardner, the heiress to this paper fortune out west. So he just got the case a couple weeks ago when she was extradited from Washington State here to Florida. And he hasn't had an opportunity because of those questions.
Well, Wogger, everybody share. And if you shared, put I shared in comments like this. If you share my live, put that in the comment. You'll be entered into the end of the month drawing.
About discovery with Saldana's case to review all of the discovery. He just got the rest of it today. So it's really in their best interest to waive that right, and that's what she did today.
Good morning.
Morning.
I've been handed a form that's titled Unlimited Waiver of Speedy Trial. Have you gone over this form with your attorney?
Yes, Your Honor.
Okay, and it has your signature on it. Did you sign it indicating that you have, in fact, gone over this with your lawyer?
Yes, Your Honor.
The form indicates that you've reviewed both the advantages and disadvantages of waiving speedy trial. Is that true?
Yes, Your Honor.
Okay. And has anyone threatened you or coerced you to get you to waive speedy trial?
No, ma'am.
Promised you anything?
No, ma'am.
Okay. I will find that the waiver of speedy trial is freely and voluntarily entered.
And Vinny, that's really also an important moment because that's one of the first times we've heard from Shanna since she's been arrested. And after that, she was smiling with her attorney, as we know, Jose Baez. But he also had another big win in court because the court granted him and the team there access to what was discovered with the grand jury, those proceedings and the testimony from that.
And what's interesting, you say that he just got the rest of the discovery today. And yet after court, he was talking about how there's no evidence in this case, but he hasn't reviewed all the evidence yet. But I guess what he's seen so far, he doesn't consider important or conclusive in the case against his client. So big day today. So what's next here?
We have a couple big days ahead as well. So coming up later this month, Mario Saldana will be at this courthouse here behind me, and they're going to be again talking about the whole issue with the discovery and that privilege that could have been violated. So that's going to be on the 11th. And then come next year, that's the next time we see Shanna Gardner in court, his wife. That's going to be on February 2nd, and that's going to be more scheduling. So by then, we should get an idea if there's going to be a trial.
That's 2024.
Date set, but Wheels Does Justice probably turning pretty slow here on this one.
I think so. I really do, because I think that everything will be fully litigated, number one. And I think number two, this issue of attorney-client privilege and the prosecutors is real messy in a case where you're seeking the ultimate penalty. Matt Johnson down in Jacksonville, Florida, Duval County tonight.
That's
Great
true.
to see you, Matt. Thanks so much.
Have a good.
May I proceed?
So now we're back over into the verdict watch in court TV where they're talking about multiple trials.
For example, in less empathetic professions, right? So people who practice just looking at the facts all day long and trying to render decisions, like maybe an engineer or an architect or somebody who works with computers, they would be able to look at this without emotion and make the proper decisions.
No, I love talking to you as a jury consultant, Madeline. Always enjoy having you on. Thank you so much for being with me. Coming up next, Michael Ayala and another neighbor takes the stand in the returned mail murder trial for Jordan Palmer. Stay with us. We'll be right back.
He has actually, that's interesting, you guys. Look, they have a new series starting tonight, The Murder of Jared Briggan, Vinnie Politan. They're going to cover him tonight. Interesting. Very interesting. I'm looking for Corey because there's supposed to be a hearing today on Corey. Oh, excuse me. There's supposed to be a hearing for Corey Richens today, but I don't have anything pulled up yet. I don't see any court stuff pulled up yet. Everything is old. So we'll keep an eye out for Corey. We still got at least, how many minutes? 30 minutes before Corey's hearing comes in. And I don't know which media is going to cover Corey Richens, or if it's going to be covered live at all. Do we know? No, we've already had her hearing, Crafty Chris. We had her hearing earlier today. It was it's a pre-sentencing type style hearing. and they were just coming to agreements on some of the evidence. So they don't have a hearing again until September something. I think 5th. I think the 5th. I'll have to look back on my calendar. We've juggled a lot of cases today, y'all. So are you talking Corey Richards, June? So if that's the case, it'll be 4 o'clock. I'll be 4:30 before we start having anything on hers. So let's get going on this. Okay. Yeah, I'm just keeping an eye on it. I'm just gonna have to possibly change my start time on my other feed. The number one aunt. One of the sisters hasn't been involved with Stampin' Up for years. I know. And then Lady You Bug Lover, Stampin' headquarters is within walking distance of my house. So, yeah. One of the sisters bought out the other sister, I think. I think. We're staying in the know. Yeah. This is sad. I've been a part of that company for 10 years. And I mean it's sad. It breaks my heart. And the company had nothing to do with this that we know of. It's just who her parents are. So I'm not bashing the company at all. Not at all.
Welcome back to Court TV Live. I'm Michael Ayala.
And I'm Judge Ashley Wilcott. We will get you back inside the courtroom in just a moment. But first, we are in day 3 of verdict watch in the attempted honor-killing trial of Ihsan Zahraa Ali. The jury has gone for another walk, so they're on a break. That's why the clock is paused. But so far, they have deliberated for more than 18 hours.
I wonder if there's some tension in that deliberating room. Now, earlier today, deliberations were paused for a jury question. They asked, as it applies to instruction 46, is the violation of the protection order for Isaiah, the victim's boyfriend, or the building? Well, once again, the judge instructed them to reread the jury instructions.
For the boy.
Deliberations continue.
Michael, they are being very thorough, no doubt. They have to decide if the couple is guilty of trying to...
Okay, there's something that some people don't understand. The order is against the boy. So if the boy, she may have to stay 1,000 yards, for example, away. We'll just make it reasonable. 100 yards away. She can't be within 100 yards of him. Then that means if he is on the school property, she cannot be there. Well, she cannot be within 100 yards of him. But there was a protective order put against her for the boy, but there was also a no trespassing that was done at the school. So the school had her no trespass, which means she could not step foot on the property of the school. They're two separate orders. And that, I think, is where some of the jurors may be getting confused, because it's not one order, it's two. One, she can't be within so many feet of that young man. And two, there's a trespassing notice put on her, which means if you come back on property, we're going to have you arrested and charged for trespassing. That's how them apples work.
Their 17-year-old daughter, Fatima, outside of her former high school last October.
Now, Ihsan Ali was captured on video punching Isaiah and then attacking his daughter. Witnesses testified he had her in a chokehold and that Zahraa was grabbing at Fatima by her neck. Now, we'll continue to monitor deliberations and bring you the verdict, of course, as soon as it happens.
Right now, though, we want to go back to Montana for Court TV's newest case, the returned mail murder trial of Jordan Palmer. He's accused of shooting his neighbor, Stephen Campbell, to death in April of last year.
Palmer reportedly told police he found a piece of mail on the ground and was putting it in a mailbox when Campbell confronted him. accused him of breaking into cars. He said when Campbell started swinging at him, he shot in self-defense.
But prosecutors say surveillance footage does not show Campbell making any movements towards Palmer before being shot.
All right, I want to get you back inside that courtroom now where a neighbor is on the stand, a new neighbor on direct examination.
Thank you. When you're ready, Mr. Ball.
Good afternoon, Ms. Mashik.
Afternoon.
Where do you currently live?
807 Mantle Drive, Apartment D, Belgrade, Montana.
How long have you lived there?
For a year and a half
Prior to that, where were you living?
on Valley Center.
You said about a year and a half ago. So when was
So it'll be 2 years in October.
Look, I didn't believe my ex could have committed the crime that he committed until I saw evidence to prove otherwise. And that didn't happen until after trial. So I get it. You support your family, loved one until you see evidence that proves to you otherwise. You may still love and support them, but you don't condone the behavior and you, are very understanding of the other, the victims' families.
Why did you move to 807 Mantle?
Our residence was sold. We were renting.
And tell me a little bit about the location you moved into, 807.
It's a fourplex. We live in the bottom right.
Could you describe what that means?
Excuse me?
Could you describe what that means? What do you mean by a fourplex?
Fourplex. It's one building with 4 apartments in it.
And are those apartments, how are those apartments arranged?
2 upstairs, 2 downstairs. The upstairs apartments have 10 steps to walk up. The downstairs apartments have 5 steps.
Steps to go up to get to that apartment?
I have to walk down the steps to get into the apartment and up to get out.
So you have I guess describe where you have neighbors in relationship to where you live.
So the deceased lived next door to us to the right. Well, if you're looking at the building, to the left of us, because he was in apartment C.
Just 1 second. So if it's a fourplex, there's 2 apartments on top and 2 in the bottom. Is that correct? And when you're looking at the fourplex, you're in the bottom right?
Bottom right.
And then who resided in April of 2024 in the bottom left?
Stephen.
Okay. And what about the upstairs 2 neighbors? Do you know?
Patrick. I don't see them very often, so I don't remember their last names, but Patrick lives in the upper left and Jeremiah lives in the upper right, which is just above us.
How close are you with your neighbors? Or
They're nice enough. They just work a lot. And Jeremiah doesn't cook at home, so as soon as he gets home, he changes and goes out to eat. So I don't even see him at supper time when I hear him come home.
And I'm trying to think of the best way to do this, but can you see this map okay?
Yes.
I don't want to make you come on down, but I'm going to point at 807.
I see it.
And just ask.
That would be it.
Pointed at 807 for the record. Is that the residence that you reside at?
That is correct.
And in that photograph, I'm going to walk back over. Is unit D downstairs on that side?
Yes, so my parking spot is, my garage is the farthest north.
And I'm pointing to this part,
Yes.
Is that what you mean? And then where is, you indicated Stephen, I want to ask you who that is, but what apartment is here?
So downstairs is C and upstairs would be A.
Now, you indicated you used the name Stephen. Who did you mean by that?
The deceased.
Stephen Campbell?
Yes, Stephen Campbell, sorry.
How did you know Mr. Campbell?
When I saw him outside, he was
if she is still alive, we will do a raid when we're done.
He was a smoker, so I'd see him outside when he was smoking or when he came home from work. And he'd be hanging out there, either talking on the phone or just having a cigarette and we chat while he was smoking.
Okay. How well did you know him?
Not that well. Well enough to be sorry that he was gone, but not what I would call a close friend.
Tell me about the wall you shared with him.
I think the building is very well insulated because we didn't hear anything through the wall.
So you didn't have any issues with noise from your neighbor?
No, he was a good neighbor.
What about upstairs neighbors?
The young couple that was there before Jeremiah above us, he walked rather heavy on his feet, but so he would stomp down the stairs on the way out, but I hardly ever hear Jeremiah, so it's pretty quiet.
Okay. How long have you been living in that apartment in April of 2024? Is that 6 months?
Yeah, 6 months.
October, the 6 months prior, is that correct?
Yes.
Okay.
That is correct.
April 19th of 2024, do you recall that date?
I do.
And why do you recall it?
Because someone died across from my home. And it's usually a normally quiet neighborhood.
Can you tell us what you were doing around 11 that night?
So I was having trouble falling asleep, so I was listening to something on my iPad. And my bedroom was at the back of the building, so when I heard, I thought someone was knocking on the door. Turns out it was the gunshots that were being fired. And I remember it being close to like 11:20, 25, somewhere in there.
So Ms. Mashik, you're sitting in your room. Can you describe where your room is?
It's at the back of the building, so my windows face Jackrabbit.
Okay. So I'm gonna move. And are you indicating your bedroom's on this side, facing this way?
Yeah, that's why it was quieter. Some people said it sounded like fireworks, but since I was at the back of the building and had something in my ears, it was quieter to me.
So you had headphones on.
Uh-huh.
What were you watching?
I don't recall.
And you heard a sound.
Uh-huh.
And what did that sound like?
I thought someone was knocking on the door. So it sound like 1, 2, 3, 4, 5.
Do you recall the number of knocks you heard?
I thought I heard 5.
Okay. Do you know?
That's my closest guess. That's why I thought it sounded like a knocking at the door.
So what did you do?
I went to the door.
Okay.
I watch a lot of police shows, so I asked who it was without opening the door, and nobody answered, so I slowly opened it, and there was no one in my stairs. But when I looked outside, there were 2 people across the street.
No, I'll take you to there, but I want to
Okay.
I want to back up a little bit. After you heard that knock, what did you first do?
Just went to the door to see if there was someone
Did you have
there.
to take off your headphones?
Yeah, because I didn't want to carry the iPad with me.
Okay.
I use a cane, so I didn't want to drag that with me.
And
So I just-
know it's personal. Why do you use a cane, or how
I have
long? Have you?
rheumatoid arthritis.
Do you always use it?
Most of the time now. Yeah, there are times when if I've been walking around my kitchen, I can walk without it for a little while. But most of the time I have it.
How did you walk to the door on April 19th?
I quickly put on my robe, tied it, and walked down the hallway to the front door.
How long is it from your bedroom through the hallway to your front door?
It's a pretty small apartment, so I would say from the front of the juror's box to the other wall.
And I just asked maybe if that record.
I'm not sure how many
the
feet that
witnesses
would be.
indicating maybe from the jury box to the back wall, maybe 20 feet.
Long enough for a bathroom, a laundry room, and the living room.
Mr. Ball, I can't tell you what permission, please.
Just ask the record reflects you indicated the jury box roughly to the wall.
It so reflects.
About how far is that?
20 to 25 feet. It's not a large apartment, so.
Tell me about that hallway. Is it a straight hallway?
Yeah. So I go straight out of my bedroom door down the hall, and then go left a little bit around my sofa to get to the front door, and then it's straight to the door.
And did you walk, or did you utilize a cane?
I utilized the cane.
How long does it take you to? How long do you estimate it took you to walk that distance?
I'd say at least 30 seconds.
And you indicated you didn't open the door right away. Why not?
Because we don't have a peephole in our door, and we don't have a window near the door. So I wanted
Is she living in an apartment? Because she is. That's required by law.
to see. It's late at night, so it's very odd for me to have a visitor at that time of night.
So you open the door and you look through. Is that right?
Yeah. So there's a little entryway, and the stairs are to the right. So I looked around to the right and saw that no one was there.
When you open your front door, are you at street level?
No, I'm 5 steps down.
So your height, your eye height, where is that in relationship to the street?
When I'm standing in my stairwell, there's a little wall about this high, and then there's a railing that I can see through easily. And then there's the stairs to my right.
Okay.
So chest level is where the concrete ends.
And from your front door, can you see into the street?
Yes, easily.
And that night, could you see into the street?
Yes, we have street lights. So
Is there anything obstructing your view?
no,
Your apartment is next to what you indicated was Mr. Campbell's apartment. Is his set up the same way?
yes, it's just the opposite though. So the kitchens are in the same place.
So is it fair to say it's inverted?
Yeah. Yeah. So mirror
Still have
image.
to look up the same way? Or
Yes.
sorry, it's below street
So
level the same way?
his stairs are the same.
When you indicated you had watched or seen Mr. Campbell smoking before, where had you seen him smoking?
Either down by his door, or most of the time it was up on the patio area in front of the apartment, which you can see in the photo.
When you say a patio area, what do you mean?
The concrete. So that tree is no longer there, but the flat spot in front of the building between the driveways.
All right, let's pause it right there. When we get you back inside this courthouse, the neighbor testifies about what she saw the day of the shooting. Keep it here on your front row seat to justice.
Matriarch of the Adelson family gets arrested.
Terrible. Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markell.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot. Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage begins this August on Court TV.
Okay. All righty then. That's what they're saying. Go hop in that shower, y'all. I need something to eat so bad. I don't have anything to eat. Wait, I got crackers. Crackers now need peanut butter. When it comes back on, I'll go get me some peanut butter. We are waiting for the Corey Richens to see if we're going to have a live feed for that. I'm not quite sure yet. On the Corey Richens. Walker is a great channel. AdaKay and her. Yes, y'all keep sharing, please, guys. I was just looking at my analytics while we were watching that. We've grown so much, but as with that growth, what happens is for some reason YouTube feels the need to remove some of the subscribers to validate and make sure that we're really growing, and I ain't buying them. And I have not bought I've never bought a subscription. I mean, I've never bought my subscribers. So right now we're at 3,369. We are trying to get to 4,000 subscribers by the end of August is the goal. So that is the goal. But our viewers are growing, and I'm so thankful. We've got some new members, Miss Evangeline and Haley Mass and Angela and Miss Eveline and Angela and Luca and She Wolf and Tracy L. You guys are all new viewers. Martin, Martin, Tunips, all of y'all are Tracy L. They keep moving on me. Why are you moving on me? Quit moving. So we've got a lot of Tracy L is new. 8 days. Well, it won't let me. It keeps moving. So anyway, thank you guys so very much for becoming members of this channel. That's the way we grow, guys, and it's important that we have some good memberships. Our memberships have gone down. So y'all, memberships are very important. I'm working on some things for members. What I'm going to start doing is when we do our Sunday Night Live, if you are a member, now I'm talking the regular Sunday Night Live. In order for you to call in and talk live, you have to be a member. That is one of the things that what I'm looking at doing. So I just got to figure out how to get all that done. Yes. We're going to go here because this is. Never mind. That's not what I'm looking for. Who is this? I need some sugar, y'all. I need some sugar. For those of you who weren't with me this morning, I've had 3 days where I've had less than 4 hours sleep a night. So I'm getting that afternoon lag.
We'll head back to court in just a moment, but first, let's bring in National Trial Attorney Michael Jaffer joining us today. Thank you for joining both of us here today, Michael. Now, listen, the videos that the neighbors have shown have been hard to see and be some graphic details in it that we can't show, but I have to say that the prosecution contends that those videos make clear that the victim did not get physical with the defendant. The defendant pulled the gun, shot the victim. Video's best evidence. Is this a hard case to say, no, it was self-defense?
Well, of course, yeah. Anytime that you have any indication that you were the aggressor in a situation and somebody, an unarmed person, ended up being dead, is very, very difficult. And I always tell, defense attorneys that you always have something to prove when you're defending a client, even though the burden of proof is not technically on you. You have something to prove in every single case. If you don't have something to prove, if you didn't have something to prove, you wouldn't be on trial. So you definitely have something to prove. And also 12 human beings are weighing your fate. And those people, they almost like, they need to be sold by one side or the other. And as a criminal defense attorney, I also say you're basically a glorified car salesman when you're defending a client. You got to sell your product to your customer, and so it's very difficult when the video evidence does not show that he swung at him. And I know it's not the highest quality. So theoretically, it could still be possible. But at the end of the day, one person was unarmed and that person ended up being dead. I will say that in Montana, there is no duty legally for the one person to retreat, even if they could retreat safely. That doesn't mean that it gets them out of jail, because you still have to prove that you were under threat. You had an imminent threat for your life. So to your point, Judge Ashley, the videos show that there may not have been any imminent threat to his life. And so at the end of the day, he may well get convicted if the jury believes that he basically shot him and he was not provoked.
Mike, I think one of the things that the defense has done thus far is really trying to undermine that video, talking about the quality of it, not very good, perhaps frames having dropped out based on the quality of the video and where it was gotten from. Now, given that, there are some things on the video you can see that can suggest aggression. So one of the things that I saw, which I know, again, it could be interpreted many ways, but subjectively, the guy takes a cigarette out of his mouth and flicks it to the ground in a way that you see prior to fights. And the guy says he was threatening him. Would any of that be enough under these circumstances for him to claim self-defense when he shoots at him 7 times?
There are so many cases where it's not even a close call. This is not one of those cases. It's a very close call, because the jury are going to look at these videos. These videos act as a Rorschach test. Whatever you want to see, you're going to see. If you want to see aggression, you're going to see aggression. If you want to see somebody who overreacted, you're going to see somebody who overreacted. You just showed why somebody might look at this and say there's aggression, but then another person might look at it and say it doesn't justify you shooting somebody who was an overreaction, right? So it's a close call, but the jurors are going to look at these videos and they're going to be a Rorschach test.
Yeah, and don't forget, the use of force has to be proportionate with the threat. Right. And there's no inclination that he was coming at him with any kind of weapon, although there was a knife in his pocket. So that may rear its head again in this trial. All right, Mike, stand by. I want to head back to Montana for more testimony in the return mail murder trial of Jordan Palmer. Right now, a neighbor is testifying about Palmer yelling for her to call 911.
Was there seating out there?
No.
It's just a standard driveway?
Yes.
That night, do you know if Mr. Campbell was smoking?
I don't know for sure, but that's okay. The main reason I can think of that he would be out there at that time of night. He indicated he didn't sleep very well.
So it takes you about 30 seconds to get to the front door. You open the door, and what do?
I looked around the corner to see if anyone was in the stairs.
And was there anyone there?
No.
What did you see then?
Then I looked up and saw 2 people across the street near the mailbox.
How well do you remember the 2 people you saw?
I don't remember details. I couldn't see their faces, but I remember the neighbor across the street has a work truck, and they were very close to it. Like the man standing could have leaned against it, but he was standing very close to it.
At that time, did you recognize either of the 2 individuals?
No. My first impression was, great. A couple guys have been out drinking, one passed out, fell down, and the other buddy's calling for a ride.
So you indicated one individual was close to a work truck, standing close to it. Where was the other individual?
He was lying on the ground.
And what orientation? How was he lying down?
I believe he was on his face.
How certain are you of that?
Fairly certain.
Did you make any other observations of the person standing close to the work truck?
I did. I thought it was odd that he remained on the phone the whole time.
How did you know he was on the phone?
Because each time I looked outside, I checked 3 times, and he was still on the phone.
And you said you checked 3 times. Were some of those times later?
Yeah. So
okay.
The first time was just when I looked outside, and then I opened the door again. I said, "Do you need help?" And he said, "Yes." So closed the door again and called 911. They said they had already been called.
We'll get to that in a second. Why did you ask if they needed help?
Because somebody was laying on the ground. I wasn't sure if he was passed out or if he was hurt or what had happened.
You indicated you checked a couple times to see what was happening after that or to look outside. Is that correct?
Yeah, I didn't know the people, so I didn't want to go out there. I don't move very fast and can't protect myself very well. So being as how they were strangers, I kept my distance.
So how did you look out? How did you observe that?
I stepped out the front door and looked across the street.
You don't have like a front window that you look out of or anything?
I do. There's blinds, but it was just easier to go out the door and look.
So other than asking if they needed help, I think that's the way you put it. Did you have any other communication with them?
No.
Do you recall anybody saying anything other than yes?
That was it.
All right, we're going to step aside here. Still ahead, the neighbor continues her testimony in the returned mail murder trial.
And days after a couple was found murdered on a popular walking trail in Arkansas, a suspect is in custody. Crime and Justice correspondent Matt Johnson will have the
office and your bond in this matter shall be revoked. Now, he is entitled to a pre-sentence investigation report. Is that correct?
Yes, Your Honor.
Okay, then I will be sure to order one. Again, that takes approximately 30 days to complete. So we'll need to come back for sentencing no earlier than 30 days. When would the parties wish to return? I have the week of August 25 or September 2 for sentencing to be set. The same week as Mr. Whitaker? Okay. Are you all available to return the week of September 8th? Keep in mind, Monday would be a to-be-set date, and we would set the sentencing on a convenient day that week for all parties involved. Okay. And on the 8th, you all are free to appear via Zoom. That's just a scheduling date. That won't be the sentencing date. We'll pick a date on the 8th. All right, then we'll pass Mr. Robinson's case to September 8th for sentencing to be set. All right, thank you.
Well, he was found guilty today. There's been a lot in court today. Peanut butter and jelly on a really nice cracker. I love these. They're real thick. They don't fall apart when you eat them. Hey, Tinkatoo, thank you for coming back. Thank you so much for that, Evangeline. Has anybody called you? Well, you go by Evangeline or Evangeline? We are coming up on 19 hours of deliberation. Flash Fan, you've been great today. Thank you so much for all your help with this case. I have been watching and looking out for LaCorey Richard's hearing. I don't see anything yet on YouTube. If anybody should see anything, let me know. Let's watch this for a minute. This is on the flooding that happened here in Kerrville.
Good afternoon. My name is Nancy Zadunkowitz, speaking to you on behalf of Hunt, Texas today. I was at our
It's real low.
in Hunt on July 4th. We're just down the road from Camp Mystic. My family has had property on the South Fork for nearly a century. My mother went to Camp Mystic, so did I. We've weathered many storms, but July 4th was completely different. Our home is 35 to 40 feet above the normal river water level. And by the time my father happened to wake up at 3 a.m., the water was already at the house. And we had no warning. Within minutes, the water was already covering the yard, which is how I injured my ankle. And we raced to our cars. We drove out onto Highway 39. There was nowhere to go. All the routes to higher ground on the other side of 39 are fenced, and the water was rising too quickly for us to try to make it to higher ground on foot. So we climbed on top of our cars, and then we climbed into cedar trees, and I had to help my 66-year-old mom. Our cars flitted away soon after that. We ended up staying in the trees for several hours. We watched other cars shoot down the river and massive trees, and we just prayed and planned for what we would do if our tree was the next one to fall down. Several of our dear friends and neighbors lost their lives that night, people we've known for a lifetime, so we're actually very, very lucky. But our house was swallowed by the river. The community that we love has been devastated. Our house is now, stripped down to the studs. And so today I'm asking for your help because this community really needs help with recovery, and we need preparation for the next flood. Had there been early detection of the rising waters and sirens, we may have been able to leave in time to get to higher ground safely. I heard someone else say that they didn't think that that was necessary or would save lives in Hunt, and they are dead wrong. And frankly, that's offensive. There need to be more evacuation routes. There was no place to drive to on 39 that would have taken us down before it didn't take us up. So we need places to be able to drive that aren't private and fenced if we had that warning. More lives also could have been saved if people were able to warn their neighbors, but we have no self-service in Hunt. And when it comes to recovery, I specifically want to ensure that efforts focus on Hunt, which was the epicenter of the devastation, followed by Ingram. This is where the most lives were lost. This is where the most homes were lost. By the time we got to Kerrville, we were like, oh, we're finally safe. And so I really want to ensure you that, or want to plead for this city not to cannibalize the recovery funds and efforts just because there are more people who live in Kerrville. And I also do appreciate that, people in Kerrville were affected, but I just want to emphasize the need to focus on Hunt and then Ingram. The permanent residents of Hunt, obviously.
Center Point, Comfort, all the way down to Canyon Lake.
Come first. They need housing assistance and mental health resources and help to rebuild their homes and businesses and lives. But you should also know that almost all of the riverfront homes on the South Fork are generational family vacation homes.
They are.
These are the homes where
100
people
years.
stay when they drop their kids off at local camps, and their families support the local businesses here, like Kreider's and Hunt Store, year after year for generations. We pay property taxes. We are part of this economy, and we are part of this community. And so these homes suffered the most damage, and families like mine don't know how we'll ever be able to afford to rebuild. And so because we're not eligible for FEMA funds, because many don't have insurance, it's a real question whether or not Hunt comes back if these homes also don't come back. So, thank you for listening today. I know that the state has the power to act right now, and so my ask of you is that you please prioritize this over everything else this special session. Please, we need your help now. And I know that the governor has the power to use emergency funds today, and this is an emergency. And with that, I will turn it over to my friend. Thank you. Thank you.
Okay, guys, I'm going to say something about that. A lot of these homes have been along that river and have been built and cared for and added over the years. My gosh, they're beautiful rock buildings that were the limestone and the rock and everything that was used to build those old homes. And some of the cypress that was used for the cabinetry and everything was gorgeous. No verdict yet. Was gorgeous. And okay, I saw the clock. It was stopped. I was panicking. So, but some of these people are more wealthier than others. And because they were not in the flood zone, they did not have insurance. for flood. It's kind of like you make just too much money to not get help, but not enough money to rebuild. It is horrible. 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 I've driven that route probably 8 times since this disaster, helping people, and breaks my heart because I know some of these people that live there. In fact, I stayed at one of their homes when I lost my husband, and I need a place to shelter in my storm. And it was out there on the river. It was an old, beautiful home. It was a piece of heaven because you were so isolated. The one thing I've always complained about is why some of these people may not have received the warnings is because there is almost little or no cell tower reception in that area. There's a lot of pockets of no cell towers anymore because the cell tower companies don't want to put them out there because it's real hilly. And that is, to me, an injustice. It's not about money. It's about safety. There are people out there who have to purchase a satellite phone just to call 911 if there's an emergency on their property. And people have tried to get towers out there, tried to get these cell companies to put more towers out there, and they won't do it. We already pay a ton of money. I mean, don't we all? Don't we pay a ton of money for our self-service? Why is there not more towers in those areas? Why? I don't get it. There's no reason for it. We used to have better cell service. T-Mobile bought Sprint. And when we had AT&T, T-Mobile, and Sprint and Verizon, all 4 in this area, Hunt had better coverage. Other areas had better coverage. Well, T-Mobile bought out Sprint, and after a year or 2, their contracts ended with AT&T, Verizon, and all the other carriers because, they share towers. They did not renew it, so therefore their coverage zones went like that, and that's where we are. That's why I don't have T-Mobile. I won't, because they cut off a chunk of tower and coverage in the Hill Country. So that's where we stand. Okay, we're going to go over here. We're going to go back over to Court TV. Oh, I need to be here. There we go. Get the sound on.
And I stopped it at 122. Ms. Mashik, do you recognize that voice at all?
It's rather muffled in my ear. Sorry.
So
no.
Keep listening, please.
Michael, the audio is kind of muffled. She even said, I can't really hear it, but boy, you could hear those gunshots.
They were devastating to listen to. And, sometimes you talk about seeing something on video can affect you. Hearing that can affect the jury.
You. Absolutely. Yeah. All right. We do need to take a break here. When we come back, though, more testimony in the returned mail murder trial.
Also, as rap mogul Sean Diddy Combs tries to get released from jail ahead of his sentencing, he's now added a new twist in his fight for freedom. We'll have those details for you.
And actor Gary Busey unsuccessfully tried to get sex crimes charges dropped against him, and then he made a surprising move in court. Those stories and more when Court TV Live returns.
Tonight on Closing Arguments, jurors are weighing the evidence against 2 parents accused of trying to kill their daughter. We're diving deeper into key evidence as deliberations continue.
Closing Arguments, tonight at 8/7 Central, only on Court TV.
These are the cases that captivated the world.
Couldn't keep my life straight. They were killed by their own children.
That challenged the legal system and ourselves. Court TV Legendary Trials.
I'm looking up something real quick. I just saw something. I'm going to see if I can get. The judge has Alec Baldwin lawsuit dismissed by judge. Baldwin's lawsuit was for malicious prosecution and civil rights violation in retaliation of the fatal shooting of the Rust movie set. So Alec Baldwin had a lawsuit against, I guess, the prosecution or the county, and it was dismissed. I find that interesting. I'm trying to find it supposedly came out today, but I can't find the link. Anyway, that is where we are on that little baby. We are still in the verdict watch for the Ali trial. Unfortunately, we had a question earlier today, and it was concerning the, I guess, pretty much a definition for the kidnapping versus what a piece of crap, piece of fortune he is in jail. I don't know, Luca. I think it would be great if they did. Everybody's ready. I think this is getting a little tiring. The political people. Yeah. Yeah, go ahead and put it in comment. I'll pull it up. I think, honestly, what I'm not saying whether Alec was guilty or innocent, but I will say what Morrissey did and the way that they handled this case, to me, the way they handled this case was so inappropriate and blatant, and there should be consequences for that, in my humble opinion. Luca, go ahead and send it. It's okay. And he very well may be. I'm not going to choose sides on that one. But he, guilty or not, he had the right that everybody else has. And I think that they played dirty pool. I think if they would have played by the rules, then we would have had a very different outcome. But when you don't play by the rules, even if the person is guilty, they go free. So the victims are re-victimized all over again. Not first degree. I agree, second degree. I don't think it was first degree. I think, if anything, it would have been second degree. But my frustration is that why would the prosecution sit there, manipulate and pull their crap and risk losing the case when it was not necessary to do so?
Breaking news, we have a verdict. We've been waiting 3 days of
Yes!
deliberating. This, of
There you
course,
go,
is the
Luca!
case out of Washington State.
Got verdict.
Where Ihsan and Zahraa Ali have been accused.
Finally! Verdict. We have verdict. Woohoo! And so that puts us at what time frame? Just over 19 hours. What was my thing? 19 at 4:39. Probably about 19 hours and 15 minutes. Yeah, I know, right? So now we're waiting for everybody to come in. It may take up to 20 minutes. Let me go to X. I told people that I would put it out there. So let me get out there and go to my home. Oh, come on. I'm trying to add to my feed. Why won't you let me do it? Come on. I'm typing. Why can't I type? Thank you. I figured with this is their long weekend. You know, they don't have court on Fridays. I was anticipating that they would do everything they could to get it done today. Okay. I posted it. Okay, so I posted it there so people follow me will see it. Wait. Oh, you think the verdict. Oh, God, it can be so many things. What I'd like to hear it be, guilty on both counts all the way across the board. Why I say that about mom. I know mom could have been was brainwashed. I know it's cultural. I know she knows no different. I get that, okay? But if she was not, why did she not go to her daughter and try to help her daughter? Why did she not, after the fact, go do anything with her daughter? I mean, it was all about the husband. She did not care about that child in any way, shape, or form. Even if she suspected that he may attempt something, once they were in public, she could have tried to stop it. I know she wouldn't have because of her culture and beliefs. I get it to a point, but under the law, she made no effort to stop or to impede what was going on. None. No, Aaron, really? Really? Almost 20 hours of waiting and you're going to miss the verdict. What? Oh my gosh. It's my humble opinion. I think she should be held accountable. She could have called the police and said, "Hey, this is going to happen." She could have, she may not have been able to go to the school, but if she was in a separate vehicle from her husband, if she knew that this potentially could happen, that's if she knew, she could have contacted the school. She could have contacted the police. There were things that she could have done if she did not support it. Obviously, she supported his behavior. Oh, did you catch me on Twitter? Now you're going to stay up for the verdict, huh? I know. Welcome in from Australia. The Dubs. I love your thumbnail, by the way. Nice bike. I don't ride bikes, but I appreciate them. There is a verdict, Phoenix. Everybody start sharing. We have a verdict. We have a verdict. And I just posted it there so people would see it. So, yep. Not working, not lurking, just working. All right. Well, I'm glad you're working. I'm not going to worry about Corey right now. We will deal with that. I will delay that because I can go back and do that later if it even comes up. I may just delete that live. We'll see. This takes priority. Oh, it's live. It's live. You see the thing running. We have to wait for everybody to get in the courtroom. So we're waiting for everybody to get in the courtroom. It can take up to 10, 15, maybe 20 minutes. So don't worry. We're all here for it. Luca, thank you. Oh my God. Siba, you got the free membership. You got the gifted membership. Thank you, Luca. Hi, Rhonda. How are you? How are you? Uh-oh. Oh my gosh, I can feel the thud 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 on my ear. It sounds like there's people moving in the courtroom. How can I put the audio live, Brooklyn? Where? Hi, everybody. Thank you for joining. Where do I find the audio? Oh, why, thank you, Ada. Let me look. I don't see. Okay, how do I find lives? I don't see anything with lives. I'm not versed in X. I barely go in there, so I don't know how to find it. So, yeah, I don't know how to find this. Sorry, guys. We are usually Monday through Friday. Please, no spoilers. I'm going to keep that up. Can somebody help me potentially find a way to do it? Because I have no clue. No, I'm Monday through Friday as long as there's a jury going on. I'm on Court TV Live. That's the feed we have up in front of us right now. So I am looking on X. Thank you. I've got this channel a few times, but haven't. Oh, yeah. I'm looking. So 19 minutes ago, Little Lee said that she thought they might be deadlocked on one of the charges. Well, guess what? Nope, we got a verdict. Excuse me. I'm looking. I don't see anything yet. Well, you know what? At least it's up. They said they were going to have a delay. Walker, are you in our Discord group at all? Please let me know. If so, will you private message me? But I am searching. I'm thinking we have 15, maybe 10 minutes before it comes back to live. Okay, guys, I appreciate that. Okay, I hate to say this, and I know I may lose people. Please don't talk about other streamers who are streaming what I'm streaming live, because what happens, my numbers plummet. And I've already had people jumping off. Not trying to be mean. I do support other content creators, but when we're in a situation like this and y'all are bringing up other YouTubers, then my numbers start dropping. And I'm not trying to be mean. I'm not upset at anybody, but just kind of, please be respectful that I'm fighting for the same numbers they're fighting. And most of them are a lot bigger than I am. For like right now, they have 640 people watching and I have 86. And my numbers we're going up now. They drop every time you mention. So please don't do that. Yes, there is a verdict. We are waiting for the verdict. Yeah, we got to wait for everything to get settled. So, hi, Skylab 2300. I'm 2300, 2023. Yeah, so please understand, I'm not upset at anybody, but it does hurt my numbers. Really? That's a big compliment there. I don't know. That makes me a little nervous. Yeah, I don't like it either. I think it's crap that happens. But when somebody has almost 700 people watching them, and yeah, mine start jumping ship, it's hard. And I took off monetization on this live because every one of my lives with right in the last week, I had to share monetization. And when you sit there and like, if I had 4,000 views yesterday, total views of my live yesterday, and I got 0.002 pennies, not even 1 cent for 4,000 views. Wasn't worth it. We're weedy bitty little whittle biddle channel. They require membership to chat or subscription. We used to mods, don't we have to? You don't have to be a subscriber here to chat, right? I thought we used to be. No. It's okay. It's okay. I sometimes have to remind because I also have people in other media formats who are doing the same thing. It's not always just YouTube. It's X, it's Twitter, it's Twitch, it's Facebook, it's YouTube. So yeah, you're all good. Love you, boo. Yep, it just popped up. Now, I will tell you guys, sometimes like my courtroom TV feed popped in about 3 seconds more faster than maybe another content creator. Depending on where we are in the state, sometimes it's kind of like a slight delay by minute.
We are present on
Hey everybody, here we go.
30234 and 241132534 State versus Ali. We have been informed that the jury has a verdict in this matter. Ms. Stone and Ms. Zoe are present on behalf of the state. Mr. Kading is present with Mr. Ali and representing Mr. Ali, and Mr. Leary is present with Mrs. Ali and representing Mrs. Ali. I was told that in addition to Court TV, that there is a representative from Como TV who is present and who has requested or is intending to use the feed from Court TV. The representative has previously been in court and approached the court, and the court has previously advised the representative of the requirements and prohibitions related to what can be recorded from this proceeding, and specifically as it relates to not using the names of minors or showing the faces of the minors or the alleged victim in this matter, and that remains. And do you understand that? Thank you. Ms. Stone, any issues before we bring the jury in?
Not from the state, Your Honor. Thank you.
Thank you. Mr. Kading?
No, Your Honor.
Mr. Leary? All right, please bring in the jury.
Okay, I'm going to be writing and trying to hear this as much as I can. I know everybody's like, just shy of 19 and a half hours. 19 hours and 15, 20 minutes. Woo, they're coming in hot. Mr. Ali does not have his ears in. He's going to be able to understand this. He understands English way too much.
Please be seated.
They also had to wait for the interpreter to get there.
Juror number 11, are you the presiding juror? Could you please provide the materials that you have to the bailiff? I need to first verify that the verdict forms are in the proper format, so that's going to take a moment.
No, that's a lawyer next to each one. The interpreter is to the right at the end of the table of Miss Ali. Both of them have headsets, but Mr. Ali is choosing not to wear them. This is the moment. This is the hour. Yeah. I wonder if she is going to show any emotion, because they've both been stone-faced this entire trial. Thank you, Jane, for being here.
Forms are...
Everybody, all of you.
The verdict forms are filled out correctly, and I will now publish them.
I'm nervous. And I need to come
the jury find the defendant, Ihsan Ali, not guilty of the crime of attempted murder in the second degree as charged in count 1.
Oh my God. Not guilty.
We, the jury, having found the defendant not guilty of the crime of assault in the first degree as charged, or being unable to unanimously agree as to that charge.
Come on, my ears. Okay, do y'all have sound?
Ali and Fatima Ali, members of the same family or household. Answer, yes.
Sorry, there were names. I thought it was my ears.
The jury find the defendant Ihsan Ali guilty of the crime of unlawful imprisonment as charged in count 3. We, the jury, answer the question submitted by the court as follows. Were Ihsan Ali and Fatima Ali members of the same family or household? Answer, yes. We, the jury, find the defendant Ihsan Ali guilty of the crime of assault in the 4th degree as charged in count 4. We, the jury, find the defendant Zahraa Ali not guilty of the crime of attempted murder in the 2nd degree as charged in count 1.
Yeah, that doesn't surprise me.
We, the jury, find the defendant Zahraa Ali not guilty of the crime of assault in the 2nd degree as charged in count 2.
Yep.
We, the jury, find the defendant Zahraa Ali not guilty of the crime of unlawful imprisonment as charged in count 3. We, the jury, find the defendant Zahraa Ali not guilty of the crime of burglary in the 2nd degree as charged in count 4.
Yep, not guilty across the board. Now she's got a motion.
Find the defendant Zahraa Ali guilty of the crime of violation of a court order as charged in count 5.
Yeah, she's a free woman.
I'm now going to poll the jury.
Did anybody get count 2?
I'm going to ask each of you the same question. The first question I am going
Did anybody get count 2 on Mr. Ali? I didn't hear that.
to ask is whether or not these are your verdicts. And then I'm going to ask whether or not these are the verdicts of the jury. Juror number 1, are these your verdicts? Are they the verdicts of the jury? Juror number 2, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 3, are these your verdicts? Are they the verdicts of the jury? Juror number 4, are these your verdicts? Are they the verdicts of the jury? Juror number 5, are these your verdicts? Are they the verdicts of the jury? Juror number 6, are these your verdicts? Are they the verdicts of the jury? Juror number 7, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 8, are these your verdicts?
So now when they get out of here and they find out that she was going to be taken to Iraq to be married to a 61-year-old, and this may have been an honor red room attempt. Wait, I'm not monetized. I can say murder. I wonder how that's going to change their opinion later. Oh,
Yes, Your Honor.
if that would change their opinion, I would be pissed.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 9, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes,
Juror number 10, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes,
Juror number 11, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury?
Yes, Your Honor.
Juror number 12, are these your verdicts?
Yes, Your Honor.
Are they the verdicts of the jury? Helpful, not helpful, and the like. So at this time, I will excuse you and have you follow the bailiff back to the jury room. Thank you.
I disagree. Nope. Yeah, me too. We're going to stick around, try and find some interviews. This is BS. I'm
Please be seated.
floored. And you know what? That also means that Mama gets those kids back. Yeah. She's free.
I expect that we would be addressing conditions of release as to Mrs. Ali, perhaps both parties, but as to Mrs. Ali. I don't know if you want to address that, Mr. Leary.
So, Your Honor, my client is being held on $500,000 bail, given that she was convicted and has served. So it's gross misdemeanor 0 to 365 days. Presuming good time, she would have served the maximum. I would be asking that she be released. Obviously, not sure when the court wishes to set sentencing, but obviously the no contact order conditions would remain. Travel restrictions would remain, and any other appropriate conditions requested by the state and imposed by the court.
She should go home.
Would ask that she be released on her personal account.
Thank you. Ms. Stone.
I think the question I have is how
long until we think we will be at sentencing. Certainly we are, I believe Mr. Leary is correct as to time. But I want to ensure that Mrs. Ali has no, barriers to being present for sentencing. So I guess that would be my question. If Mr. Leary anticipates sentencing would be next week, I would ask then that she be held pending sentencing next week. If it's going to be much longer than that, then I think Mr. Leary's request is reasonable as it relates to Mrs. Ali.
So, assuming that there's a third offer good time, she's been in custody 10 months, so she has served the statutory maximum with good time, which she is entitled to. So I don't see a basis. When we talk about the factors, there's no concern with administration of interference of justice in terms of, likely to failure to appear. She's never been charged. She did travel back and forth to Canada with family and had her 2 kids up there. She would understand that she wouldn't be able to travel outside of Thurston County. And she was acquitted of the violent offenses, and the only remaining offense is violation of a protection order. So I would ask that she be released.
All right. As it relates to sentencing, the complicating factor in trying to set an actual sentencing date today is that we have to arrange for interpreters for the sentencing. And I don't know the availability as it relates to that. I don't believe that we will have sentencing next week. And I am not here the week of August 11th. So I think we would be looking, hopefully, if we can arrange it sometime during the week of August 18th for the sentencing. But I will need court administration to work on the issues. What I would like to do is set a day, and then if we are unable to arrange for interpreters on that day, it could be reset so that the parties know the day we'd like to do sentencing, but that it may be altered.
Thank you, Your Honor. May I remain seated for the personal microphone?
Yes, of course.
Your Honor, then could we, does the court anticipate that the parties would coordinate that via email with the court's judicial assistant?
Yes, but let's just say right now, August 18th at 9 a.m. I was told that a Monday is good and 9 a.m. is good.
Can I put that on the 3-2
Yes,
order?
that's what I would like to do. And with that, Mrs. Ali has been acquitted of all of the charges except for violation of court order, which has a maximum penalty that the court could impose of 364 days in jail. Mrs. Ali has been incarcerated, since about October 22nd. And so she, with good time being a third off, and not hearing from anyone that she wouldn't be entitled to that, she has served the maximum time already that I could impose. And therefore it is appropriate for me to change her conditions of release pending sentencing on August 18th at 9 a.m. I'm going to release her on her own recognizance, and she will be released today. I would continue in effect all of the other requirements that I'm going to order that she not leave Thurston County. I'm going to order that she follow the no contact orders that are in effect. And I don't know if there were other conditions other than that. I think Ms. Stone will look that up.
I'm looking up Odyssey right now, Your Honor.
Nobody really saw this coming. At least they should have allowed in that the daughter was going to be shipped out of country, no return ticket home, and be married to a 61-year-old pervert.
I think that's it, based on the prior order, conditions of release set on October 24th of 2024, Your Honor. Standard condition of do not violate the criminal law, do not leave the state of Washington, do not possess dangerous weapons or firearms, and then I've included do not leave Thurston County, and abide by the no contact orders in this case, also no contact with the two previously noted victims identified in this case.
Jake, I want your honest opinion. We can be respectful, but I need your opinion.
So I will continue those conditions in place pending the sentencing in this matter.
We enjoyed having you, Jake. Hope you'll come back.
Worked on Ms. Stone as it relates to Mr. Ali.
Thank you, Your Honor. Mr. Ali is now facing a prison sentence. Since he has been convicted, he has lost the presumption of innocence and the right to release and bail. I would ask that Mr. Ali remain in custody pending sentencing in this case. Sometimes setting it for the same date and time, if that works for the court as well.
Thank you. Mr. Kading?
I would disagree as to him facing a prison sentence in this case. My calculations are he's looking at 6 to 12 months in this case. That would be on the assault 2 at one point, including for the unlawful imprisonment. He too has been in custody in this case for 10 months. He has reached the at least maximum of the standard range sentence. Having completed the trial in this case without any aggravating factors, I believe that his sentence would be limited to a maximum of 12 months as well. He was previously out on this case and follows all conditions of the court while he was out for 10 days between his arrest on the 18th and his remand on the 1st of November. Mr. Ali lives here, obviously, has family here, doesn't have any prior criminal history of any kind. I would ask the court at this time to authorize his temporary release pending sentencing and the same conditions as his wife, with the caveat that he be allowed to travel Thurston, Pierce, and King counties, as he has a business that he operates in King County that we need to be able to travel to those locations.
And Your Honor, Mr. Ali's score is a 2, not a 1. Both of those are domestic violence crimes. They count additionally against each other. His range at a 2 on the assault in the second degree is 12 to 14 months. It is a prison sentence, and his range on the unlawful imprisonment is 4 to 12 months. So he is looking at a prison sentence. The state's position remains the same.
All right. At this time, I'm not going to change Mr. Ali's conditions of release, except that now that he has been convicted of those 2 charges, I would revoke bail, which was previously imposed, and hold him pending the sentencing in this matter for August 18th at 9 a.m.
And Your Honor, I would ask the court to lift the condition of no contact with his wife in this case.
Right. Any issue, Ms. Stone, on that?
No, Your Honor.
All right. I would remove that condition.
I had the opportunity, while the court was addressing bail on Mr. Ali, to review the conditions of release with the interpreter, with my client. She has signed it. The interpreter has signed his name to the bottom of page 2.
Thank you. I have also signed the order that changes the conditions of release. Thank you.
But here's the thing. If he's not a U.S. citizen and he gets out, immigration time. Just saying. We don't know if they're citizens or not. It's not been made clear. I'm worried about the little girl. Well, she's 18 now, but still. What about the children, the little ones? Yep. 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 She's being released. She goes home tonight. As soon as she gets out of there, they'll go back to jail. She'll get her personal effects if she wants them. And then she's home back to her normal life. The dad goes back to jail. He will stay there until August 18th at 9 a.m. when they do sentencing. His time served will go towards the sentencing. So he most likely will get out because they also do good behavior and all that kind of stuff. So if he serves any more time after August 9th, it will probably be about a half a year. Roughly. Maybe 6 to 7 months more, from my humble opinion. I could be wrong. I'm not a lawyer.
On Mrs. Ali's case, I would just indicate that on page 1, the box that the defendant is released with the conditions identified on page 2 was not checked. I checked that box.
Yes, she is living in Canada with family at the moment, but the mother wants to go to Canada. That's where the mother wants to go. She's a martyr. Not really. What's the word I'm looking for? Yeah. Everybody in her country is cheering. No, I can't say that either. A lot of people in her boat are cheering. There were a lot of people in her faith and religion that were supporting her. Not right.
Yes.
Not right now. Not right now. That's right. Not right now. But as soon as she meets the conditions of the violation of court order, probably get probation. If there's any conditions put, as soon as that's done, she can leave the country within a year.
And that was reviewed with Mr. Ali with the interpreter.
Yes, it will.
Her conviction is not federal. Her conviction of guilty of violation of court order is not federal. That's a misdemeanor, isn't it? His may be,
All right,
but
I
hers
have
is
some
not.
of those orders, and I'm ready to recess. Before I do, Ms. Stone and Ms. Zoe, if the jury is willing, would you like an opportunity to speak with them? All right. Mr. Katie.
Felony. Oh,
and Mr.
felony. Thank you.
Leary, if the jury
Sorry.
is willing to talk with the lawyers, would you like to speak with them?
Yes, sir.
My sorry, June. Is hers? I don't think hers is a felony, is it? I didn't mean federal. I meant felony. I might get sleep today. 4 days of less than 4 hours sleep a night is killing me.
And I don't know, typically, we would sometimes catch them on the way out. I think in this case, it might be a good idea if you'd allow us back there. Because nope. Okay.
I can't allow you back there, but I would bring them into the courtroom and there'd be no one else in the courtroom and the media would be all turned off in here.
All right, that was going to be my question.
Certainly.
Sorry, Your Honor.
No, and
Okay, so they want to ask the juror questions about how well they presented their case, why they voted the way they did, what did they do or not do to give the results that they got.
it still stands. My
Verdict on father, guilty on the imprisonment, count 3, and on count 4, guilty of assault, 4th degree. That's it.
order that the jury cannot be photographed or recorded in any fashion. And we will not be in session, and so there could be no recording in the courtroom. All right.
He is to be remanded back into jail. His bond has been revoked. August 18th at 9 o'clock, which we'll put it on the calendar in a minute.
A good question.
Maybe I should do it now while I
Court will be in
forget.
recess. Thank you.
All rise. Court's in recess.
So I'm going to hang out here for a little bit because we don't know what we're going to get in a minute. We may get, so August 18th is also the first day of jury selection. And that will be the same day. I'm sorry, that is going to be the sentencing at 9 o'clock. That's 9, that's 10, 11 my time. Yeah, he's not going to get much. Okay, it's on the calendar. We got it. Too many people know about their extreme yeah. I was shocked to get this kind of verdict, in my humble opinion. We're gonna sit and wait a minute. We're doing my notes. You can't read my writing with crap, but maybe I can later. We'll see about it. We'll never know. I won't tell you. But yeah, I'm slightly disheartened by this news. Not the verdict that I wanted to hear. And I'm not trying to be, it's not what I believe. I just felt that they were guilty. Misdemeanor in the world I search for, the word I'm searching for, usually felony is incarceration 1 year or longer. Misdemeanors are less than a year. Yeah, I think this is a misdemeanor. Yeah, come on. I want to hear. Aww. Yeah. I'm going to mute this while we let it play and see what comes in. I agree. 90% of the people feel there was no justice. Yeah. Just did a poll. Oh, wow. I don't need to do a poll. I think we all feel the same. Fatima is not safe now. Not with her father for sure. No. Yeah. Technically, she's not been since this happened because mom and dad and family members are looking for her. Oh, yeah. And the sad thing is that, believe it or not, now this has happened. The family, even from Iraq, will come. Some of them can try and come over here and find her and unalive her. They've been known to do that. No way, Ronnie. No way. So we're gonna sit here and wait a minute. I'm going to start searching for some outside courtroom if we can find anything outside the courtroom. Reactions. Trying to see. Just trying to see. Okay, we don't have any reactions yet. Oh, no. I'm not saying anything yet. Everybody's waiting. All the feeds are waiting. Florida man found guilty of an NBA player's red room. I know. Yeah. Somebody else in this live would agree with you on that. Yeah. Hello, welcome. Washington's second-degree assault involves assaulting another person or either risky cause of substantial body harm, assaulting with deadly weapon, assaulting, strangulation. Okay, what was that? What's the penalty for that? I think it was a year. I could be wrong. Well, let me do this. Give me a sec. Hello, love. Yep. Okay, maximum penalty for Washington State. A second degree is classified as a Class B felony. Sentencing depends on several factors, including offender's history. Maximum up to 10 years, $20,000 fine. Standard range for first time is 3 to 9 months in jail, but it can increase significantly with aggravating factors or prior conditions. Aggravating factors such as weapons, strangulation. So there you go. There is an exaggerating factor. So they're going to score him. So 3 to 9 months. Probably that's a minimum he'll get. They can get maximum of 20, but doubt it. With score 3 or more, it's 15 to 20 months. So here's the enhancers. Aggravating factors with deadly weapon, no. Strangulation, yes. Cause substantially bodily harm. I don't think it was substantial enough for that. Along with the person who turned mandatory sentence. So I think I would be shocked if he got any more than a year. Any more than a year. In my humble opinion. So we welcome you. Thank you so much here. Hello, everyone. My 2 cents as a president for the other cultures can do it. Yep. Yep. Poor Fatima or Fatima. Yeah. Yep. Yep. You're right. But he's not going to get much. I would 12 months. There we go. It says right there. He's already served 8. He'll be out in less than half a year. Or he could be out on good behavior. We've already had it. The father was found not guilty on attempted murder. Count 2 was not guilty. He was found guilty on imprisonment and guilty on the assault in the 4th degree. That's what he got. Yep. Yep. Thank you for joining. Don't forget to sub, you guys. The judge said he will do prison time in Washington State, prison time 300 days or more. But he can get sentenced to prison, which is, say, 15 months, 2 years. But with time served and everything, he may stay in jail. Because if the remainder time is less than a year, he'll stay in jail. I get it. Most likely. Been found guilty. Yep. They get penalized for living. Well, hello, Fierce like Frida. I would love to hear what the jury has to say when they find out that information. Yeah. Yeah, right. Wooden spoon, coat hanger, fly swatter, shoes, broom, weeping willow tree switch. And we had to go pick our own. And we knew, depending on what we picked, she was going to make. If we picked one that she liked, it wouldn't be as bad. If we picked one that we liked, it was going to be worse. Just saying. Yeah. Oh, yeah. We're all on the same boat, Frankie Leroy. Well, the lawyer, his lawyer, is wanting to talk to the jurors right now. And so his lawyer and the other lawyer have asked to speak to the jury, I guess, to find out where or what was that helped them come to that decision. Yep. I agree with that 100%. Hi, Live A. Hi, welcome. Well, it's not the judge's fault. I mean, there are laws that she has to go by. And by allowing that information would have prejudiced the jury. I don't agree with it. On the personally and morally, I don't agree with it. But on the legal end of it, I understand why it was done. And I don't like it. Oh, military belts. How many of us have ever been spanked with the military belt from the 70s and 80s? That nylon tight rope, whatever it was made from, holy crap, barely touch you and you're screaming bloody murder. Looking at it hurts. Yep. Oh, not necessarily bigger, because sometimes the thicker, the less they sting. There was a range that we knew if it was too thin, it didn't hurt. And then sometimes if she wanted to really make us suffer and drag it out, she'd tell us to peel it. Take the knife and scrape it, get the bark off, just to torture us. Yes, it was done. And if she says she never did that, she's a lying. Joseph, immigration status wasn't an issue here. Your prejudice is showing. Well, we all have a right to our opinion. Don't have to agree, but I will say that we don't know what their status is. We know they came here. All but the two youngest, I believe, or maybe the three, were born in Iraq. So nobody knows what their status is. Let me. So. Yep. Yeah. Well, we can agree to disagree nicely here. Keep it nice. I don't have a problem with everybody's agreeing to disagree. Everybody, look at the comments up here, and these are the comments. I left it like this because I wanted us to be able to see their comments. Everybody is upset. Oh, yeah. The holes will belt paddle. My father was an industrial technology teacher, and he worked in woodworking, metalworking, auto mechanic, and all that. He made paddles for all the schools in the school district of Northside ISD one year. And they had a big hole by the handle and a bunch of holes in lines. And when you swing it and that air went right through, football players would cry. It got to the point that after they had one or two swats of that, they would see that and they would start sweating. I kid you not. My mother was a vice principal's secretary. She got to witness all the spankings. We don't have that anymore. He possibly can be. I don't know if they're citizens or not. If they're not citizens, then after he serves his time, he can be deported. Definitely. We don't know. Oh, I was adopted. My twin brother and I. I know. I know. See, the thing is, it's very rare do they survive, and she survived. The ones that don't survive, the people get life sentences. The ones who survived get a slap on the wrist. I don't understand it. Yeah. By the way, the no contact order for mom with her children remain in place at this time. However, the no contact between Mr. and Mrs. Ali has been lifted. And they can talk to each other. The sad thing is she's going to remain married to him. I'm not going to disagree. Oh, well, thank you, Karate Cat Mom. I barely ever got the belt. My brother, that's a whole nother story. Oh, their passports were removed if they had any at the time that they were arrested and put in jail. Well, I can't answer this fully because I'm not in the judge's mind. But from what I understand, the stigma and everything that goes along with their culture that a lot of people have about arranged marriages and honor unalivings could prejudice the American jury. That was my understanding. If anybody else has a better answer, go for it. I'm not a lawyer. I am a criminal justice major. I'm graduating at the end of December, but I'm not in the courtroom. I can't answer that. Yep. Oh, the father will be less than a year. We had almost 20 hours for that. Wait. Now I know why, because that must have been a lot of deliberating in that room. I would say not citizens because the excuse they used in court was they needed to go review their visas. Yep. I'm on the same boat. I agree with you on that, Tinkitude. I think you're right on that, but I can't say 100%. I don't know. But let me tell you what, I ain't going to lose sleep if they leave. I'm worried about all the kids, all of them. My dad let us use the pedal. Oh, shoot. Snap. I mouthed off to my mom. Mom's made the mistake. My dad's standing right there next to me when I did it. Yeah. I mouthed off to my grandmother once and my grandfather, who I was the apple of his eye and he mine. He never laid a hand on me. But that day he did. He back popped me, not hard, but popped me like that in the mouth. I thought my world had come to an end. And the fact that I upset my grandfather enough for him to do that, I wanted to crawl under a rock and die. That was the worst. Even though they've been here for 12 years, here's being, yep. Lady, why don't the jury take the consideration she should have been? Yeah, that's the thing. I don't understand that. I don't understand the imprisonment and assault to the 4th degree. I would consider it, well, it may be the way it was written in the charges and their interpretation. Oh, yep. I said that earlier, Denise Curtis. I said that. I said it's not unusual for men in the family to come to the country and find ways to unalive. Yeah, I did say that. And that would not shock me if that happened. I'm really concerned for Fatima's safety. I am. I would change my name. I would go into hiding. Oh yeah, right. Skylab 2023. So bad. Yeah. Well, Live A, thank you for joining us. I hope you come back. I really do. Depending on parole, they may have to stay in the U.S. and if not allowed to leave or travel internationally, like to Canada. That's right. Every state's different. Every single witness showed that the dad was guilty, and they had the video. Yep. Yep. Y'all don't forget to check the like button and comment ILIKED in the stream to be entered into the end of the month giveaway. That drawing will be done at the end of this live. Ooh, what kind of old magazines? Just saying. Yeah. That's kind of it right there. I'm not as upset over the mother situation as I am the dad, because you're right. And I believe, honestly, I know it, I'm going to go rub against some grains here, but I think the mother herself is a victim. And brainwashed, and she's going to victimize too, because that's all she's been raised to do. She knows no different. She has no freedoms, no liberties. She is a victim herself. I'm sure she's gone through hell as a young woman and a mother with that kind of a man. I'm really pissed with the outcome, and it smells like hell. Oh, that's bad. Mother would make me put soap in my mouth and brush my teeth with it as a punishment if I talk back to her. I remember the soap in the mouth, putting that bar and holding it, bite down and hold it. I still have the taste in my mouth. I just think about it, and that taste still hits. They can't leave the country yet because she has not been sentenced. This is not done. Somewhere in Canada. She came in for the trial, and I bet she's going back to Canada if she's not there already. I see it. Okay, let me get to a few more, and then I'll read this. I see it. I saw it pop up, Jen. FM, I'm sorry. I'll open up X and read what you say there if you're going to go over to my channel on X. If you make a comment in X on my channel, it will show up in the YouTube feed. It will. Okay, I got it up over there. So if you say it over there, it'll pop up on my, it'll not fit up. It doesn't pop up in YouTube. It will pop up in my StreamYard, and I can pop it up. So FN, go to my X, make your comment over there, and I can pop it up over here. Thank you, Ronnie. He's guilty. Yeah. Yep. She's controlled by him and all the men in her family, not just him. I lived in India a few years, and it was horrible. What was done to women and female children? They were selling her to some old man in Iraq. Yep. The daughter. Oh, you're in the UK. Okay, Amanda. Okay. We have some, oh, that's a good comment, Amanda. We have some amazing Muslim families. I believe that. I believe that to be true. But this is the bad apple. This is the monsters. Uh-huh. Yep. I agree. I don't disagree. I said that earlier. She could have stood up once he was restrained. She could have defended. She didn't. Once again, we think in Canada. They will not be allowed to travel even into Canada until they completely exonerated. Washington will not allow them to cross the border. We're going to read that right now. If you enter Canada with a felony conviction on your criminal record, could be deemed criminally inadmissible into Canada and denied. Temporary resident permanency may be issued to individuals who would otherwise be inadmissible to Canada because they were convicted of a crime permitting them to enter or stay in the country were justified by compelling circumstances. With a DUI, that's what we're looking for. Criminal rehabilitation. Can I enter Canada with a felony arrest? If you've been arrested and accused of a felony crime, you may be criminally inadmissible into Canada, even though you have not yet been convicted, even with no prior criminal history. Immigration officer does not require to presume innocence and can use discretion accordingly. Unless a person has proof of favor, settlement, or non-conviction result, the Canadian border may refuse them entry, even if it's a misdemeanor or a felony arrest appears on the record. There you go. So, yep. Thank you so much for that, June. Yep. I really wanted justice for her. She was such a brave girl. Very brave young girl. Thankfully, most are not. Yeah, families is in Canada. Who sent her there? The baby will be in Iraq unaided for in a month. Yeah. There is a young one, what, 2? Something like that? No, absolutely not. I don't think she's 18 now. She's not going to go back. Yep, no girl child in that family's safe. Ain't that the truth, Amanda? I'm devastated with the verdict. Yep, we all are. Mothers are worse than the husbands. The men grace over the wives and their family. Yep. The honor of the family depends on the honor of the woman. Yeah, she is 18 now. Yep. Oh, that's what I want to hear and see. Yep. And we're caught up. Yeah, I saw that. A little interesting. I think, it's bad enough when you have a father that you believe is trying to kill you and your mother is not really trying to help, but you're going to live in denial because you want at least one of your family parents to love you. I don't know. I think that, and I can't judge the mother's heart because none of us can. But I will say that when your heart and your honor are two different things, she may love her daughter, but at the same time, her daughter chose to dishonor the family in her eyes, and she has to be punished. It's more important to the wife. It's her family name is ruined. Yep. The entire honor of the family is based off the female line. If one of the daughters was EPAR'd or actually assaulted, they will unalive her. Even if she herself had no control over the situation, they will unalive her because she's impure, and that breaks the family honor. I know. Yep. That's right. Yes. Uh-huh. That's true. Yep. Well, that's the other thing. Her sister very well could potentially try to unalive her herself. In fact, I think she already did. Yeah, I think she already did. And that is a big deal. Okay, I need to try and find. I don't see anything about interviews. Does anybody else? Yep. Oh my gosh. I could not imagine the hell that little girl was going into over there. It's hell. And she's not the first wife. So she's not the wife. She's those multiple wives. So she was low down on the totem pole. So not only would she be sexually abused and EPAR'd and everything else, she also would be forced to take care of all the other wives because the younger one takes care of the older. I guess so. I have no idea. I hope somebody will speak. There's no interviews, nothing. I'm waiting. Oh, I'm that of this early 70s. Mine didn't either. My mother was the one that was worse, though. She would, of course, Dad was gone well, she worked too, but she got off before Dad did. And, Mom would punish, and then she goes, wait till your dad gets home, and that was the worst. Wait for Dad to get home to find out if you're going to get your butt beat or not. I don't see anything about this at all. Don't see anything. I don't see any interviews or anything. Yeah, I'm waiting for that. I'm waiting to hear from the jury. I'm looking, y'all. I'm not seeing anything. We may not have anything today. Yeah. That was something else. Thank you. You're so right. So, well, I don't know if the family's been fully paid, but when you make an agreement for a child for marriage and that child for some reason doesn't get married to that person, they still owe them a child for marriage. It doesn't just go away. And the family themselves can be unalive for not honoring it. Yep, that's right. After clicking on the thumbs up, comment I liked in the comments to be entered into the end of the month giveaway. We don't have very many. We only have 19. Oh, you know what? What bothers me is around the men in his culture, he's seen almost like a hero, standing up to the government, getting found not guilty. That bothers me greatly, greatly, that he's going to be looked upon, and the other men in this country are going to be just like him and try to get through all this. I mean, they're going to do the same thing. You see what this said? Oh, yeah, Veronica, I'm just now seeing that. That is so funny. Member chat. I'm going into our Discord real quick. Yep. Yeah, good one. Oops. So it is 6 o'clock my time. I'm going to hang for a little bit more. If anybody comes across a video, I'm going to start. We've been live for 6 hours today. Yeah, yesterday it was 9 hours. That is frankly, you're right. Cows, goats, all of them worth more than a girl. They will kill you and save the goat. Yeah. They will kill you and save the goat. I'm trying to find. I'm not finding anything new. I have this video I want to share on a live. My parents tried to kill me. I'm going to share this.
And I was in a lot, almost as though they were determined to kill me. And all my life I'd been threatened that we will bury you under these floorboards. And I really believed they would. And within no time, they'd broken my jaw. They had broken my arm. And I was in a lot of pain.
Were you the only girl in your household?
So I'm the youngest of three. I have two older brothers, and I'm the only girl born in my immediate family, but also the only girl in my extended family, with my father being one of 7 brothers. My normality was such that I was kept in my room at the age of 6. My room wasn't like a child's bedroom, whereby it's got nice furnishings and soft toys. It was very bare, brick walls. The only time I was allowed out of my room was to go to school, or my mother would call me to cook, or I would be called to do another chore like washing the plates or dishes or the clothes, because we didn't have washing machines. And I had no interaction with my family. I didn't make eye contact. Girls are told to look down all the time, and I still have a bit of an issue making eye contact with people, primarily because we get hit if we make eye contact. We get shouted at. So I was non-verbal because I didn't engage in conversation with my family. I had to nod, not speak. I used to press my ear against a very rough wooden door and listen into TV programs and pretend I was sitting with my family. But my friend at school would walk me to school and sing me all the songs from Top of the Pops, and that's how I knew a lot of music. I amused myself with books. I've got a love of books still. I used to take as many books from school as I could because they were my friends. I would name them. And I really believed in fairy tales and that I was Rapunzel. And then one day I would be saved from my room.
What was your relationship with your parents like?
I was very scared of my mother and father. And a lot of people don't understand that women play a big role in my community as much as other communities that are like mine and cultures that are like mine, whereby the person that would call me out of my room would be my mother. The person that was watching a lot of my abuse was my mother. And she herself was very angry all the time just by my existence. I wanted to please my father. I would go out of my way to do things to make my father happy. By that, I mean I would cook food as quickly as I could and most kids have a toy they remember from their childhood, but I remember he brought me back a blue crate that had bottles in it, and I turned it upside down, which meant when I was a little 6-year-old, 7-year-old, I could reach everything so much quicker in the kitchen. And I felt maybe that was an extension of his love to me as well.
Think about that. He brings you a crate so you could be elevated, so you could work harder and more. And that's your gift. And all you think of is you want to please your father. You want to please your father. I am like, what? Oh, no.
And you mentioned that you were able to go to school. What was school like for you?
So school should have been an escape, and it was to a certain point because of the books, and the teachers were quite pleasant.
Okay, I apologize. I've got to take a comfort break. I'll be right back.
But I was the only person of colour in my school with my brother. So you would hear the word scrap and people running, and it was because I was being piled upon and beaten, or it was my brother being beaten. My hair was pulled, I was spat upon, and every day was a bit of a battle in a different way. I had literally a couple of friends because nobody wanted to be my friend because they too would be picked on. But the ones I had were very loyal and very loving, and I wasn't allowed a lunchbox. And my first experience of jam sandwiches was because my friend offered me one of hers, knowing that I wasn't getting any food at lunchtimes. And, you know, I remember making that little jam sandwich last for the whole of the lunchtime so I could be part of the lunchtime community, sitting inside instead of sitting on a bench waiting. So my father, from the age of sort of 7 upwards, would bring back a group of his friends, and I knew them all. And in my culture, you don't say names, you say uncle or auntie to anyone that's older than you. And they would come and they would eat and they would drink. And my father owned a lot of pubs. So my father was the place to go to because he had the alcohol. And, you know, he would come back from the pub, and my mother was the one who would wake me and say, go down. She would go back to bed, and I would go and cook rice and chapatis and chicken and some vegetables, and I would take them on a tray. Then I would sit on the bottom of our large wooden staircase waiting for them to finish because my father didn't like mess. And when I got to 14, my mother woke me up, and instinctively I had this horrible feeling. I remember taking the food in and waiting, and I remember thinking, I don't want to go and pick the dishes up because they were exceptionally loud. They'd started to bring bottles outside. My father used to put the empty bottles outside, and there was bottles of Johnny Walker all lined up. And then when I did get the call, I went in with the big tray that we had. It was a big white tray, probably bigger than me. And he grabbed my wrist and the tray fell down. And he was the first person to throw me onto the table and rape me. I didn't know what was happening. I was too young. I closed my eyes. But I lived without the ability to see. So I knew each person's sound of who it was, each person's touch almost. And it was a very horrific attack by 7 or 8 men on me. And I was thrown from person to person. I was beaten. I was bitten. And eventually I must have passed out. And when I came to, it was because my mother opened and closed the door and woke me up. And I remember not having my bottom part of my clothes on. And I was literally lying in a bath of my own blood. And the first thing I thought about was, there's food everywhere, on the walls, on the floor, and I'm going to be in so much trouble. I didn't actually give myself any consideration because I believed I wasn't worth anything, because that's what they had taught me from birth to believe.
So this is what Fatima has to, may not be identical, but this is their beliefs.
You mentioned your mother, so how
Virginia
did you
Little,
respond?
Virginia Little, thank you so much for joining all of you. Skylab, human being all of you, Denise, Brooklyn, I can't list everybody. Penny, thank you so much for joining.
After this attack.
Well, my mother was the one who woke me up. As I said, she opened and closed the door several times. And she was angry, you know. It's all about perception. I look back sometimes and I say, could she have done anything? Did she show any act of kindness? And I know that she was the one who gave me a new set of pajamas. Was that an act of kindness, or was she just doing that? I don't know, but she could have at some point just come to see me and stroke my hair or give me some comfort, but she was just angry and almost made me feel that it was my fault, that I had asked for it, that it was me that had instigated the whole attack.
Hello.
I was so naive. I didn't.
Yeah, they were only convicted of, the father was convicted of imprisonment and aggravated assault in the 4th degree. And the mother was for violating the judge's orders.
Understand what happened. You know, we don't have conversations about periods or sex or relationships in my culture or cultures like it. It's a taboo to even think about it. So I just knew it was wrong, but I didn't. School back then didn't teach us these things. And all I knew is that it was wrong, and I didn't feel like me anymore. She allowed me to have a shower, and I was never allowed to shower. My brothers were. They used to make me have bucket baths, which meant you have a bucket and you fill it up, and then you use a jug to wash yourself. But on this instance, she told me to have a shower, and again, I thought maybe she was being kind, but the shower really stung. So where I'd been bitten, where I had open wounds, it really stung, and I kind of wished I had had the bucket bath. But after that, I had just asked her if I could go to sleep because I was in so much agony. I was in a lot of internal pain naturally, but the mental pain was almost that I felt broken. I just felt like that was it. That was the end of me.
And were you living in fear that...
I brought that up the other day, Ronnie. Remember, I brought that up. Was there somebody of like mind on that jury?
Something might happen again?
I used to walk in with that tray with my legs shaking from that day forward. So every Friday or Saturday when my father would bring his friends, I was visibly shaking and scared because I was sure they would try to do something
You're
again.
welcome.
And then not knowing, it's torture. There's no other word for it. But it was always upon me to go and face them every weekend and give them this food. I turned 15 and I realized I was pregnant, and I told my mum that I was no longer having periods, and I didn't know I was pregnant, but she told me that I had spoilt myself. My dad was called immediately. He came and they both sent me to my room and they were shouting at each other, and before I knew it, I was in the car, and I'd never been in my father's car, and I remember it was a blue Humber Scepter, and I'm sat in the back looking at the trees and the clouds and wondering where I was going. And they took me somewhere in the West Midlands to a clinic, and I remember arriving in the clinic and there were lots of women. I remember the whole procedure, and this was the clinic where I was going to have an abortion. The thing I always talk about is the act of kindness from this whole experience of this abortion, because it was the first.
Well, Joe Schmo, how are you? I texted you, boo.
Time someone had actually extended
Hopefully
love
drive
to
safe.
me.
Be safe.
And it was in the form of a lady where after the procedure they
By the way, Joe Schmo, yes or no? Are you going to be here?
Make everyone sit
Anytime.
on a grass verge, and I had my sort of clinic gown on, and she brought me a cup of tea. But it wasn't the tea that she handed me. It wasn't the fact that she handed me tea. It was the fact she reached out and touched my hair and stroked me in a very maternal way. And I think it doesn't matter how old you are, we all crave love. And I realized at that point I really was craving some love from another.
Wait. Whoa, back it up. Are you going to be here tomorrow afternoon and do a live? Or are we going to do a live the next day? Which day? Friday or Saturday are we going to do the live? Because I need to get the studio set up. Just saying.
Another human. And I realized as well that maybe I wasn't as bad because she didn't catch anything by touching me. And I was told all my life and believed it, that if someone touched me, they would catch this evilness that I was containing.
We're good to go, Joe.
And when we got home, on the way home, my parents were really upset, saying, what are we going to do with her? This is such a problem. Nobody will.
Sorry, guys. And I'm going to drive Joe through the 80% of the, or if not more, the flood zone. I live in Kerrville. Anybody who doesn't know, I'm AdaKay. Thank you for joining me. I live in the beautiful hill country, the town called Kerrville, where the 4th of July flood happened. I am safe, but my home was okay. My yard, we had fallen trees. I'm a volunteer firefighter, first responder, and we have been working with the victims in my community. I want to thank everybody for all y'all's love and support and prayers. All of our super chats, super stickers, everything is going to go to the flood victims between 4th of July and August 4th. So I just want to thank you guys so much for joining me.
Marry her, because to get an arranged marriage, you have to be a virgin. And I wasn't a virgin, and I blamed myself. So my father was really anxious for a while after the abortion, saying that what will we do? How are we going to do this? What we're going to do with her? And there was talks about me being sent to India, where they would either marry me to an older man or kill me. One of the people that had raped me came forward. He was the person that bit me, and he came forward and said that he would take me. He wanted to have me in his house so that he could have me as a sex slave and his wife could have a servant. But his son was dating a white English girl, and in our culture that's not allowed, but it's very common. And they were going to have me marry the son so that the community thought that the son was good. It was a sham wedding. It was very rushed. I was very young, but my father and he started to make a trade for me. They placed a silk scarf over my head, and I was forced to sit down. And I have a few pictures, and I look at those pictures and think, what was going through your head? You look so scared. Because I thought, when I go to his house, will he call his friends? Will I be a victim again of a group rape? I didn't know what to expect. And my father and he argued about gold and money. And eventually they came to an agreement, and everyone was happy. And I kept hearing this word, happy, happy, happy. And I didn't know what happy was. I got to the age of 16 and I was married. And when I walked into the marital home, I first of all noticed how small it was. And they led me to a room and said, this is your room downstairs. We sleep upstairs, but you don't. And the room was like a makeshift cupboard with a small bed and an open space for clothes. They took all of my gold that I was wearing for the wedding ceremony. They took all of my belongings, and they handed me old things and said, I must get a job. I didn't really ever speak to the person I was married to. He was living his life. He was happy. I don't think people understand that cultures like mine, the in-laws, play a very big part in mental abuse and physical abuse, and often sexual abuse. It's not spoken about because there's a taboo, there's a stigma of saying anything, but the amount of mental abuse a bride or a girl.
Thank you guys so much. I had to go answer the door. Oh my gosh, Virginia Little, thank you. Oh, you're welcome anytime. Like I said, I don't have a problem with people sharing their views. If you're respectful, you got it. Be respectful and you can share your views. And I appreciate it. A human being. Thank you so very, very much. Yes, it is. The devastation is far worse than you can ever imagine. It looks like a war zone. It really does. So we're going to have Joe Smo in the house on Saturday, and we're going to go by there, and I'm going to let him see it. Oh, well, come on and catch up, babe.
Experiences from her in-laws is actually, it destroys that person. I was told that I would do all of the cooking, and there was no door so that I could be accessible to my father-in-law, who would come in and rape me and attack me and threaten me. he had a real craving for control and to scare me, which he did. There was a thing in the 90s called the bride burning, which meant there was a lot of brides being burnt in the area I lived. And what I mean by that is they were giving their husbands baby girls. So the women from the community and the mother-in-laws and the father-in-laws would blame the bride, and they would pour petrol over
Mods to mod chat, please.
for the girl and
Thank you.
set her on fire. And the police would turn up and disappear thinking it was a suicide. And they would say that they didn't know what to do. They didn't want to get mixed up in it. So I was literally dodging my father-in-law because on the weekends he would tie me up with metal coat hangers around my ankles, and the metal would actually dig into my skin, and he would strip me so I couldn't move. I would sit there and soil myself because I couldn't use the bathroom. And I was really, really scared. I was scared of everything. I was very skinny because I had an eating disorder. Every time I would plate some food at the end of preparing a meal, my mother-in-law would throw it into the dustbin. And tell me, she would tell me to eat out of the bin. Because she said, it's not your father's house. And you don't deserve to eat like one of them. And at first, I used to try and get food out of the bin because I was hungry. But then I just gave up. Sorry.
Are you ready to keep going? Cool. Thank you. You mentioned that you had a job. How did it feel having that sense of independence finally?
I actually started to discover me at work. I started to discover who I was. I got this job and I started to notice a different culture, and I quite liked to take some control of my own life in the workplace. But I also wanted to do well because I thought if I earn more money for them, they might leave me alone. And I did make some friends, who were very important in my journey, I guess. In my second job, that was selling kitchens on the phone, which I absolutely loved because it meant I was constantly on the phone talking to people. I met an Indian girl who had a Nigerian boyfriend, and we connected because we were both Indian, but she would notice things and she would say, why are your ankles bleeding? You know, why do you have bruises? And I felt I could trust her. So I started to tell her things, and she didn't judge. She didn't judge or make me feel stupid or silly. She actually would just listen. And then one day she said, you know, my parents weren't very understanding, but they are now because I'm older. Why don't you go back to your parents' house if you're so scared and so unhappy? And I started to again dream about things because I was a daydreamer. I started to almost visualize this fairy tale of walking into my parents' home and them holding me tightly and telling me that they loved me and they were proud of me, because I think that's what every person wants their parents to be like, to give them that love. So I went to work one day and I never went back. I got onto a bus to my parents' house, and I was sat on the bus and unknowingly celebrating to myself that I'm going back home. It's something I'm familiar with, you know, it's my home, and I'll be able to see my dog and I'll be able to speak to my mum, not even thinking that you never spoke to your mum. Life was never that good at home.
What happened when you did arrive home?
I wasn't scared for the first time. I was kind of excited to see my family. I hadn't seen them for 4 years. And my father opened the door. I was a little bit surprised he was at home because it was during the day. It was mid-afternoon. And immediately he pulled me in by my ponytail and dragged me in. And I thought, I've just made the biggest mistake of my life. He took me into the same room in which I was raped. My brother was there, my eldest brother. My mum was there, my sister-in-law was there, and they started to beat me. And this was a different kind of beating. It was almost as though they were determined to kill me. And all my life I'd been threatened that we will bury you under these floorboards, and I really believed they would. I remember my dog barking in the other room. They'd shut her up in the other room so she wasn't able to come near me. And I desperately wanted out, but I didn't know how to get there. My father is an ex-professional wrestler. My brother's 6 foot tall, and I was this very thin, small 21-year-old. And within no time, they'd broken my jaw. They had broken my arm, and I was in a lot of pain. I was literally bouncing off.
Brooklyn, if this is something that's too much for you, please self-care. I'm not trying to trigger anyone, but I feel that this is important for us to see some of this so we understand a little more what Fatima was possibly going through on some sense and level and what she still may go through.
Off the walls like a little rag doll, and I fell to the floor. You never forget what people.
I'm sorry, let me touch that. It was Dad was only got found guilty of imprisonment and assault of the 4th degree. The mother was found guilty of violating a court order. The mother pretty much walks. She's going to get probably a probationary sentencing, and the father could get he probably won't even serve a year. And he's already served 8 months.
And how they say it. And they were telling me I was a disappointment, that they knew that this would happen because I was a girl and they didn't want that girl. They should have killed me from birth. And what they meant by that is when I was born, a lot of girls were put into plastic bags and suffocated and buried in the garden. And I know this because people would come to my mum's house and give birth to a girl and not report the birth, so nobody knew about the pregnancy. So I was always told I was very lucky to be alive, and I was really scared of dying. My brother started to kick me, my father started to stomp on me, and they displaced my hip, and there was probably no part of my skin that wasn't cut or covered with bruises or blood. It came to a time where my father held his foot on my throat, and I felt at that moment I left my body. And I remember looking at myself and thinking, this is it. This is it now for you. But I heard something. It sounds strange, but it's what I believe, and I know what happened. And something said to me, not yet. It's not your time just yet. And I remember going back into the body and feeling nothing. I was numb. I knew they were still kicking and punching and stamping on me, but I wasn't feeling anything. All I was doing was watching blood literally drip from my head onto my nose and into the carpet. And they continued. I remember feverishly looking up towards my mum and my sister-in-law, maybe in a way to ask for help. And I remember them standing with their arms crossed, and they were very, very angry. And before I knew it, my other brother walked in, shouted, "Not here." And they all just disappeared very quickly. And I remember passing out and coming to and passing out. And the door opened and somebody said, "They're going to take you to India, ask for help, it's security." And I thought, what a silly thing to say to me, because if I have my brother on one side and my father on the other, I'm not going to ask for help. And I thought to myself, I'm already dead. I don't want to live anymore. But then this little voice was saying, no, I don't want to die. And I tried to get myself up, but I couldn't. I tried to, almost like a baby, crawl, and I couldn't. So I started to talk to myself, and I said, if you can get to the door and you can reach the handle, you've only got to get to the kitchen. If you can get to the kitchen, you've only got to get to the back garden. If you can get to the back garden, you will be free. I didn't even know what free meant or where I would go, but I knew I had to get out of there. And it sounds very fictional, I know. And I know I look literally like something out of a horror movie, but I started to move and my body was stiff because I'd laid in the same position for days, and I was dirty and smelly. And like I said, I was covered in blood everywhere. But I started using this part of my arm, and I shuffled forward, and I would fall. I would internally cry because I was too scared to make a noise. I knew I had a very small window of opportunity before this angry household would know that I'm trying to escape. But I did, and I got to the door, and then I got to the kitchen. And when I got to the garden, my father had this 6-foot-high wall, and I thought, I'm not going to be able to do this. And I sat there literally and thought, oh, I can't do it. and my dog came. And she was the loudest person. She would bark. She would make so much noise. The neighbours would complain. And I remember touching her wet nose and almost begging her not to say anything. And I really believe sometimes in life we really come to a crossroads where we just need one person to say, you've got this, in whatever form they come. And I believe in angels. And I felt she was this messenger or an angel saying to me, go. Because she looked up and she looked back at me. And somehow I managed to get on top of this fence, and then I fell on the other side in quite a loud way, thinking they might hear me. But I crawled, literally crawled over to a little park opposite my house, and I passed out in the bushes, and they never found me. And when I woke up, it was early hours of the morning. I have no idea what time it was, but the birds were singing, and I managed somehow to get to a taxi rank, which wasn't too far away. And when I got there, I had no money. I could barely stand. And the person that came to me was this white British man, and he was so kind, and he said, who's after you? What's happened? And I said, my parents are trying to kill me. And he got me into the back of his taxi, covered me with a blanket and said, am I taken to the hospital, to the police? And I said, no. Can you take me to my friends, please? And he did. He took me to a place called Market Harborough, which is in Leicestershire, where my friends lived. But nobody answered the door. But he didn't leave me. He stayed with me and eventually took me to the police station. And I remember collapsing in the police station. And I remember the policeman saying what happened, started to take photos. And I told him it was an attempted honour killing. He almost looked disappointed and uncomfortable and like he didn't know what to do. And he said, the best thing for you to do is to get to a hospital. And before I know it, I was on my own in a hospital, lying on this bed. Nobody visited me. Nobody asked me who I was. The nurses would come and do their observations and disappear without looking at me as though I was there. I watched the people in each bed and their families. And I knew who was coming at what time. But I also knew that nobody was coming for me.
Have you had any communication with your family since you left?
My brother came looking for me 15 years after I had moved out because he had attacked his...
This is an interview with someone who, similar to Fatima, but a lot worse.
...partner at the time with a hammer. And the police had put him into some sort of program whereby he didn't have to do jail time if he put right what he had ever done in his life. And he said to them openly that he had attacked me in an honour killing attempt. And I was scared because I was still scared of my brother, and he asked for forgiveness. And I said, I forgave you all a long time ago, but I just cannot forget. People don't understand why I've forgiven them, but I forgave them the moment they did something wrong because that's the kind of person I was. I don't speak to my parents now. I have been continuously threatened and haunted by them, whereby they have said they will behead me. So I get 30 to 40 death threats every month, not just from them, but from people I don't even know, especially the Middle East. And the way they look at it is if you leave an arranged marriage, they have to kill you to retain that honour. And I understand the importance of speaking out regardless of stigma and shame, because they will continue to do these things over and over again. So whoever it is you're protecting, the first and only person you should be protecting is yourself. I don't speak out of hate for my culture or to bring disrespect to Indians or Sikhs or Punjabis, whoever you may be. It's not for that reason. It's to say that as humans, we should value life. Whether it's born, that child is born a girl or a boy, they are a precious life. And he became very violent, pushing me a lot, pushing me down the stairs, pushing me in the wall, grabbing my hair and pushing it into the passenger side if he was driving. And I didn't know I was in a violent situation until things were very serious. And when I was pregnant with my third child, and I was 7.5, 8 months pregnant, and he pushed me down the stairs. I fell. And he left. And I remember not feeling my baby move.
He looked young. He did look young, but
Okay, so we're going to go ahead and stop there with this. I just wanted to play that because I wanted everybody to understand a little bit, have some more context. I think we understood. It breaks my heart that Fatima's life will most likely, at least for the next 15, 20 years or so, I don't know how long, really be in jeopardy. I don't think she will ever be safe as long as the elder men and her family are alive, because the family of the man that she was to be married to, he was going to be, I think he was 61 or going to be 61 at the time. They want their bride. And I'm surprised that the elder daughter was not sent in her place. It's highly unusual for the elder daughter to still be, or for them to take the younger daughter. I don't know. Maybe not, but I would have thought that the elder daughter would have already been married off by now. But I think if Fatima is in Canada, I pray they protect her. No matter what the verdict was in this case, I feel that it was definitely shown that there is reason for her to fear. If I was in the government of Canada, I do care about the outcome, but as far as how I would handle her, I would protect her no matter what the outcome of the trial was. It is so frustrating that these things are going to keep happening. That is so true. She had a job and she was also for two younger boys. See, yeah, not only, well, she was a babysitter and a house care provider for her family, but then when she was engaged to this older man, he paid dearly, I'm sure, for her, because they pay for these girls. This is not a free thing. The daddy would bargain the price as high up as he could for that daughter. And now he's responsible. If he was already paid, he's got to make it right there. But even if he wasn't paid, that's a cultural thing. Once you're engaged, that's it. Unless the man releases her, the father's responsible and required to get her to the altar, so to speak. So it's horrible. Wait, I missed that. The older daughter I'm speaking of, also the job is caring for the two younger boys. Yeah. Tinkatu, she's not safe in Canada. Her family has family that lives there. Oh my gosh. That's where the mom took the brothers. Oh, that's right, Virginia Little. Virginia, why do I think like I feel like I know you? I forgot about that. I don't think she'll be safe anywhere in the world as long as anybody knows where she is, truth be told. If I was her, I'd get an asylum. I would get a legal name change. Heck, I might even change my hair color, maybe even change my facial feature. I may get plastic surgery. She's not in Canada, huh? I don't know where she is, honestly, and if I did know for sure, I would never say. It said that she was in Canada, but I don't know. You're right. She's not safe anywhere. She's not safe anywhere, period. And the moment the father gets out, and the moment he could leave this country, if he's smart, that's what he'll do. But then again, I got to thinking, is his life in danger? Does he have to be concerned for his safety? Did this trial put him in danger? Is any risk to him? I'm just curious. Can you guys take a minute, click the thumbs up, and give me a good like for this live? I would greatly appreciate it. When you do, make the comment ILIKED, because in a minute I'm going to do a drawing. And if you give me the ILIKED like this, like the stream, only 21 people out of 104 likes have done that. put the comment I liked. If you've liked the stream, and at the end of the month, I do a giveaway for merch. There's a saying I always say in my humble opinion. So here's my muck. IMHO in my humble opinion. We do have a merch shop, so you'll get free merch at the end of the month, the winner. And if you're overseas, you will get a free Amazon gift card, digital, of course, by email. She's in grave danger, and so the others, yeah. Yep. You missed it, babe. The father was not guilty of the attempted murder and also count 2. He was found guilty of imprisonment. He may get 12 to 14 months. And also he was found guilty of assault in 4th degree, which is 12 months. The mother was not guilty on all counts except for violating a court order. She will get time served. They have let her out on supervision. So the mother is out on supervision. Yep. Yep. Okay, in my humble opinion, I do not believe it has ever been said that she was in Canada. It has been said that her family was in Canada or that she had family in Canada, and it's been speculated that she was in Canada, but we do not know for sure. We were just talking examples pretty much. Yay! And it got you. Thank you so much, Janet Chandler. Thank you guys. Yes, and don't get me wrong, there are a lot of really cool, nice Muslims out there. I've known a few. They're not all this way, and I don't judge a culture by what 1 or 2 do. But as a majority of the cultures, well, I guess it depends on what kind of Muslim you are, where you grow up, what you're taught. That's a possibility. This family, the mom and dad to me are monsters, not all of them. He has served 10 months. He can get 2 years, but 85% sentence only has to be served, maybe 4 to 6 months in prison for him. That's right. I think she can add it again just to be safe. Thank you so much, Jake, playing. Come back again. Thank you for your kind words and your comments and support. Yep. This is true. Yes. Hey, Virginia Little, are you on our Discord? Everybody get on our Discord. Come on now. We do some fun things. We started watching movies. We have some fun sites for you. We got recipes. We got all kind of fun little things for our members. We've got pet picks recipes. We got hobbies. We got the gifts, whatever, bingo cards. We play bingo with some, not all of our trials, depending on the type of trial. My father strangled me and my little brother, or almost killed my little brother, and I had my home broken into one night to be choked in my bed and the pressure pain. Oh, I am so sorry. I am so sorry. Virginia Little, get a hold of me if you don't mind in Discord. Anybody can get a hold of me in Discord. I'll talk to you. These are traditional. Okay, it is not the Muslim. It's the ideology of Islam that we're being. Okay, thank you for the clarification, Jake. Perfect way to explain it. Thank you. Hug your kids and adult kids. You give them hugs today. Fatima, who said she didn't get hugged or comfortable. We would have her. Oh, I know. I would give her the biggest hug. I wouldn't let go. Oh, I'm sorry. Verdict was in. Dad was found guilty on imprisonment and assault in 4th degree. That was it. Slap on the wrist. The mother was only found guilty of violation of court order. That's all. That be all. Yep, that's it. Okay, guys, what I'm going to do, it is almost 7 p.m. my time, and Mr. Joe Schmo said he's going to be in Kerrville tomorrow afternoon, and then we're going to do a live on Saturday. So I need to get this studio kind of arranged a little bit to make room for him. It's a very small room, and we got 2 adults, so I need to get to where we can both fit. Oh, no, they lifted the gag order between mom and dad, but she still cannot contact anybody else. That is still in play. So let me get ready for our wonderful drawings. Here we go. We got a lot of them to do. We got about 1, When Maud gets it, I automatically redraw. They still get the credit, but I automatically redraw. Nightbot! No Nightbot. That is true. That is true, Virginia Little. We do not judge the culture, but we do not have to be okay with it. Yes. All right, there we go. Evangeline. Woo-hoo. Okay, we'll go to the. Here's another I shared. Let's go. Again, June. Boy, you are the luckiest person I draw again. Tinkatude! Oh, that's right, Tinkatude. You're now a mod. Everybody, welcome Tinkatude to the mod family. She has joined the mod team, so she gets to keep it, but we'll draw a second one. No, Nightbot. That's okay. It'll go for tomorrow. Okay, let's go over to this one. We had 3 live today. 2 live, 3 live, so I'm doing all of them at once. What is it with, well, hey, you play a lot. Do it again. Oh, thank you. Case 1. Here's another one. Okay, for tomorrow, I will not be live unless something goes on, and we may have some interviews or something. I may do that. But in general, I'm not planning on going live. I have an entire studio to get ready for a special guest in the house. We're not talking just, he's in Florida. All right, Amy, congratulations. One more. But I need to get this arranged where we have the camera can get both of us, the mic can get both of us. We gotta do some arranging here. And then we have Mr. Joe Schmo in the house on Saturday. But I got to get this place ready for him. Because right now it's a small spot and I need to. June, what is it with you and all of these wins? I'll draw again. Don't worry. I will draw again. That is unnecessary. Thank you very much. Have a nice time at the block party. Thank you very much. Okay, let's go on to the next one. Woohoo! Let's go. This is the last one, guys. Like I said, I love everybody. I love people giving us. I love people giving us. What is it called? I love looking at both sides of the coins. I think it's important for us to have good debates. I love debating. Sorry. And that was the. I got to do it again because Tinkitude. You got to do it again. I love debating. I love talking things through. I love hearing everybody's point of view. I love all of that. But there's no need to be rude or disrespectful in any way, shape, or form. All right, guys, those are all of our winners. I have screenshotted all of you. I will get you all added. And early next week, we will have the drawing. It takes me a while because I have a ton of names to put in that wheel, and I can only put so many. So I may have to put 2 wheels up, draw those winners, and then put those 2 in a wheel and figure out who won. Yeah, Nightbot hasn't been behaving well lately. So, oh my God, June, you're so welcome. Congratulations, Jen, She-Wolf, Weird Debbie, Evangeline Light, Tinkitude, She-Wolf, K-Swan, Amy Drag, Sweet Magnolia, and Tinkitude. Congratulations to all the winners in the house. I want to thank everybody for joining us today. It has been a journey. I have to tell you, I'm a wee bit worn out. I'm just, this trial has exhausted me emotionally, mentally, physically. It has been tiring. Hello, it's Brit. Oh, you're going to say bye. But tomorrow, let me see what the calendar looks like for tomorrow before I make any kind of comment. We were supposed to have a court date today. 2 things I didn't see them live today. 2 of them was, I did not see Corey Richens today. I don't know if that was there or not. Oh, that's tomorrow. No wonder I didn't see it. Duh. Okay, so tomorrow is the Texas Brad Simpson, Fraser Baum, and Corey Richens. So I will be live tomorrow, but I don't know what time. So, okay. Oh, I think Joe Schmo is going to be here tomorrow. We'll figure it out. That's true. We really thank all of you for watching with us today. It really means a lot, and all the helps in the channel. I need to give out some shout outs before we leave. Evangeline became a member today. June, thank you so much for your $5 super chat. Jury question. Okay. Sorry. Okay. Frank Leroy, thank you so much for your super sticker. Thank you for the gifted membership, Luca. Oh, Virginia Little, thank you so very much. I appreciate you for your gift. All of the gifts will be going to the fund for the disabled and flood victims. Human Being, thank you so much for your gift. Thank you, June, of course, again for your gift. I thank you, thank you, thank you. Y'all are amazing. You're getting addicted, huh? So we will have a live on Saturday, and we will have a Sunday's members only live for all you green people. Yeah. I need 3, Denise. I need 3 wheelchairs. That's what I need, like ASAP. All right, guys. I got to go to the bank first thing in the morning. I got to get a hold of them now before they close. So y'all have a wonderful night. We'll see you later. Thanks for watching. Please comment, like, share, and most importantly, subscribe. I hope you have an awesome day. Till next time, take care.